All right, buenos dias, good morning, everyone. I'm New York State Senator Jessica Ramos. I represent the 13th District in Queens, the neighborhoods of Jackson Heights, Corona, East Elmhurst, and a little sliver of Rego Park that I have now. And this morning I am joined by State Senator Brad Hoylman Siegel, who will also address you. I chair the Labor Committee, he chairs the Judiciary Committee. We care very deeply about working people and justice, ensuring that everyone is taking home their entire paycheck and making sure that they have the tools to feel empowered to pursue claims and actually expect their money back, which is the goal. So I'm very happy to be here this morning. Wage theft really is the biggest crime that no one talks about in New York State. In this year's budget, we were able to lead the charge to secure the first raise in the minimum wage since 2019. That's right, no one clap, it wasn't that high. It should have been higher. That effort to put more money in New Yorkers' pockets is incomplete without also providing them with the tools they need to ensure they take home every penny they have earned. According to testimony submitted by the Department of Labor Commissioner Reardon in 2022 alone, the DOL's Worker Protection and Labor Standards teams oversaw wage theft investigations that recovered $25 million in wages for nearly 18,000 workers. These are just the funds that have been recovered. The DOL, like many other state and city agencies, have been systematically underfunded. We need another tool to make sure that workers are bringing their entire paycheck home and, quite frankly, end austerity altogether. SWET allows, and by SWET I mean my bill to secure wages earned against theft, allows workers to secure a judgment against their employers in a wage theft case. It protects immigrant workers who are both frequent targets of wage theft and afraid of retaliation by allowing them to file anonymously. I want to be clear from the outset, to apply for a lien, the worker and their representatives will need to show cause and be prepared for litigation. Our former governor's veto, he who shall not be named, on the basis of a lack of due process, either willfully misread the legislation or willfully took the side of bad actors. I want to thank the workers who are taking time out of their lives to put their stories and their advocacy on record. I also want to thank the representatives of employers who are here today to engage in good faith rather than hiding so they can lobby against working families in the dark. When an employer steals from workers, they are harming the family that relies on those wages, as well as taxpayers and honest small business owners who are subsidizing these predatory business practices. This is the year we pass SWET, baby. And with that, I am going to throw it to my esteemed colleague and Senate floor neighbor, State Senator Brad Hoylman Siegel.
Thank you. Thank you, Senator Ramos. Make sure this is on for the benefit of... It is on. Thank you very much. State Senator Brad Hoylman Siegel, represent the 47th District, which runs from Christopher Street on the west side all the way to 103rd. Proud co-sponsor of the Securing Wages Earned Against Theft Act, S. 1977, known as SWET, with 20 senators who are co-sponsors. And I am chair of the Senate Judiciary Committee. The reason I am here, in addition to being a supporter and co-sponsor, is that the bill is currently in the Senate Judiciary Committee as it changes the lien law in New York State. We have passed it through the Judiciary Committee previously in 2019. As was mentioned, unfortunately, the governor at the time vetoed it. Since then, the problem of wage theft really has only become more acute, as those most affected immigrants and blue-collar workers were also disproportionately harmed by the COVID-19 pandemic. During the pandemic, we relied on these workers to keep coming into work, while those who were privileged work from home and ordered their meals from home. These workers are essential workers that we all claim to admire and appreciate, but through time, we did not do our part to protect them through legislation that would guard against the pernicious crime of wage theft. These hardworking New Yorkers deserve their wages in full and on time, not to be exploited by employers. That's the least we can ask for. Each year, an estimated 2 million New Yorkers are victims of wage theft. It's high time we ended it. Senator Ramos' SWEAT Act will put power back into workers' hands. As chair of the Senate Judiciary Committee, I'm proud to co-host this joint committee hearing on this important bill, and I look forward to hearing from our witnesses about how we can best address wage theft in New York State. Thank you, Senator.
Thank you, Senator. So these are the rules of the game. Each speaker is going to be given 10 minutes to testify. And, well, if at some point we're joined by some other colleagues, including us, we'll be permitted 10 minutes for questions following up to the panel. I'm going to call you up by panel, and please try to remember the order in which you're called. You might want to even sit in that order, maybe start over here on my left, your right, so that you can testify in order. Okay? And then I think if we have other committee members, they'll have 5 minutes. So Brad and I will have 10 minutes to question. Other senators, as they come, will have 5. So let's get started. Panel A. From the New York State Attorney General's Office, we have Labor Bureau Chief Karen Cassese. From DA Alvin Bragg's office, his Worker Protection Unit, we have Roshana Pathak. I hope I pronounced that correctly. And Rachana Pathak. Thank you. Elizabeth Kennedy from the Office of the New York City Public Advocate. She's the Deputy Public Advocate of Education and Opportunity. And from National Mobilization Against Sweatshops, restaurant worker Virginio Caballero de Jesus. Good to see you. You can begin when you'd like.
Good morning. My name is Karen Cassese, and I am the Labor Bureau Chief at the New York State Office of the Attorney General, where I've been for more than 3 years. Prior to that, I was the Director of the Employment Law Unit at the Legal Aid Society here in the city for over 9 years. I want to thank you both for convening this important hearing and for giving our office an opportunity to share our recent experiences, feedback, and insight. Today's hearing offers many of us working on labor issues in New York State a chance to discuss the scale of wage theft in the state and recommend solutions. At the outset, I want to note that the Attorney General James and the rest of our office continue to appreciate the strong and constructive relationship with the legislature. And as with any other issues that arise, we are happy to offer our time and expertise to help you achieve the legislative objectives. The Labor Bureau enforces federal, state, and local laws affecting workers in New York State, and our office prioritizes enforcement of labor law violations against low-wage workers, including wage theft, discrimination, safety, and family and medical leave. Our office recently resolved several investigations involving home health aides, laundry workers, nurses, restaurant workers, and residential building staff. As you noted, wage theft has been and remains an enormous issue in New York State. In a comprehensive 2017 report published by the Economic Policy Institute, minimum wage workers in New York State had nearly $1 billion in wages illegally withheld from them annually. And this number only considers minimum wage workers. It clearly would have been higher if workers earning more than the minimum wage were considered. Women, people of color, immigrant workers, and young people are more likely than other workers to experience instances of wage theft, as they are more likely to be in low-wage jobs. However, wage theft is endemic across all demographics, especially in low-wage industries. When a low-wage worker is not paid the wages they are entitled to, they are 3 times as likely to be in poverty than minimum wage workers overall. One of the main priorities for our office is to investigate allegations of wage theft and to recover lawfully due wages for workers. Our office receives hundreds of complaints regarding the improper payment of wages each year. Since the beginning of 2021 to now, we have received over 2,160 such complaints, and the trend shows that these complaints are growing in number. During the same period from 2021 to now, our office has recovered over $10 million in wages due to workers, which we are distributing back to the affected workers. Wage theft takes many forms. Some of the most common are failure to pay the minimum wage, failure to pay 1.5 times the regular rate of pay for hours worked over 40 hours per week, failure to pay workers for off-the-clock hours when workers are required to work before or after their stated shift, failure to pay spread of hours and split shift pay, failure to pay proper wages for tipped workers, and theft of tips. Employers taking illegal deductions from workers' pay, and misclassification violation where workers are wrongfully identified as independent contractors to pay them below the legal wage. Further, even if an employer is found liable for owing workers' wages, unscrupulous employers can transfer and hide their assets, frustrating collection efforts and leaving workers still without their pay despite a court-ordered judgment. We have the following suggestions to combat wage theft and to help workers obtain their lawfully earned wages. Then the very first one is the sweat bill. And I know that so many people in this room have been working on this for such a long time. It would be really a wonderful accomplishment to have it enacted this year. The sweat is necessary because enforcement of wage theft is essential to ensuring that unscrupulous businesses do not have an unfair advantage over their law-abiding competitors. The legislation will expand New York's existing mechanics lien law to include all workers, allowing workers to put a temporary lien on the property of an employer who fails to pay wages. It will amend New York's existing attachment provisions to make it easier for workers to attach an employer's assets at the start of litigation before the property can be sold or transferred, and it will improve the procedures for holding the largest shareholders of privately held corporations and limited liability companies personally liable for wage theft. This bill will increase the likelihood that victims of wage theft will be able to secure payment of unpaid wages for work already performed and will deter employers from failing to pay the required wages. In addition to the sweat bill, we have several other proposals that I will go through briefly. Some of them you are already sponsoring, some of them we have suggested. So the next one is adding wage theft to the types of activities included in the crime of larceny. With a single exception, all crimes set forth in labor law are misdemeanors, and prosecuting wage theft as a felony would be a greater deterrent to egregiously bad actors committing wage theft. This would be accomplished by amending the penal law larceny statute to include wages in the definition section. Next, we advocate for eliminating the tip credit. While New York recently eliminated the two-tiered tip credit wage system in miscellaneous industries, the tip credit is still allowed in the hospitality industry. The elimination of the tip credit in all industries would allow for a more equitable and manageable wage system and eliminate a system that leads to abuse and exploitation of workers. Next, we suggest elimination of the unit rate for residential janitors or building superintendents. Under the Building Services Wage Order, a residential janitor, often known as your super, can be paid a weekly unit rate rather than the hourly minimum wage rate. The unit rate is the number of units in a building multiplied by either $10 or $9.45, depending on the location in the state. The weekly pay of a super is capped no matter how many hours they work, and no overtime pay is required. These are the only category of workers who do not need to be paid on an hourly basis, and elimination of the unit rate would bring these workers in line with all other industries. Next, we suggest strengthening the law against misclassification of employees as independent contractors. Some employers in some industries regularly misclassify their employees as independent contractors so that they do not have to meet all the requirements under the labor law, including those related to wages. The labor law should be amended to require classification as an employee, not an independent contractor, unless the hiring entity can demonstrate the worker is free from control and direction, the worker performs work outside the usual course of the hiring entity's business, and the worker is customarily engaged in an independently established business of the same nature as the work performed by the hiring entity. The adoption of this ABC test would bring New York in line with many other states already using this standard and would greatly support our efforts to combat misclassification of workers as independent contractors. And the last suggestion we have is to strengthen the law prohibiting kickbacks from employees to keep their employment. In 2022, the New York Court of Appeals ruled that Labor Law Section 198-B, which prohibits anyone from requiring a kickback from a worker to maintain employment, did not contain a private right of action. That decision reversed years of understanding that workers did have the right to enforce the law themselves in court. The law should be amended to clarify that workers do have the right to recover illegal kickbacks, as doing so would bring this provision in line with other forms of anti-wage theft laws. We very much appreciate the opportunity to share our input with you here today and welcome the chance to continue the conversation moving forward. Thank you.
Thank you. Thank you, Senators Hoylman, Siegel, and Ramos, and the members of the Judiciary and Labor Committees for the opportunity to submit this testimony about the serious problem of wage theft and about the Manhattan DA's efforts to investigate, prosecute, and help prevent wage theft. My name is Rachana Pathak. I am the Chief of the Worker Protection Unit for the Manhattan DA's office. It is a privilege to be here to discuss the fight to end wage theft. The Manhattan DA's office has long been a leader in investigating and prosecuting wage theft, primarily in the construction and real estate development industries. More recently, we have expanded our practice to other industries in which wage theft is common, including the retail and restaurant industries. Our Worker Protection Unit also enforces workplace safety labor laws and pursues charges including reckless endangerment to manslaughter when an employer creates dangerous or deadly work environments. In the last 5 years, our unit has recouped over $6 million for workers in stolen wages. Today, I'd like to discuss the trends we are seeing in the wage theft area and make some recommendations on how to strengthen our laws to prevent and combat wage theft. Our perspective is based on years of experience working in the trenches in this area, answering and vetting hotline calls, investigating cases, bringing wage theft indictments, and prosecuting these cases criminally. I'd like to first note that it's difficult, if not impossible, to ascertain the precise scale and scope of wage theft because, as in other victim cases, many workers do not report it. This is due to several factors, including a lack of resources or knowledge, time constraints, a mistrust of governmental agencies, and unequal power dynamics. For example, often when a worker is owed $1,000, he or she will accept $500 from an unscrupulous employer to keep the job and to keep some money coming in, and this unequal power dynamic enables exploitative companies to continue the exploitation. Cornell University's ILR school estimates that workers lose up to $1 billion every year to wage theft. This represents 10,000 workers, many making minimum wage, less than or not much more, and these workers are the most vulnerable New Yorkers. Many of them are not native English speakers, many do not have legal immigration status, many are new to the United States and New York City and are unfamiliar with our systems and our protections in place. Our unit works with community groups to encourage workers to report wage theft and to participate in the criminal process. We have made successful prosecutions and recouped money through these critical collaborations. As one example, we received allegations from NICE that construction workers who had done electric work at 1227 Broadway, the site of a Virgin Hotel in Midtown Manhattan, were not paid for 6 weeks of work. We were able to recoup $112,000 upfront for 18 workers, and this also led us to create the nation's first stolen wage fund to help workers recoup wages after a criminal case is completed. We recently indicted a contractor for stealing wages from day laborers, and we have several ongoing wage theft investigations that we will be announcing shortly. From our extensive experience, we have developed an expertise in the area of wage theft, and we make the following recommendations that we encourage this legislature to adopt. First, expand the category of eligible crime victims under the New York State Victim Compensation Fund. Executive Law 621 sub 5 defines crime victims narrowly. It does not include victims of wage theft. Opening that category to wage theft victims would encourage more people to report wage theft and bring justice to more victims. Second, amend the definition of property under the larceny statute, as has already been said, to include compensation for work or services. This would be a significant change, allowing us to aggregate larceny amounts with multiple victims. The Senate has passed Senator Breslin's legislation that would make this change earlier this session, and it's currently pending, and our office supports this bill. Third, we suggest adding gradations to the scheme to defraud statute. Someone who steals more money from more victims should be penalized more heavily. When a defendant steals wages from 5 people versus 50, or steals $1,000 versus $50,000, right now we can only charge that defendant with a Class E felony, and we would recommend gradation. There are many reasons to pursue wage theft cases criminally. Chief among them is that for many companies, wage theft is part of a company's business model. Too often, when a company is caught stealing wages from its workers, it simply pays back what it owes and continues its exploitative conduct. It is a cost of doing business. Our Worker Protection Unit has developed creative ways to penalize and deter such behavior. In a recent case involving prevailing wages, a company and its principals were indicted for stealing more than $1 million in wages and bribing an investigator to cover up a double-breasting scheme where the company was using non-union, unqualified labor and paying its workers less than what New York City paid for qualified union workers. In the end, the defendants paid back $900,000, which our unit distributed to the workers. All defendants pled guilty to felonies. The company was debarred from city contracts. And debarment from lucrative city contracts is a powerful new tool and has great deterrent effect. It should also be noted that our wage theft cases at the Manhattan DA's office often go hand in hand with other white-collar crimes. Our unit not only investigates a company for wage theft, but we also investigate the company as a whole. Time and time again, if a company is shorting its workers, it is also likely cutting corners and committing other crimes such as insurance fraud, falsifying business records, filing false documents with governmental agencies, committing other labor law violations, bribing government officials, committing bid rigging, and money laundering. One of the most common crimes that we see when we investigate wage theft is insurance fraud. So companies will intentionally underreport or misclassify their workforce to lower the premiums for workers' compensation insurance. As a result, when a worker is injured on the job site, the company will send the worker to an urgent care facility and will instruct the worker to lie about how the injury occurred. This is to prevent scrutiny into how and how much the workers are paid, how much workers' compensation insurance the company holds, or the safety of the work site. For example, after a 39-year-old carpenter fell 29 floors to his death at 161 Maiden Lane, which was the site of a 60-story luxury building, we brought manslaughter, insurance fraud, and wage theft charges. Not only did the company plead to manslaughter, but they paid back $517,000 in stolen wages to 51 employees. The district attorney is dedicated to expanding our worker protection unit to build even more impactful cases, to increase outreach, and to develop other creative ways to combat wage theft. In March of 2023, the DA, Alvin Bragg, requested additional funding specifically for our unit from the New York City Council during this year's city budget. We welcome the state legislature's support for this funding. Thank you again for the opportunity to give testimony and for your dedication and attention to the victims of wage theft. We are proud of the work we do every day to combat wage theft crimes zealously, and I know the legislature shares our concerns about this issue, and we look forward to continuing to work with all of our partners to hold accountable those who commit crimes against workers. Thank you.
Good morning. Good morning. My name is Elizabeth Kennedy, she, her, aya pronouns. I'm the Deputy Public Advocate for Education and Opportunity at the Office of the Public Advocate of our New York City Public Advocate, Jumaane D. Williams. Today I'm here to read testimony from our Public Advocate, Jumaane D. Williams. Good morning. I would like to thank Chairs Ramos, Chair Hoylman-Siegel, and the members of the Committee on Labor and Committee on the Judiciary for holding this hearing. I'm here to advocate for the passage of Senate Bill S1977 and its Assembly Companion Bill A46 to protect all workers from the longstanding issue of wage theft. wage theft has been a persistent issue impacting workers across a range of industries. When we think of wage theft, we may have a particular idea, yet wage theft exists in many forms. This includes overtime violations, paying below minimum wage, misclassification of employees, and illegal deductions from paychecks, among others. With the misclassification of employees, our office published a white paper last year noting the prevalence of wage theft among independent contractors, as the State Department of Labor does not have streamlined methods nor the capacity to identify and remediate wage theft for gig workers. As a result, employers may be inclined to classify workers as contractors rather than employees, as our colleagues have shared. Wage theft deeply impacts workers from immigrant and low-income backgrounds. In particular, industries that predominantly hire low-wage or immigrant workers, such as construction, restaurants, salons, and domestic work, are more likely to be affected by wage theft. In regards to immigrant workers, they may be reluctant to seek recourse as their immigration status may be used against them by employers in retaliation. Low-wage workers may also lack access to adequate resources and finances to fight for the compensation they are owed. With the backdrop of the COVID-19 pandemic these past 3 years, low-wage and immigrant workers, many of whom were essential workers, have had to face health challenges and loss of work opportunities in addition to ongoing wage theft and exploitation. Nationally, compensation owed to workers due to wage theft is estimated to be in the multi-billion-dollar figures according to the Economic Policy Institute. In New York State, recent analysis by 7 workers' organizations calculated over $130 million owed to workers from wage theft during the pandemic. This figure greatly contrasts the $3 million the state recovered for workers in 2022. With so much potential compensation yet to be recovered, it is clear that there is ample opportunity for stakeholders to seek redress for wage theft once and for all. S1977/A46 aim to meet the needs of our workers. They should amend existing laws to increase the likelihood that wage theft victims will be able to secure payment of unpaid wages from their employers for work already performed. Notably, the bills would allow workers to place a lien on their employer's assets if they have not been paid their earned wages, even if the business closes or files for bankruptcy. It would mitigate employers from evading liability and pay out what their employees are owed. We have the potential to finally hold exploitative employers accountable and recover millions of missing dollars owed to workers. Lastly, I would like to acknowledge the hard work and advocacy of labor advocates, many of whom were or continue to be subject to worker exploitation, including wage theft, and have taken their personal experiences to ignite a movement that I hope will result in the passage of S1977/A46. Thank you for sharing your stories and your continued advocacy. Thank you again.
Sí, buenos días.
Buenos días.
Buenos días. Yo soy un trabajador de Indios Valley. Yo trabajaba muchos años con ellos y después el dueño les pidió a nosotros y él pagaba 20 pesos por... Entramos a las 5 de la tarde hasta las 11 de la noche, pagaba 20 pesos por día. Trabajamos los seis días y después allí el dueño les pidió a nosotros y vinimos apartamento labor y agarraron ellos caso a nosotros. Llevamos muy tiempo y nosotros vinimos cada 5 o 6 meses, preguntamos cómo va el caso va bien, dice, ya como los 6 años ya vinimos después, dice que el caso ya no estás allí. Y le preguntamos al cargado de allí, unos cargados que trabaja allí, y dice que el caso ya no está acá. Y dijeron ellos que nosotros no está el caso. Le digo, ¿dónde fue el caso? Pues nosotros venimos acá. Y después no sabemos, todos nosotros no podemos decir. Ellos nunca dieron la respuesta dónde está el caso y nosotros fuimos sobre la lucha, nosotros vinimos a hablar, buscamos ayuda, cómo vamos a resolver el problema nosotros allí. Y fuimos a protestar al frente del departamento de labor. Mucho, como 4 o 5 veces fuimos y nosotros ellos, el dueño, el jefe del departamento de labor, fue donde nosotros pedimos ayuda ayer, pedí disculpas a nosotros, que él no sabe de qué problema tiene allí, que no se fue el caso. Pero dice, no se preocupe, dice, yo voy a hablar con el dueño del restaurante donde trabajaron ustedes y lo voy a cerrar todo, si no paga a ustedes, le debe mucho dinero y lo voy a cerrar todos los restaurantes, dice el jefe del departamento de labor. Ajá. Pero ahí con tiempo fuimos a protestar todo el tiempo ahí al frente del departamento de labor hasta que habló con los dueños, pagar nosotros. Y pagó poco, pero no le pagó todo porque la ley no está muy fuerte, la ley está débil. Y nosotros seguimos luchando hasta ahorita, ganamos pues nosotros no estamos robando tampoco y estamos trabajando para ayudar a la familia y todo eso. Y nosotros siempre estamos luchando hasta ahorita, sí. Y nosotros queremos ley que cambie, que pase eso para que le ayude a nosotros. Nosotros somos los trabajadores que andamos afuera dejando la comida, lluvia, nieve, todo eso andamos nosotros sufriendo allí. Hasta uno pierde la vida, nosotros los trabajadores del Libre Boy. Sigo yo trabajando en restaurante ahorita todavía, pero por la familia, sí. Sí.
Sí, voy a traducir yo. Ya terminaste.
Sí.
Okay. My name is Virginio Caballero de Jesus. For nearly 20 years, I have worked as restaurant delivery worker for 7 different restaurants and delis. I work for the restaurant Indus Valley 6 years, making $20 a day, 120 a week, 6 days a week, 36 hours per week. I organized with 7 co-workers to recover our stolen wages. When we went to the Department of Labor, but after 6 years of delay in us asking about our case, the Department of Labor told us our case was closed. So they washed their hands of our case. We were angry. We decided to protest the Department of Labor. We organized a picket in the front of Department of Labor to demand action on our case. After a few weeks, the Department of Labor told us they have a settlement of about $300,000. That was only a small part of what we were on. But we refused to stop fighting. We refused to stop fighting. We started a picket in the front of Indus Valley. After about 6 months, the boss changed the name to Manhattan Valley and claimed it was a different business. And wasn't responsible for our stolen wages. It was a lie. The boss, Lagbir Singh, was still cooking inside. The menu, the decor, even the name of the delivery bags were the same. When we continued fighting, the boss said he was bankrupt and had no money to pay us, that he had sold the business. We continued picket. We won a court judgment of $700,000 against him. Despite winning in court, the boss claimed he had no money in bankruptcy. Judge say it was clear the boss was trying judgment and ordered the money from the sale of the restaurant be given to us, about $110,000, but to this day we are still on $500,000 and $900,000. It swear were a law when we began fighting for our rights. We could have put a lien on the restaurant and the boss, other property to ensure we could collect all of what we were on. The Indus Valley boss would not have been to use declaring bankruptcy as a way to avoid paying his workers. Our case would not have been dragged out for years because the boss would have wanted to get rid of the lien and would have tried to resolve the case instead of just waiting us out. I am very angry with Hospitality Alliance protects the bosses who steal so much from workers. Show us you are on the side of the workers and not on the side of the Hospitality Alliance. Our employers pass sweat now.
Well, before I begin my questions, I would like to, point out a noticeable absence in the room. Unfortunately, the Department of Labor decided not to come and testify in person, and I am deeply disappointed because while they did submit written testimony, well, their not being here means we cannot ask questions about their process or their enforcement, or lack thereof, as it may be. And we, of course, know that that stems from deep underfunding that has continued for a very long time. But unfortunately, in this post-pandemic world where wage theft is more rampant than ever, we actually need the Department of Labor to have the resources to fight against wage theft daily. With that, Ms. Kikase, and I apologize, I mispronounced it earlier. I wanted to ask what it takes for wage theft cases to come to the Attorney General's office, because of course not every case does. What types of cases do you guys pursue? And what's your internal process for them?
So we have an online complaint form, or people can call us, or they can email us. All of the lawyers in the Labor Bureau will return those, administrative staff and the lawyers will return those calls to figure out if it is the kind of case that our office first has jurisdiction over and then has the capacity to pursue. So under Executive Law 6312, our office can investigate and litigate any cases of repeated or persistent fraud or illegality. So the illegality part can be a violation of the labor law, but it does need to be repeated or persistent. So if like a single individual calls us and says, I was not paid, what we usually do is refer that person to the Department of Labor and have the DOL is obviously the regulator, and will.
It's not you.
Oh, okay. And will and should investigate that claim. If it is something where there is repeated or persistent violations, and it, as we said, like we look to focus on low-wage workers. We're looking for industries where there is a lot of exploitation, like delivery workers, like home health aides, like misclassification cases. So if it is something, that falls into one of those priority categories for us, then we open an investigation. And so because our office has subpoena power, we can request documents and take testimony and do our investigation before we file a lawsuit. And so if we go through the investigation process, and then what we usually do is make a settlement presentation to the employer and say, these are the facts we've discovered, these are the violations of law we think that you have engaged in, this is the amount of money and injunctive relief we would need to settle these cases, and so this case. And so I think I've listed a few of the industries and types of settlements we have had lately, and those have come as a settlement after our investigation process. But if we are unable to settle, then we can go ahead and file a complaint in court, and we would litigate the case.
What if the employer doesn't pay the settlement?
We are in the same place as everybody else in trying to enforce a judgment. We don't have any extra tools at our disposal to enforce a judgment. So if we end up litigating and we are successful in court and we obtain a judgment, then we are limited to trying to find the assets and trying to if depending on what it is, whether it's if it's a bank account that you would attach or a property that you would put a lien on, going through that whole process. But we don't have the ability to do that until after we get the judgment, just like everyone else. So during the entire time that we are investigating and litigating, the employer can be dissipating their assets.
Okay, thank you. Ms. Pathak, I am wondering if you believe that the collection side of this equation is a big problem here with wage theft.
I think it depends. I think bringing criminal charges is a big deterrent. People are motivated to pay back the stolen wages if we're bringing an indictment. So there is that. To address this issue and what was spoken to earlier about declaring bankruptcy, we see that a lot. A lot of companies will declare bankruptcy, which is why our office created a stolen wage fund. We have put in $500,000 into that fund. So in that situation where somebody is declares bankruptcy and we have criminal evidence, we now have a fund. But I wanted to just repeat what I said in the remarks. I think the state, we would really like it if the state included wage theft victims as crime victims so that there could be funding just like there is for assault victims or sex crime victims. They are entitled to money from the state victim compensation board. Wage theft victims are not. So we really would support that.
I hear that. I would want wage theft victims to be eligible for a U visa at the
Right.
federal level.
That's right.
As victims of a crime. I struggle, actually, and I'm sure you've noticed I don't co-sponsor the bill to criminalize wage theft or to upgrade the charges for wage theft, largely because I believe that it actually just puts another family in a precarious position. And I'm wondering if you simply don't believe that people should, perhaps that person shouldn't be allowed to open another business, shouldn't be allowed to open another LLC. Is that not enough?
I don't think that what we do prevents that. I just think that what my unit has seen through working in the trenches on these cases is that there are bad actors out there. They are exploitative and they will continue to be exploitative. It is a business model, wage theft. Workers are seen as dispensable. And we're seeing that they're using labor brokers, they're using subs of subs to dodge responsibility, and it becomes a catch-me-if-you-can game where we recoup the money and then they continue to exploit other people and not pay wages. So I think a criminal hit, I understand where you're coming from, but I think there are advantages to deter this behavior, and our office also has the ability to execute search warrants where we recover payroll records and documents, and we can make a much bigger case. And like I said before, employers who short their workers are likely engaged in other criminal activity, white-collar criminal activity, and we want to deter that.
No, I understand. I mean, unfortunately, not all district attorneys are created equal. And unfortunately, it's hard to trust that such a statute would be carried out evenly and fairly in all of the various jurisdictions of our state. Do you believe that SWET would serve as a deterrent to wage theft?
We support. I think this is more of a civil redress, but
It is definitely a civil redress.
Right. But we support the concept of recouping wages for workers who've been wage thefted. In theory, it reminds me of a little bit of labor law 198E, where we can, in the construction industry, where we can attach to the general contractor when the sub has not paid. So it reminds me of that a little bit. But so in theory, we support it, although I don't think it necessarily applies to our criminal practice.
Right. I mean, that's the thing about district attorney offices, in fact. Ms. Kennedy, I don't really have questions for you, but thank you, and thank Public Advocate Williams for his continuous support of this bill and so many other things to help working people. Don Virgilio, yo quería preguntarle a usted sobre el impacto que tuvo el robo de salario con respecto a los gastos de su familia. I want to know exactly what impact wage theft had on the finances for your family.
¿Quieres saber qué problemas tuviste al no tener el pago, el mínimo? Si tenías problemas de
¿Hubieron gastos que no
financiero,
pudiste
gastos,
cubrir?
o
No sé si tienes
algo que
hijos.
querías comprar y no lo pudiste comprar. ¿Quieres decirle ahí? Dile, pues cuando no sé qué querías, no podías pagar la renta o algo. No,
Sí, que
no-
se
ajá,
te
sí.
se te
¿Qué
dificultó pagar pagar el alquiler.
Tú sabes, siempre cuando le paga, ellos siempre faltaba comida, faltaba la renta, para el dinero para pagar la renta, pero mi esposa tiene que salir a buscar también, que sea limpiar casa, Brooklyn, hay que ayudar también. Faltaba siempre, por 20 pesos, 120 no va a alcanzar por la semana, por la renta, que está cara la renta, todo.
Sorry,
Oh, no, no.
you know, I forget that other
Oh,
people
okay.
don't speak Spanish very
Oh,
often. You know, the
so I
border
have
crossed us.
sí, okay. So I have it difficult to pay the rent, to buy groceries, to support my family. So that forced my wife to go to work, to cleaning, looking for some money. So that was very difficult. My life.
También quisiera saber cómo fue que usted aprendió sobre sus derechos, dónde fue en que encontró la información, qué recursos encontró, se le dificultó encontrar esos recursos. Espérate, traduzco la pregunta. Porque I'm asking him how it was that he learned of his rights, where it was that he found resources to know exactly what to do once his wages were stolen.
Ok, la información que nosotros lo vimos en televisión, que cualquier gente tiene problemas puede ir al departamento de labor. Nosotros lo vimos en televisión y lo tomamos número del teléfono. Nosotros vinimos al departamento, nosotros vimos en televisión, ahí se me ve en televisión con mi esposa, que es lo que pasa la gente que tiene problemas, que vaya y tiene su derecho a hablar, pero ya no existe derecho porque tardó mucho tiempo. Nosotros tenemos que luchar para sacar los hijos adelante también, sí, porque tenemos más hijos en México, tres tenemos y uno nacido acá, y nosotros tenemos que trabajar más duro para pagar la renta. Si no pagas la renta aquí, te cierra la puerta y te saca para afuera, sí. Pero nosotros vimos televisión para la información del Departamento de Labor, que ayuda a mucha gente que tiene problemas, pero no fue así. Ajá, sí.
Muy bien.
Okay, I watched on the TV because about the Department of Labor, but when I went to the Department of Labor, yeah, they treat you very well, but when you learn the law, you see it's not on your side, it's on the sweatshop bosses' side, so.
Okay. Bueno, pues es un buen momento para recordar a los que nos estén viendo en casa que aparte de ir al Departamento de Labor, también estamos nosotros los legisladores, que tenemos un personal que puede ayudar al trabajador a navegar el proceso de hacer un reclamo de robo de salario. This is a good moment, I think, to remind folks at home that even us as legislators, we have folks on staff who are able to help workers navigate applications, this wage theft claim and others on the DOL website, so we can be a resource too. But thank you. Muchas gracias.
Gracias.
All right. Senator Hoylman Siegel.
Thank you. Thank you, Madam Chair. A few questions. Ms. Casase, just wanted to get a sense of the scope of this problem, and you provided us some numbers, but could you just remind us how many wage theft complaints your office receives a year?
Several hundred, and since 2021, it has been over 2,160.
Mm-hmm. And could you identify the industries where this is most rampant?
I don't have. We could get that for you. You know, I didn't break it out like that, but we see it in the industries that you would expect, right? Restaurants, home care. Laundry workers we had recently, all types of retail, right? Really anywhere where domestic workers, building superintendents, you know, where
Construction?
Yes, construction. And construction, we also see, I think as the DA's office said, the prevailing wage problem, where they're supposed to pay the higher wage, and they're just not doing that.
Do you publish that data, or is it
So
going to
we
be
have
publicly
on
available?
our website, we have all of our assurances of discontinuance, which are our settlement agreements, and all of our press releases. So that is all very easily available. We can provide the information about complaints by industry. That I don't think is up on our website currently.
I just wanted to point out in Massachusetts they do publish that data and
They
have
put,
it available.
yeah, we
Yep.
could take a look at that.
Yeah, I think that'd be helpful for the public and for workers to understand their rights in connection with this. Are there particular employers that you see time and time again?
There are, and that is also one of the ways people find us, is that, if we've helped them with a case. So, unfortunately, some people go on to another job where they are victims of wage theft again, so they will come back to us, or they will have a friend who will come back to us. And sometimes we do see the same employers, and that is really where I think the criminal law can be useful. If you are seeing a repeat employer violate the wage law, that might be appropriate for criminal prosecution. So that is one of the reasons that we do advocate for the change to the larceny law.
And I want to congratulate you and your team for securing $175,000 in stolen wages from Gotham Pizza, which has at least one location in my Senate district, and I think you might have even supervised that case.
Yes.
I'm just wondering, how does a case like that get to you? Was it workers coming forward? Was it your own independent investigation?
Yeah, for most of the workers come to us. I don't remember exactly if that was a call through our intake or if it was a referral through a community group. I mean, there's so many community groups and legal services providers here in the room today, and they also call us about cases and will say, this is one that looks like it makes sense for the Attorney General's office to take a look at.
Would the proposed SWEAT legislation have had a difference in it in a case like that if the employees were able to put a lien immediately on?
Yeah, I'm sure it would, right? I mean, this is, that the lien is something that employers will take very seriously. And so instead, that investigation took a very long time. So instead of having us do the entire investigation, making the settlement proposal, as I went through our process, if you have the lien, the workers might be able to get a quick settlement and not even need our resources. But also it would be helpful for us, right? If it was our case.
And what's the argument on the other side that a lien like that, without just simply going into court and without any proof of wrongdoing, do you think that, is that an encumbrance that is unfair or unwarranted?
I think there's been so much work on this law over the years to make sure that it is very fair to employers that I do not think that employers that are paying workers correctly should be worried about this, right? And, and even in the case, if there was, it's so unlikely, but let's have a hypothetical where there's a worker who's just out to get their employer, even though they've been paid totally correctly, they file this frivolous lien, right? It can be dismissed under the way the bill is drafted if there's not enough documentation of the wages that are owed right when it's filed. Also, the employer can require the employee to file litigation in 30 days. If they don't do that, it will be dismissed. If the employer wants to post a bond, then the lien comes off. So there are so many procedural requirements that have been worked into this bill over the year. I really don't think that employers who are following the law should be adverse to it.
Thank you. And Ms. Pathak, thank you for your work and for the fund, the wage theft fund, stolen wage fund. You've put in $500,000 into that. How much have you distributed?
We just started it in, we just announced it in February. We have a case right now where we're vetting the claims. I think we are up to 7 workers on an old case, so we will be distributing money within the next month or two.
And where did that $500,000 come from?
Asset forfeiture.
So, in other words, you're filling in a void that we could be assisting you with legislation like
Absolutely.
this. So thank you for stepping up.
We're going to save you money.
And I truly like the idea of adding the victims compensation fund as a supplement to that. Is there? Could you just describe the process in terms of the stolen wage fund?
Sure.
Like how does that work?
So it has to be a criminally prosecuted case, first of all. So there has to be a resolution to a criminally indicted case. And what happens is, for example, a community group might bring us a case. We will pursue the case. We'll recoup money for, let's say, 10 workers. The case is resolved. The company has paid back the money, and then 6 months later, we get calls saying, "Hey, I also worked for that company. I'm also owed wages." And the case is resolved, so we can't go back now and say, "Give us money." So they have to fill out forms. We have to interview them. They have to show us some documentation that they actually worked where they said and what dates they worked, and we do a calculation, and that's the process. But there has to be a criminal prosecution first.
Well, thank you for your work. And then, Ms. Kennedy, I was just wondering what the public advocate is doing. I'm sure you can tell us in terms of getting workers informed about their rights.
Yes, thank you for that question. Overall, I mean, we have a number of ways of informing workers, informing folks in New York. Those look like, first, our constituent services. So in one way, that's ways where individuals or groups of workers, anyone residing in New York can contact our office both on an online form, calling as well, or visiting in person. We take in-person folks right at 1 Center Street, New York on the 15th floor. So anyone can come in person Mondays through Thursdays, but we also are available Mondays through Friday.
Your hours?
Our hour is 9 to 5. Yes, and also in our community engagement team. So I am the Deputy Public Advocate for Education and Opportunity. Opportunity really supports pathways to dignified work. And so we see this as a mission in terms of the office because this, it holds the fabric of our families and our city together. So in our work, we both connect with our policy team, but the community engagement team really connects with relationships on the ground. So that's where we connect directly with advocates, particularly with community groups, mutual aid groups, as well as folks that are doing this work both at the electeds level, but also, again, in many other ways. My work, again, is in the education realm as well. So we find that parents, right, parent advocates, community education councils even find us through the many pathways that our community engagement team works. We also have a justice, health, equity, and safety team. And so when we think about and housing equity team, when we think about access to resources, it could come through a number of different ways in our teams. We did put out a report that really addressed parts of this, but also it's a way in which we amplify in a number of ways the public advocate, whether in city council hearings, the bully pulpit in his role, as well as keeping city agencies accountable. And so when we do see those patterns, it's something that we can amplify and bring to the forefront. And we are really, really grateful for this bill.
That's really good to hear, and I know the public advocate is never shy about amplification of issues of public concern. So thank you for that. And then, Mr. Martinez, I just wondered if what you can. Oh, sorry, I apologize. I have my notes here wrong. How you think we can encourage workers to report theft violations?
¿Piensas que debemos animar para reportar, hablar, quejarse, salir o qué piensas?
Salir, no que salir.
¿Qué le recomendarías a otros trabajadores que están sufriendo el robo de
Sí,
salario?
sí, porque le lucha a ellos también sobre, porque ellos uno le tiene miedo uno tiene miedo de estar trabajando y a veces los patrones también comienzan a gritar, ellos les tienen miedo o que no vaya al otro lado por eso el problema.
Okay. So he encouraged the workers to speak up. I know the bosses, they yelling us, they discriminate against us, but don't be afraid, speak up. Yeah.
And what are the groups, outreach, community organizations who he is familiar with that help elevate and amplify the voices of workers?
Okay, so, ¿qué grupo o qué organización conoces que estás participando y deberías decirle que vayan allá? ¿En qué grupo estás participando?
EMA, ¿no?
Okay,
Sí.
okay.
Organización EMA, dile.
Okay.
The organization EGMAS, National Mobilization Against Sweatshops. Yeah, he encouraged to workers come to EGMAS. Yeah.
Thank you.
Gracias.
Well, thank you, Panel A. Thank you for your time. While we give them a few minutes, and I'll introduce Panel B, I will announce that after Panel B, we will be taking a 30-minute union break. Mandated. All right. Panel B, we have Margaret McIntyre from the National Employment Lawyers Association. Come on up. We have Andrew Ridgey from the New York City Hospitality Alliance. We have Richard Blum from the Legal Aid Society. Jeff Garcia from the Latino Bar and Restaurant Association. And Natalia Varela, supervising attorney at Make the Road New York. It is quite a game of musical chairs. Apologies. Yes, Mr. Ridgey, number 2. We have McIntyre, Ridgey, Bloom, Garcia, Varela. Also, they brought a memo of opposition in addition. Ms. McIntyre, when you're ready.
Good morning. I'm a sole practitioner in into my 3rd decade of representing employees who suffer from economic insecurity. Most of my practice has been in employment discrimination, but in 2010 I began taking on some wage and hour cases, and I mention that because I was surprised by the amount of legal gamesmanship that is found in the legal process when attorneys bring these lawsuits in court on behalf of workers. So that's why I'm here in support of SWEAT. New York has great laws that prohibit wage theft. The Wage Theft Protection Act of 2010 was very strong. It provided full liquidated damages and meaningful penalties when employers do not keep good records, which they have been required by law to do for decades. But those penalties haven't been enough to encourage enough employers to actually keep the good records. In New York, as everybody knows, we have the Department of Labor, the Attorney General, the District Attorney's Office. We have a lot of nonprofits that represent low-wage workers, and then we have the private bar. And in the private bar, the larger firms tend to handle the class action cases, and the individual or small collective action cases end up being handled by small firms or sole practitioners. And still, with all of these different people trying to address the problem, doing good work, there are a lot of employees who fall through the cracks and never find representation at all. And a lot give up on going to the Department of Labor. And so all of the providers of legal services to employees to help them collect on unpaid wages, they struggle to achieve their goals when the process is too long and the outcome is uncertain. That means that both private attorneys and public interest organizations have to seriously assess the likelihood of prevailing on a case before they take it. Because otherwise, you could spend years and end up with nothing for the employee. the current situation is a tragedy for each individual worker who this happens to. But this also represents a systemic failure of our legal system to handle wage and hour claims. The good laws we have, all the people working, haven't stopped the problem. And yes, it is quite common for some employees to find themselves needing legal help more than once in their lives. And sometimes the employers will accuse them of being serial litigators who fabricate claims. That's wrong. People bringing more than one lawsuit is a sign of the pervasiveness of wage theft. Almost no one likes being a litigant, least of all the persons who become litigants because they are working hard but not paid for all they're owed. We would not have the level of wage theft we have without there being a lot of employees experiencing wage theft from more than one employer in their lives. People who have the guts to bring a second claim for wage theft should be praised for their courage and resilience, not ridiculed and viewed with suspicion. One opposing counsel of mine referred to the lawsuit we were litigating as being, quote, not your client's first rodeo, unquote. That being her explanation of why my client must be exaggerating the amount of hours of unpaid work. That's not true. It's not a rodeo. It's not fun. This has to stop. And so, in the legal process, the most common way for the most powerful party to block the least powerful party from achieving their goals is to engage in delay tactics. And this happens in all kinds of litigation, unfortunately, but it happens more in wage and hour cases. I'm not going to go through all of them. And I want to say first that that's our legal system. Our system allows both a plaintiff and a defendant to litigate cases that can't be settled, and good lawyers on both sides are trained to fight hard. When employers are sued for wage theft, they need and deserve good counsel. But in my experience, what happens is they do employ these typical litigation delay practices, and that's why we're talking about these cases taking years. 2 to 5 years is not at all uncommon. And this is about wages that people already earned. We have things like struggles to actually serve complaints, late answers, default judgments, partial defaults where one party defaults, but then the case has to be litigated against another defendant, and that takes time. And disputes over discovery, again, just takes time. Now, and when an employee finally gets a legal judgment, they're supposed to get paid within 30 days. But often they don't because the assets are gone. If the judgment is large, an employee might be able to find a collection attorney, somebody who specializes in collecting on unpaid judgments. They might be able to find somebody to take that case. But if the case is considered too small for such an attorney, that's not going to help. So then the plaintiff's attorney has to file judgments in all the state courts where the employer has property. Sometimes you can enlist the services of the city marshal, who can collect some amounts from accounts that can be seized. If that doesn't work, then the attorney on behalf of the employee has to engage in what we call post-judgment discovery, where you can go back into court and start asking for more records about the employer's assets. And if you find those, then you have to start an action to actually seize those assets. And so it's not surprising that by the time you get to that stage, the assets can't be found. There are continuing legal education courses offered frequently to help lawyers help their clients protect their assets. And these CLEs are presented as complying with the rules of professional responsibility that apply to lawyers, and I assume that they are. But those asset protection strategies that might be appropriate in commercial litigation should not be deployed to prevent victims of wage theft from recovering on judgments. Okay, so enhancing criminal penalties won't help. I understand the emotional appeal of that. There are some people who are such repeat offenders with wage theft that they deserve to be thought of as felons. However, going after someone criminally is not going to get the money back into the hands of the employees. So I think we really need SWEAT, and I think SWEAT is our best chance of creating a disincentive to employers to continue to do this. It has to stop.
Very good, thank you, Ms. McIntyre. Before I let Mr. Ridgey begin, I want to acknowledge Assemblywoman Linda Rosenthal, who is the bill sponsor for SWEAT in the New York State Assembly. You want to say hello?
Sure. Thank you, Senator Ramos. Thank you, Senator Hoylman-Sigal. It's great to be here. I'm an Assembly member. Yeah, we can all work together, and we are. The Assembly has passed. We must. The Assembly has passed this numerous times. The Senate has passed this, and we're hoping to do it at the same time, so that we can have a law. But we've spent many years fighting against wage theft in all its forms, and I think this is the way forward. Of course, we're open to hearing other suggestions, but it is an epidemic of wage theft. And we have to do right by the people who aren't getting what they've earned. It's a calamity for them. And so the thing that's impressed me most is when the workers who have not gotten their wages say, we want to still work in this place. We are still interested in doing our jobs. We just want to be paid for it. And that's, a different gesture than one you would expect. And so I'm interested in listening to everything everyone has to say, some of which I've heard for many years, but some of which is new and a different angle. So thanks for having me.
Absolutely. Thanks for joining us, Mr. Ridgey.
Okay, good afternoon. My name's Andrew Ridgey. I am the Executive Director of the New York City Hospitality Alliance. We represent restaurants, bars, and nightclubs throughout the 5 boroughs. Thank you, Senators, for having me. Hello, Assembly Member. I actually prepared 2 sets of testimony. One, when I received the first invitation, it was a little bit more broad strokes on this issue, so I will submit that for the record. If we have time, I can hit some of those topics as well, but I will focus on the bill here today. So I've worked with many of the advocates in this room, and I know I'm probably one of the few contrarians on this bill here, but I think there's some really important issues that need to be pointed out about a lot of our significant concerns. I want to be clear. Wage theft is absolutely horrible. It's our job to be here to represent employers who also have a major stake in this. And I look at it as 2 buckets. There are horrible employers that are going to continue to find ways to circumvent the law, and there are good employers. And very often, good employers trying to do the right thing can get caught up in the complex legalities of all the different city, state, and federal labor laws, and it can result in a lot of complexity, a lot of legal liability, a lot of financial liability. And in the case of the SWEAT bill, it essentially removes due process for small business owners, for their investors, and even for managers. And this is, I think, the only place where we would even be having a discussion about removing due process I understand wage theft that can't get collected is an injustice, but we should not be trying to address one injustice while replacing it with another injustice. So I do not know if we've discussed there are ways to amend the bill to make it acceptable, at least from our perspective, but I do want to highlight a lot of the concerns, and then we can certainly discuss. Essentially, this bill will allow an employee or employees to file a lien on the personal assets of owners, managers, and investors based solely on the allegation of a wage violation, not a judicial finding. Second, that could freeze credit for small businesses, making it harder for them than it already is to access credit. If they need government loans, it can make them ineligible for government loans. It could also dissuade employers from incorporating or forming LLCs here in New York. It could also encourage them to create shell corporations. That could make it even more difficult for the individuals trying to collect to find out who the actual real owners are. And it creates a lot of additional expenses and burdens on employers because even if they prevail in the overall lawsuit, they're going to have to undertake additional time and additional costs to have the lien removed. It's going to decrease the number of investors that businesses can turn to because what investor is going to want to put money into a new restaurant or a growing local company if they know that there could be a lien placed on their personal assets? This would also give unfair advantage in any types of negotiations. I understand, as speakers have mentioned, that these cases often take a long time, but this also gives the lawyers a lot of leverage over employers to settle more quickly and for a larger amount, even if the the claims are disputed. Often, particularly with restaurants and some of these claims, there's a lot of disputes. It's not always crystal clear. It's about overtime. It's sometimes people clock out early. There's a lot of different factors, I won't get into all right now, that put a lot of these different disputes at claims at dispute. It could, as I mentioned earlier, increase bankruptcy by employers and individuals trying to get rid of the liens. It could encourage employees to exaggerate the claims so they can assess a larger lien by doing so, which again gives more leverage to settle quickly and for larger amounts. I mentioned putting managers at risk. Who's going to want to be a human resource professional or a manager in a business to find out that a lien can be placed on their private assets, meaning that they can't, put their kids to college because they can't get the loan? Difficult to open up bank accounts. So there's a lot of additional consequences for these managers, employers, and investors based on this. We've discussed before, there is a provision in the law that allows a plaintiff to get an order of attachment, which somewhat similar to a lien. If the plaintiff can prove that there's a likelihood the defendant is going to improperly transfer their assets, would have, obviously frustrating creditors. There's also a difference between a wage lien and a mechanics lien. In the construction industry, when a payment's made to a contractor, the company will receive a mechanics lien release that prevents the contractor from falsely asserting a lien after being paid. There's no such protection for an employer in a wage lien context. And I can go on, but additionally, we also believe this is unconstitutional. Unconstitutional taking, as it prevents an individual access their own property without due process. I know it was mentioned earlier about bonds. There is no bond market for wage liens. I've spoken with some different folks, and it's questionable whether or not a bond market would even be developed and created in this case for some different legal and other financial complexities. Again, we understand the underlying issue here. It's a serious issue. No one's disputing it. And we want to work with you all, and I hope you know through our work over the years, we are open to doing so, but we just do not see how this bill is drafted works. And we also think, as was mentioned before, that a few folks said, wage theft is a business model. And as long as wage theft is a business model, people that want to commit it will go to great lengths to circumvent this law. You can put the assets, a lien on the private assets of an employer. Well, that employer could just put their assets in the name of someone else. They can move their assets out of state. So there are still ways that the bad employers who this law is trying to address will continue to circumvent it, while the good employers, the small business owners that you know well in your neighborhoods, people that want to invest in these businesses, the managers that you know when you go to your favorite restaurant and see, will be impacted. You are removing their due process. Nowhere else would this be acceptable but here. And if there's ways to make modifications, we're open to those discussions. We're not sure exactly what those have been, but we're here. We'll always speak with you. As I said before, I know many of the people in this room, some of them I've worked with on other issues, are very unhappy with us because of our position on this, but you do have the New York City Hospitality Alliance's commitment to be an honest player in this, and I presume and hope you can appreciate where we're coming from and sharing this perspective. So I'll leave it at that with the extra time. Like I said, I also did submit other comments. I hope you look at it because there's a lot of other issues I think we could work to address together. Thank you.
Questions. Thanks for being here.
You got it.
Wow, that got louder. Yes, Mr. Blum.
Thank you, Senator. Oh, wow. Is that a good volume? Thank you, Senators, for having me. Wonderful to see you, Assemblymember Rosenthal. It's been a while. At least pre-pandemic, post-pandemic first meetings, right? So I'm glad to be here to address this issue from the perspective of the Legal Aid Society, say a few words about that, and then address some of Mr. Ridgey's concerns, since much of what he described is actually not in the bill. And then a few things that are in the Constitution that should be addressed as well, that are good for this bill. So first of all, the Legal Aid Society has probably the largest nonprofit employment law unit in the city, which is to say, when we're fully staffed, it will be 7 attorneys plus 2 supervising attorneys for the entire city to do discrimination cases, trafficking cases, wage theft cases, leave law cases, and some unemployment cases. That is to say, there are very few nonprofit lawyers out there to bring these cases. Nevertheless, we do these cases quite a lot because wage theft is an enormous problem. Colleagues in the nonprofit world. We also work with the Department of Labor, with the Attorney General's office to try to combat wage theft. I'll give you 2 examples to illustrate how many resources we have to put in because of the problem of transfer of assets. One was a case I did several years ago against a wholesale bakery. The day after the defendant was served with the complaint, he transferred his home in Brooklyn for $10 to his daughters. I think it would be very difficult on Zillow to find a house in Brooklyn that's worth $10. And he then sold the property and physical assets of the bakery to someone he claimed he didn't know. He then donated his share of the proceeds from the sale to a for-profit business associated with the buyer. Something seemed wrong there. It took us years in bankruptcy court with expert pro bono bankruptcy counsel from one of the city's leading law firms, 2 adversary proceedings in bankruptcy court to finally get him to pay $320,000 that he owed to a group of workers. Some of those workers were represented by private attorneys who would have been able to collect zero had we not been able to, had they not sort of come along for the ride with our pro bono bankruptcy counsel. So that was a group of altogether about a dozen workers, years of work in bankruptcy court with pro bono help. All because we were unable to prevent those transfers in advance the way the lien would allow us to do. On the attachment, the Bobby Nail Salon case, and we have a plaintiff from that case here who's still waiting with his co-plaintiffs for the $400,000 plus owed on the principal, plus the additional $300,000 or so owed in accumulated interest, which has not been paid. We brought a motion for attachment in federal court under the CPLR, it's the CPLR that controls here, the state law, saying, look, he's selling the businesses and transferring his assets, stop it. The judge at first said, okay, fine, he has to put the assets into escrow, fine. Then the judge decided ultimately, because you, the workers, can't show the employers intent to commit fraud here, who knows why he's transferring this money, why he's getting rid of his assets? Who knows? Could be for any reason, right? That's why we're here years and years later still trying to collect on these hundreds of thousands of dollars owed to these workers. So the bill would remedy that problem by adjusting how attachments are done. Now let's say a few things about the concerns expressed about, supposedly about this bill. First of all, I just want to make a comment about the complex legality. The businesses we're talking about, and let's talk about small businesses, they hire lawyers and accountants to handle negotiations over leases, to handle bank loans, to negotiate all sorts of things with vendors. They know where every dollar comes in and goes out of their business, but somehow they can't count to 15 when it comes to determining what the minimum wage is. We are not talking about oopses here. We are talking about employers and large segments of certain sectors, including the restaurant industry, maybe most especially, who don't pay at all for hours worked, who have people shave the clock, who have people work off the clock, who don't ever pay overtime. They may have 2 sets of books. We see every kind of shenanigans out there. And these, again, this is not an oops, this is a business model. And that is all too pervasive and is unfair to the employers who are doing things right. So let's talk about a few features of the bill. First of all, this idea of removing due process is just legally incorrect. The Court of Appeals affirmed the appellate division decades ago, saying that a lien is not a seizure of significant property. It is putting a notice, a marker down, an encumbrance, to inform potential buyers that this is disputed property, which it is. It is disputed property. And so therefore, the terrible thing that the company has to endure, or the employer has to endure, is that they have to keep their own assets. That's the terrible thing they have to endure. The court said this is not, that giving notice basically to potential buyers who could be, who themselves could be defrauded, is not a violation of due process. And that makes perfect sense. It isn't. So nobody's removing due process from anybody. I'll also add that it is simply not true that investors are subject to the lien under the bill. This is not true. As far as freezing credit's concerned, and problems with government loans, well, filing a lawsuit has an impact on this as well. And nobody's saying, I hope, that we have to get judicial approval in advance to file a lawsuit. The whole point of the lawsuit is to sort out the dispute. And yes, there are concerns raised about property that's in dispute, but the property is in dispute. I don't understand how this encourages shells. The whole point is that it makes it harder to play games like that. And yes, it does change the negotiating position, and that is exactly the intention. So instead of having cases drag out and have the assets dissipated, we come to the negotiation honorably, early on, settle the case, and actually the main purpose of the bill is to prevent violations of the law in the first place. So we'd like to see enhanced compliance as a result of this bill. We expect to see enhanced compliance. I'll also add something about the managers. First of all, it's not the HR person. You have to be an employer under existing law. The bill does not change existing law. You have to exercise enough control over the workers with respect to their wages to be considered an employer to be subject to this. That's been the law for a very long time. So yes, if you have a manager who is stealing people's wages, putting down false records, firing people in retaliation for complaining about it, yes, that person is an employer, can be sued, those assets are in dispute, and the lien is appropriate. If they are the shift supervisor, they are not, who is just doing scheduling and so forth, and doesn't have those degrees of control, they are not an employer, and therefore the law simply doesn't apply. So it only applies to managers who qualify as employers because they're exercising the kind of control which enables them to commit wage theft. As far as exaggerated claims are concerned, there is a provision in the bill which punishes people for trying to enforce a lien where there is exaggeration, and the lien can be thrown out for exaggeration. The lien, again, has been mentioned before by Karen Case. The employer can force the worker into court within 30 days to have the case adjudicated. The worker can't just sort of sit around and sit on the lien. as far as the bond market is concerned, it's not surprising there wouldn't be a bond market yet for wage liens since there are no wage liens. And I'm sure there was a bond market, I know there was a bond market developed after the nail salon bond requirement was developed. I think the main point here is that the focus of these different industry representatives, if I may, should be on protecting the people who do obey the law, who do pay $15 an hour for each hour worked, plus the extra rate for overtime, who do not steal their workers' tips. These are basic principles. This law would make that a reality. And I think what we do to enforce a law reflects the values of the society. We have allowed the reality here, not the hypothetical, imaginary concern or worry. The reality is years and years and years of pervasive wage theft as a business model. That's the reality we're grappling with. This law would make the existing laws real, and I think that would speak to the values of the society. Thank you.
Thank you, Mr. Blum. Mr. Garcia?
Thank you, Chairwoman and Assemblywoman. I'm here on behalf of the New York State Latino Restaurant, Bar, and Lounge Association. My name is Jeffrey Garcia. I serve as president of the New York State Latino Restaurant, Bar, and Lounge Association, which represents the interests of hundreds of minority, immigrant-owned restaurants, nightlife establishments throughout New York City. I will focus my testimony today on our concerns with the Senate Bill 1977, which would place an automatic lien on business owners' business and personal assets based on an allegation of a wage dispute. While we appreciate the intention of the bills, which protects workers and wage theft, the association has concerns with the financial implications and the lack of due process the bill would have on our businesses. The proposed legislation will affect our employers, managerial employees, and minority-owned establishments already struggling to overcome the many challenges present today in our hospitality industry. Our industry was one of the hardest hit during the pandemic, and many of our members are still recovering from the economic strains induced by the pandemic. The proposed bill will make matters worse for our small business, many of which serve communities of color, by forcing them to shoulder additional financial burdens to defend themselves against liens based solely on an accusation. Additionally, we fear that this proposed bill would prevent our businesses from a fair hearing and due process. We urge the committees to consider implications of this proposed bill and the impact on the hospitality industry. We thank you for the opportunity to speak on behalf of the New York State Latino Restaurant, Bar, and Lounge Association. Now, just on a couple of notes since being here, my background before getting into this advocacy was law enforcement. So I come here, with that in mind. And our members, my members, I tell them all the time, and they must know that wage theft is unacceptable in any shape, way, or form, right? Our employees are the face of our businesses. They are the ones that represent us when we're not there, and, are the ones that encourage people to come back or not come back, right, if bad service is given. So we depend on them, and we understand that it is unacceptable. What happened to the gentleman that was here earlier today is unacceptable. But as we also heard directly from him, this was an additional mishap on the Department of Labor not doing their job. And I think there are significant things in place for employees and recourses, right, through the State Attorney General's office, through the DA's office, Department of Labor, that they have the recourses to go after the bad actors. So another unintended consequences of this with loans. Imagine during the pandemic, people that may have a false lien placed on their property. They wouldn't have gotten an SBA loan. They wouldn't have gotten the PPP loans to help them survive through these industries. A lien also, automatic lien, puts an issue with your landlords and your leases, which also are huge concerns. So there are unintended consequences to this bill that we also need to consider. And we would love to work with you to work on these issues and come up with a better solution. Thank you.
Thank you. We had also called up Natalia Varela, who is a supervising attorney at Make the Road New York. My understanding is that she's still on her way, so hopefully she'll be able to join the next panel. If it's okay, I'll begin with some questions, and then you can go ahead, Assemblywoman. Ms. McIntyre, can you... I really enjoyed your testimony with regard to the need for representation, or for the increased need for representation. And I'm wondering if you have suggestions as to how we can better reach communities that are underrepresented by attorneys, and if you have any ideas as to how to alleviate kind of this paradigm from the outcome-driven model.
Well, I don't think that we need to be encouraging more lawyers. I'm not looking for that.
That's not, I don't
It's
know
not
that that's
working.
working.
It's not.
Maybe the other one?
This working? No.
Is the light green?
Yeah, no.
Okay.
Maybe that's working.
As long as the light's green.
Okay. I'm not looking for more lawyers. What I'm looking for is a better system where the lawyers that we have a reasonable chance of succeeding with the claims they bring in a short amount of time, so that recovery can be certain, and so wage theft will not be an attractive business model. Really, we don't want more of this. We want less of it. We want less of the problem, so that we don't need more lawyers.
Okay. And can you tell me how SWEAT would change the way you represent your clients?
Well, yes, and not just me, but I can tell you that lawyers who are in private practice often, well, first of all, I found out after I got a judgment in my first wage and hour case how common this was. And I learned that a lot of private practitioners will look into the assets of the employer before they even bring the lawsuit. At first I thought that was cold-hearted, but then I realized, like, they have to do that. And it's the employees who suffer because that has to be done. So again, I think that SWEAT would help that in terms of making representation more likely. The best outcome for an employee is for them to need as little legal help as possible. And what that means is there has to be swift and certain redress actually available. And if that's the case, then an attorney in my position could take more cases that would take less time, and the employees would have more money in their pockets.
Very good. Thank you, Ms. McIntyre. Mr. Ridgey, perhaps the most compelling argument, or the argument that sounds most compelling, is that somehow employers' right to due process will be taken away. But due process is not a loose term. Due process means a very specific thing. It means the right to receive fair notice of a hearing. It means the right to secure the assistance of counsel. It means the right to cross-examine witnesses, and a written decision with reasons based on evidence introduced and with an opportunity to appeal the decision. Which one of these is denied in the SWEAT bill?
Well, all of those things are occurring while there is a lien on the assets of people based on an accusation, which can have multiple material impacts on their livelihood. So an accusation is allowing an action that is negatively impacting the owners, as you said, investors and managers, which often exert control over the business prior to any sort of judicial ruling. So it's allowing an accusation to materially impact someone before there's an actual finding, like in a criminal case. And again, I'm not, an attorney.
Neither am I, but I do play one on TV and write
Yeah.
laws for a living. My understanding is that the obligation of the lien actually means that you're prepared for litigation.
And the lien is in place before notice of the hearing. So one aspect to address. Is that
Okay. Can you understand that the fear is that if we were to give the employer additional time, there would be the transfer of assets, as we've seen and actually has been outlined in other testimonies? I mean, what do you think the employer would do with that additional time?
No, as I said, I understand that it is a legitimate issue, and it is something that should be addressed. What I am suggesting is that there may not be a perfect solution to this. And I think those employers that would be those ones, if you were to give them additional notice to transfer their assets, if this law is to take effect, it's part of their business model. So they are not going to keep assets in their name. They are going to have assets out of state. So I think there are ways that they can circumvent this law. And as was suggested in some of the responses to my testimony, I just do think it's clear. I understand if people deal with these horrible situations, but I deal with employers all the time, and I can tell you there are good people all the time that are sued for large amounts of money over the complexities of the labor laws.
But there's a penalty for frivolous lawsuits.
Well, but who's to? Well, I don't know. It's a penalty. So yes, if you were to exaggerate a claim, there is a process, but you would still have the lien on your assets while you're trying to have it removed. Two, how do you even get to know if it's exaggerated or not? An employee could say, "Well, I was working for X number of hours off the clock." A lot of things are going to be in dispute. And this whole time while you are trying to get to the facts of the case, you are having an impact on these employers. And many of them are good employers. And I'm saying, yes, the people that
what would you say is the biggest impact on the employer?
On the employer? Well, I think there's multiple that I lined up. I mean, one having to do with credit. Another one, just the fairness of having an impact, being able to place a lien on someone's private, personal assets based on accusation. I just think is philosophically a big problem, but issues with credit, issues with other types of loans, investors, managers having this types of responsibility, the issue of having the leverage, which I understand folks want on this side, but on the other side, being able to use and exert this influence to settle more quickly for a larger amount of money than they would in another circumstance. So, I mean, those are several of them.
Do you believe that the remedy for wage theft should be civil or criminal?
I think right now that it's civil. I'm not as familiar with some of the other proposals that were discussed here. I think if someone is truly exploiting workers, there should be significant consequences. My only concern would be, I think, which gets to you, that sometimes there are issues at question, and sometimes someone, not because they're a bad person or they have malintent, could be in violation of the law. And for them to have criminal charges could be a concern. So there would have to be some distinction made on which employers would be facing criminal charges and which wouldn't. And we could certainly discuss that further.
Now, the Hospitality Alliance has submitted a memo of opposition
Correct.
against Sweat. Have you submitted a memo of opposition against the criminalization bill?
I have not, or we have not. I'd be happy to look at it. Again, I'm not as familiar with all the details of this. This has just been a bill for multiple years now, which we have repeatedly expressed a lot of concern about. It's something that we constantly hear from our members that are very fearful about the implications of it. But we would certainly be happy to discuss and look at that other bill and whether it was a memo of opposition or comments to make modifications where we think it would have a beneficial impact for workers and not hurt good employers, we could submit something.
How do you believe that workers should be able to obtain their stolen wages?
Well, one, Department of Labor. I understand there's a lot of concerns about, their enforcement or their teeth. Perhaps there's things that can be done there, whether enforcement, it was mentioned that they are underfunded. I don't have those numbers, but we would certainly support additional funding for the Department of Labor and for other entities to help enforce these cases. I think also wage theft is a very broad term that can be used, in many different ways. So if we're talking about...
How broad? How broad?
Well, it covers a lot of issues. So, for example, in the restaurant industry, there are a lot of complex issues. For example, if there's something called the 80-20 rule, which if it's violated, it can invalidate a tip pool, which creates enormous financial liability for employers. I think it has a lot of negative consequences for workers as well. But that could be a situation where none of those employees are earning less than the minimum wage. In many cases, they could be earning a lot more than the minimum wage, and it's technically probably considered wage theft, but I think it is more of a technical violation than an intent to steal someone's wages or to underpay them or to have a judgment against you and then, fraudulently transfer your assets. So I think, again, there's a distinction, and it can be difficult legally to do it between the types of situations that are being discussed here where employers, part of their business model is exploitation, underpaying workers, and the other type of employer that can have a judgment against them or be in violation of the law where it was not malintent, where the subject of the situation isn't the theft of wages like I think are being discussed here today, where, again, it's more technical related, often due to the complexity of the laws.
Okay. Thank you. Mr. Blum, you are, I think it's fair to say, one of the foremost experts in New York State with regard to wage theft policy. You were an active member of the coalition negotiating with the former governor about this bill. I'm wondering if you can expand, maybe share a little bit about the veto and where you might think the governor had made a mistake.
Okay. And by the way, I'm glad to hear that we have an ally in supporting funding for the Department of Labor's enforcement work. We'll be
Amen
happy
to
to work
that.
with them on that. And I suspect that the other area where we probably agree is that I'd like to be put out of business and not have any of these cases anymore. So that would be that's an outcome that I think would be advanced by this bill. The governor's veto mentioned two things. One, both of which were inaccurate. One was it gave the impression that people who really had no control over the situation, were really not involved in the wage theft, would be victims, in quotes, of a lien. That's simply not accurate. Again, we are using the existing definitions of employee and employer. We haven't changed any of that an inch. And those definitions go to issues of control. So again, the manager who in fact is stealing wages is an employer who's in a position where they can steal the wages, right? Where they actually do the paying, where they do the timekeeping, and where they're fudging the timekeeping or whatever. Those folks are employers. They can be sued under existing law if this is never passed. That's the law today. All this says is they can't transfer their assets. Now, obviously, if the person doesn't have any assets, they don't really have to worry about a lien. But if they're a person who does have assets and they've been stealing someone's wages, then there's a claim against them under existing law, and the lien is appropriate to make sure that the disputed assets don't get dissipated, don't disappear before the matter is resolved. The governor's other incorrect point was that there's a due process issue. As I explained before, the Court of Appeals resolved this issue in, I think it was 1978. I think it was 77, the Court of Appeals. And they affirmed the appellate division, which said that this is not a due process, that the mechanics lien, and very much for the same reasons, is not a a due process violation because what it is doing is putting an encumbrance on your property. It's not taking the property. The property still belongs to the person. It's letting prospective buyers or other actors on that property know that the property is in dispute, which in fact it is. That's not like alerting people, notifying people to a dispute is not a due process violation while that dispute exists. So those were both incorrect statements, and unfortunately, based on those incorrect statements, it was vetoed. I'll just also point out that we've just heard about complexities repeatedly. The bad unicorn in the room, or not in the room, is the false allegation that's been invoked several times. We don't have a history of that. I mean, there's no record of it. We've been requesting examples for years, haven't gotten any. There are, examples way up to here of wage theft that we know of. We're going to hear more about them. That's a real problem. The bad unicorn of the false allegation is a fake problem. So we really need to remedy the true problem and not be scared away by the fake problem. The other thing I'll say is that complexity for one person is rent money for another. So the 80-20 rule, it's been in existence in New York State regulation for over 10 years. And it says basically that you can't treat a person as a tipped worker for work when they're not getting tips. Now that's not like a complex concept. That's like, just don't cheat people, right? So we had people who were spending half their time doing non-tipped work, and they're being treated as tipped workers for all their time. That's wrong. So yes, you do have to keep time records for this. That does mean that. And you can't violate those time records. So this is something that, if employers are going to do that, they are in fact violating the law. They're violating a well-established law. And if they are sued, we want to be sure that they can pay, in the end, the judgment under the current law. That's what this is about.
Mr. Blum, you're here representing the Legal Aid Society, which of course, provides representation on a full range of cases. And would it be fair to say that the docket in criminal court is pretty lengthy?
Yes.
Right?
Yes.
Is it increasingly hard for New Yorkers to receive a speedy trial?
Well, I would not be the best person to answer that question for the Legal Aid Society. I'm not in the criminal practice, and I don't have access to the data on it. But we certainly have concerns about the overuse of the criminal system, the significant overuse of the criminal system.
So, would you say that adding another burden would that actually be helpful in addressing the issue and in getting people their money?
We believe in a civil solution to this problem. We've not supported attempts to expand the criminal law. Generally speaking, the Legal Aid Society does not support expansions of criminal law. We tend to prefer other solutions, in this case, particularly a solution that would empower workers, which I think is actually exactly what's in dispute here, right? Because we're hearing, what workers might do something wrong sometime in the future, right? And we're saying, no, actually, it's important to empower workers. There is an power imbalance that this problem reflects, and we want to put more of that power, if you want to call it leverage in negotiations, but more power back in the hands of workers.
Perfect, thank you. Mr. Garcia, you stated that you are a former law enforcement agent, right? And so I'm wondering what your opinion about this civil versus criminal debate might be.
Well, first, I think that it almost seems like we're trying to convict someone without even indicting them, right? And it just seems like we use the word encumbrance way too loosely. Like, it's just okay to encumbrance the owner, because of this. Now, again, if the owner is and has been violated wage theft, then he should be addressed. That should be addressed.
But then how should that be found?
Again, and I think that, and I agree with Andrew and yourself here, where I think it should be the Department of Labor. We should put more money into the Department of Labor so that they can do this. Just like, we put money into these other agencies to do enforcement, whether it's the SLA and giving them money for enforcement, we should give the Department of Labor money for enforcement in these cases. I think there's also should be a big education background done on this, whether it's employees and the employers on what wage theft is and how it should be addressed.
But what
Andrew, unless it's something like we've heard here where it puts people's lives in danger and things like that, holding them criminally, I think is a possibility if it leads to something of in danger. But everything else should be done civilly. But it should be done in a process.
What happened? Well, I think we're here to figure out, right? What do you think that process should be? And what happens if the DOL does, or the AG for that matter, does find that someone is guilty, but the employer isn't paying out the settlement, which is the issue that we're trying to address here.
Well, but wait a minute. Now they were found guilty. Well, maybe at that point there should be a lien. But you went through the process, okay? You went through the process, not before. And again, me saying anything different would be encouraging wage theft. I don't encourage that. If you were found guilty of that, then you should be held accountable and you should have to pay. Now, I don't agree that, from one day to the next. I don't know. I would love to find out how they sold the property in one day, but, I didn't think it was that easy. Because, again, I think that there is, even with that, there is a process, right? But, again, I don't believe that a lien should be placed automatically just on you going in one day saying, oh, they stole my wages. And, and you show some documents that you understand is stealing of wages, but there is no further proof, or you don't bring the owner in to talk about that.
Do you have a recommendation for how we can address this?
Well, I think that we've spoken about this, right? And I think that there should be some timeline before any type of lien should be placed. Folks should be brought in, and there should be a timeline. And again, if there is
you agree with the
substantial,
lien approach?
again, I don't agree with an automatic lien. So I wouldn't agree with the bill the way it's stated right now.
Thank you. Assemblywoman Rosenthal, they're all yours.
Oh, thank you. Some of whom I've spoken to for years, and it's great to see you and you as well, Mr. Reggie. I'd like to ask you some questions. It was about 10 years ago that the Saigon Grill, a very popular restaurant on the Upper West Side, closed after the owner had been found guilty of owing millions of dollars to about 38 delivery workers and other workers in the restaurant. He then sold the restaurant to someone else who promised me he would pay what was owed and did not. And then the restaurant went out of business, and the workers, I still talk to some of them today, and they have not gotten their money, and that's what inspired the sweat bill. So we met in my office shortly after that, maybe it was 2014, 15, with a restaurant owner on the Upper West Side. And I said at the time, if an owner is doing the right thing, they're paying their workers, then they should have nothing to worry about. And you brought up that there are many claims that are not true. But we've heard that that is really not the case. Maybe you could elaborate on when you think that happens. And I offered at the time, well, let's deal with that. If you think that is such a prevalent practice that, you or the restaurant owner said, well, someone will come in and work for 2 days and then allege that they're not part of the tip pool, and then they sue, and then the owner has to agree to avoid going to court, and that's how they get scammed out of money. So if you could elaborate on the claim that many people are operating in a scam mode and really just want to extort money.
Well, my comment, I think it's broader than that. I think it goes back to kind of making the distinction between the two types of employers. I think there's just bad people in all places, but generally most people try to be, good people, whether they're employers and employees. I don't want to say what's true or that people, there's this huge group of people that are just going out and just suing businesses, for no reason. I think one of the biggest challenges that we see with restaurants in New York is not that their employees are just going there just to sue them, but the labor laws are so complex, it is very easy to run afoul of various labor laws, and the result is enormous amount of liability. And I would strongly disagree with the suggestion made earlier about something like the 80-20 rule, where it's like, oh, just comply. I mean, when you get down to it, and we can speak more about it, it is very complex, it is very problematic and easy to be in violation of it, and it also hurts employees. It ends up in employees getting fewer hours, gaining less experience, and a whole list of other challenges. So I guess my point is less about just someone going in saying, I'm going to work at a restaurant for 2 days and sue them, but it's very easy for there to be large claims due to what I would characterize as not gross violations of malintent and wage theft and exploitation, but more a result of restaurants in a complicated work environment trying to comply with very complex laws. That's tough. And I would just say, related to this on the due process thing, I just want to make a mention of this, and I know it's sometimes tough in these larger discussions, but the court case that was referenced back in the 70s concerning due process, I have a Supreme Court ruling here from 1991 showing that liens do get due process despite their temporary nature. It says temporary or partial impairments to property rights entitled by attachments, liens, and similar encumbrances are sufficient to merit due process protection, even though they do not amount to complete physical or permanent deprivation of real property. So, I just wanted to point that out, but yes.
Do you think that workers who allege that they're victims of wage theft go direct, find, and they generally don't have a lot of money, try to find a pro bono attorney, head straight to court, and get a lien without actually attempting to speak to the manager, the owner, and attempt to get what is owed to them?
I would presume a little bit of everything happens. In certain cases, if someone feels that they have been paid improperly, they may go and the employer may make up the difference. They may dispute it. There may be other cases where an employee does not feel empowered or feels threatened, so they do not bring it up. I don't want to make any suggestions or use my opinion to say what is in the minds of employees when they are going to file a suit, or in this case would go to get a lien. I'm just really trying to focus on the specific substance of this proposed legislation. I'm not denying the problem that is wage theft, that is exploitation, and I think that's what frankly puts kind of an employer representative in a difficult position. I'm not saying you're putting me in a difficult position, but I'm not here to defend wage theft. There are legitimate concerns with the specific provisions of the bill. And I don't want to speak on what an employee thinks or doesn't. I'm sorry, respectfully. I just don't think it's my role or position.
Okay,
to do
well,
so.
well, I'm just trying to illustrate that it is a bold and probably the last step that an employee would take going through court, because it's not easy, as you heard from Mr. Blum. He doesn't have like hundreds of attorneys working on this, and they spend a lot of hours working on these cases. At times, people get private attorneys, but that's not the first attorney.
No, but there are. I don't know the number. But I presume, I don't know how many are filed every year, but there are a lot of cases that are. And what would also be helpful, I would be happy to chat offline. I know we were talking about the amount in dollars of wage theft, but do we know? Because this obviously bill is trying to address a very specific situation of employers fraudulently transferring their assets. What percentage of
Well,
these?
it's addressing wage theft. And one of the ways that we believe that we can get to fewer cases of wage theft is by putting something that maybe might be perceived as onerous by employers, but often we pass laws to prevent bad things from happening, and the disincentive to steal wages or not pay properly maybe met by, oh, I might get a lien put on.
Yeah, I mean, maybe an idea is, and I'm, again, kind of thinking out loud, but, I don't know what the percentage of these judgments are that are not being collected because the assets are being, fraudulently transferred, and is there any way within the laws of, fraudulently transferring assets, could those laws be amended or addressed in a way to be more aggressive to better help collect? I don't know. I'm just trying to think outside of the box to address the issue at hand.
I mean,
but
we can talk more outside of this hearing. It just, there's a power imbalance. The worker works and expects to get paid. That is why they resort to going to court. A lien doesn't mean you have to close your business. You continue operating.
Well, not necessarily if you can't get, a loan or, I mean, there's a lot of
But it's
lot of
not something the
implications.
worker should bear the brunt of. And that's right. That's right. So, of course, we all think every governmental agency should be better funded. That way there could be enforcement of all the good laws we pass. But it's not true, and it's been true for years that Department of Labor has been underfunded to keep up with the amount of wage theft that's out there. So this, we believe, is a good answer. And as I said earlier, if an employer is doing the right thing, and most are, then they don't have anything to fear from this legislation. Thank you. I'm good. Oh, Mr. Blum. We've worked together a long, long time. Maybe you could expand on how the idea that people go into restaurants or other businesses with the intent to file a lawsuit alleging wage theft when that didn't actually happen.
Well, I've never seen that ever. But I also should say we should take a step back and look at the context here of these, particularly these low-wage industries. These are workers who are accepting and working under really bad conditions because they have very few options. And speaking up against an employer who may very well retaliate against them is a very scary option. Even doing it after they've been fired in retaliation or they quit in disgust, it's still very scary. There are language issues here. There are knowledge of the law. There are big, differences in power. So for people to come forward requires an awful lot of courage and is not a light or simple thing for them to do. And so when it happens, it's usually because there's a pretty bad situation. Now, what I think I've heard from Mr. Rigi is a complaint about the substance of the law. And, we can have our own debate about the 80-20 rule or whatever, but our point is we're not changing the law. The law is the law. It should just be enforced. And you should not have a situation where someone's entitled to money and can't get it. So even if the employer didn't have terrible motivations, but they still wound up with an awful lot of money that belongs to the worker under the existing law, then the worker should get that money. And probably in those cases, if there is goodwill on both sides, it will get resolved relatively quickly. And good chance there won't even be a request for a lien. But if there is, it'll still be resolved quickly. So it's really, if someone has a beef with what the law is, that's one thing, but our position is that the law should be enforced. The other thing I'll just say about the due process issue is the issue is not whether due process applies here. The issue the Court of Appeals addresses whether a prejudgment lien violates due process, and the answer was no. With the various protections, actually we have more protections than the mechanics lien that they were addressing had or has. So with those protections, due process is not violated. That's the legal point. The other thing I'll just say is that, two things. One, on the Department of Labor, it would greatly enhance their efficiency and their use of resources if they had the access to the lien. They would have, under this bill, they would be able to use the lien. The AG's office would be able to use the lien. And they would have much more efficient use of their resources if they could bring folks to the table quicker and not have to settle for pennies on the dollar. I always say by the way, I'm here representing the Legal Aid Society, but I also have been told I can speak on behalf of the United Auto Workers Region 9A, which I'm a member of, a longtime member of. When I speak to auto workers, my union siblings, about this issue, I say, if someone stole your car, sold it, and offered you half back, you would not consider that a good deal. And that's what happens at the DOL, because they're so afraid of just not being able to collect on judgments that they settle for much less. I have gone to court to sue employers where there was a settlement with the DOL that was grossly inadequate, and I've gotten much more money. And in those cases, they say we don't have money, and somehow it is produced. That was the opening bid in one of my cases, where they came into the DOL settlement conference and said, we don't have money, we can only pay this much. So I sued them, and suddenly they had the money and they paid it. So the DOL does, I actually, I don't fault them for this, that they settle for what they can get to get the money into the pockets of the workers, but with the lien, they would have much more ability to do that, and they could use their resources in a much more expansive and targeted way.
Okay, thank you. Okay, done, thank you.
All right, well, thank you. That brings us to our 30-minute break. Please do stretch, maybe go outside, get a little sunlight, grab a bite, hopefully from a small business and not a chain. Enjoy. And we will be... all right, we are up to panel C. And so, we are now joined by Natalia Varela, supervising attorney from Make the Road New York. And we'd also like to be joined by Joanne Lum, director of the National Mobilization Against Sweatshops. Also, Christopher Marlborough from the Marlborough Law Firm. Caletso Tebogo, class representative in the Doria wage theft lawsuit. I hope I pronounced that correctly. And William Medina from the Worker Justice Project. Seems like we're missing a few folks. Well, yes, you are, Reverend Cook, who I've never seen in a tie before. Welcome. Come on up. I'm sorry, I don't know how I skipped your name. But yes, it's Natalia, Joanne, Reverend Cook. Christopher? You're not Christopher.
My name is Marcus. I'm speaking for Christopher.
Okay.
Your office allowed me, I'll be speaking later today, but your office allowed me to condense as long as they keep it under 10 minutes.
That's the rule. Marcus, what's your last name?
Montero. Montei.
Montero.
Yeah.
Very good. Okay, we are waiting for William Medina from the Worker Justice Project. And Caletso Tebogo. So, Reverend Cook, I'm so sorry, but you're going to want to sit over here.
Oh, I'm sorry. I'll swap.
That's okay. No, you're fine, because we're going to... The two folks that we're still missing are actually on the end.
Oh, I see.
So, perhaps that means that we can begin, and hopefully they make it back on their way up. We are all friends here. I don't know about outside, but we are all friends here. Well, before we begin, let me tell you. All right, so we're going to begin with panel C. We will be breaking again for the 10-minute stretch after panel E. Okay? Leaves everybody something to look forward to. Okay. Well, and then I lost the assemblywoman. I wonder where she is.
I think we just start.
Yeah, let me just shoot her a text. Okay. All right, well, let's begin with you, Natalia. 10 minutes on the clock.
Okay.
Make them count.
I'm going to try. Good afternoon. Make the Road New York is pleased to submit this testimony to the New York State Senate Standing Committees on Labor and Senate Standing Committee on the Judiciary on the subject of the critical need to ensure adequate resources to address the endemic wage theft in New York throughout low-paid industries and its devastating effects on working class and immigrant communities. We're a not-for-profit, community-based membership organization with over 25,000 low-income members dedicated to building the power of immigrant and working-class communities to achieve dignity and justice. We have 5 community centers across New York State, in Queens, Brooklyn, Staten Island, Brentwood, New York, and White Plains. We provide legal team support for workers' rights and service over hundreds of people within a year, as well as provide community rights education to thousands. This critical work is supported in part by a mix of state and local funding, including the New York State Office of Court Administration and the IOLA programs. Thanks to this crucial funding, Make the Road New York and other legal services and community-based organizations have helped workers recover millions of dollars in stolen wages from their employers, fight sexual harassment and other forms of discrimination, protect their right to paid leave, and safeguard their rights to protest violations free of retaliation. Limited resources for workers' rights enforcement and outreach means that we can reach only a fraction of the workers who need help. We need more funding for employment legal services for and outreach to low-paid immigrant workers and to government labor agencies who carry out these investigations. I would like to cover several points. The first is the rampant workplace violations that plague New York's immigrant workforce, the inadequacy of the current standards enforcement scheme at protecting low-paid and immigrant workers, the need for state to fund civil legal services, the importance to increase funding for New York State Department of Labor Standards Enforcement and Worker Protection, the need for New York State to adequately collect, maintain, and analyze data regarding stolen wages and collection. New York State should pass the Empire Worker Protection Act, as well as the Securing Wages Earned Against Theft. So I would like to proceed by just saying that, as we all know here, I hope that wage theft is rampant throughout the state's economy, in construction, restaurants, warehouses, delivery, cleaning, domestic work, factories, where despite strong laws on the books, enforcement has simply not been robust enough to ensure that workers are getting the benefit of higher wage and benefit standards that the city and state have passed in recent years. Effective enforcement of basic workplace protections requires that the state commit to consistent resources for legal services and for outreach to immigrant workers so that they can enforce their rights. Every year, an estimated 2.1 million New Yorkers are victims of wage theft, robbed of $3.2 billion in wages and benefits they are owed. In New York City alone, low-road employers steal nearly $1 billion per year from low-paid workers, including by paying workers less than the minimum wage, violating prevailing wage requirements, failing to pay non-exempt employees time and a half hours for overtime, stealing tips, requiring off-the-clock work before and or after worker shift without pay, making illegal deductions from pay, among others. Even seemingly small violations quickly add up and amount to thousands of dollars stolen from workers' pockets. Employers evade compliance by threatening and retaliating against workers who come forward to enforce their rights, falsifying their business records, knowingly misclassifying employees as independent contractors, and forcing their workers to sign arbitration agreements to keep claims against them out of the court. Immigrant workers are even more vulnerable to workplace violations and face much higher barriers to enforcing their rights. To give just one example of these difficulties that our clients face, Make the Road New York represented 12 restaurant workers who worked as waiters, bussers, and kitchen staff at an upscale Italian restaurant in Staten Island, and suffered egregious wage theft, among other abuse. Many of the waiters were not paid any wages at all for several years and only earned the tips left by customers. Later, they were paid just $25 for the whole lunch shift and $50 for the dinner shift. Despite regularly working up to 14 hours a day, 78 hours a week, the workers never received any overtime pay. Indeed, this case came to us from the New York State Department of Labor after one of our clients filed a complaint for retaliation with the New York State DOL. In 2018, the DOL began investigating. They were concerned about the well-being of the workers and connected them with us. We took the case and began with a few workers. The boss continued to harass the workers and threaten them about cooperating with the DOL investigation. Initially, the DOL flagged the case for the criminal investigation by the Richmond County DA. The DA's office met and interviewed several of our clients. One of our clients were scheduled to appear in front of the judge with the DA's office in March 2020 to secure a search warrant for the restaurant's records. But the appearance was canceled when COVID hit and the DA's office and courts closed. By the time they reopened, Our clients had left their jobs at the restaurant, and the DA was unable to secure new corroborating witnesses. At the end of 2020, we filed a lawsuit in federal court against the restaurant and its owners to recover the unpaid wages, and 12 workers joined the case. After suffering numerous delays to COVID and protracted discovery disputes, when the restaurant failed to produce accurate records, the restaurant filed for bankruptcy in June 2022, yet again delaying our clients' recovery for their earned wages. Finally, after participating in a bankruptcy court-ordered mediation in August 2022, our clients reached a settlement. The clients received their first settlement checks representing only part of the wages they were legally entitled to in May 2023. Nearly 5 years after our brave client went to the DOL to report that he had been fired for asking to receive his lawfully earned wages. A landmark national survey of approximately 4,400 low-wage workers across cities in the United States found that undocumented workers are far more likely to experience wage and hour violations than U.S.-born workers and workers with authorization. 37% of undocumented workers were not paid the minimum wage in the work week preceding the survey, compared to 21% of documented workers and 16% of U.S.-born workers. Broken Laws also reported that those workers who complained about a workplace issue or attempted to form a union in the previous 12 months, 47% experienced employer threats to fire workers or call immigration authorities. And the vast majority of workers who experience wage theft do not file a claim to recover stolen wages. COVID-19 has only impacted these issues. The pandemic has also complicated Make the Road New York's efforts to seek redress for wage and hour and other violations. We have dozens of clients whose employers suddenly shut down their business, owing their employees days or weeks' worth of wages. Many said they could not pay because of financial difficulties or simply disappeared and stopped responding to calls. Many workers were desperate to keep whatever jobs they could get during the pandemic. Employers in several of our cases have declared bankruptcy, seeking to discharge their debts to workers, which generally take less priority than debts to commercial lenders and other for-profit entities, and the process can take years to recover. The impact, we all know, goes far beyond the directly impacted worker and extracts billions of dollars from workers, households, and our state's economy. Employers who evade enforcement are also emboldened to cheat other workers in the future, fueling pervasive abuse. The current public enforcement scheme is simply insufficient. The DOL does not have enough resources to promptly investigate the complaints that come into the agency, let alone enforce state employment laws in workplaces where workers are too scared to report violations. The pandemic has only also impacted this. Courts closing, DOL backlogs delayed cases by months to years. In the past several years, New York has taken the lead in worker protections, including to the minimum wage, paid leave, and protections against gender-based pay discrimination. Constraints on enforcement, however, have blocked many working families from experiencing the real benefits of their policy. Through our work, we see that employers bet on the state having inadequate enforcement capacity. They steal wages from their workers and allow toxic workplaces to fester with the expectation that it's unlikely they will be caught. Our labor laws are rendered meaningless when workers do not have a reasonable expectation that employers who violate the law will be held accountable. Nor can private enforcement address the scope of violations. Private attorneys are reluctant to represent workers whose claims are not worth enough to cover the costs that they will incur in bringing the case. Many low-wage workers cannot find a firm to help them and face long waits when they attempt to file complaints at the government agency. Make the Road and other community worker centers and legal services organizations fill the gap in services for low-wage immigrant workers. While New York City has devoted some resources to the program, such as the Low-Wage Worker Initiative, they do not meet the need. Each year, we help hundreds of low-wage workers, the overwhelming majority Black, Latinx, Asian, and immigrant communities, who are blocked from access to justice. We urge the state to meet the needs of low-wage immigrant workers and fund legal services and outreach. To meet the needs of low-wage workers and increase services, our organization hired new attorneys and legal staff and took on cases that will last well past this fiscal year. Without ongoing robust and sustainable funding, our organization's ability to continue effectively addressing the employment-related legal needs of the state's low-wage workers and retain hire new staff for crucial work is in jeopardy. Sustained dedicated state funding for low-wage essential workers in need of employment-related civil legal services is critical. Without strong enforcement, these laws on the books are not real for workers. The New York State DOL has the power to seek stolen wages and benefits for up to 6 years, but because of the limited resource, only starts at 3. Recently, the state expanded New York Labor Law 215, anti-retaliation provision. However, these new protections will be vitiated of their power if they cannot be enforced. The DOL requires more funding in New York State to adequately be upheld, and workers in our economy need their wages, and they need to be protected from employers who viciously retaliate. The data on the amount of wages stolen out of the worker's pocket is woefully underreported by the state. The massive number that I've cited earlier of $3.2 billion on the account of 2.1 million New Yorkers, that number's from 2015. In the New York State minimum wage increased from as low as $9.70 per hour in 2015 to $15 per hour. It's safe to assume that the amount of stolen wages has risen considerably, and we need actual data. We need to know the amount of money that is being siphoned from our economy and from our hardworking New Yorkers' pockets into the exclusive hands of their employers in order to best address the harm. We need data to more accurately demonstrate the many ways that employers evade payments of wages even after an order has been issued against them. The life of a worker's case often takes years, and all too often without a resolution that includes putting money back in the worker's pocket. Not only do they await agency and court processes, but like our Staten Island case described above, they also have to await the bankruptcy process and ultimately have to file liens when such a remedy is available. New York State should pass the Empire Worker Protection Act. The Empire Worker Protection Act, A1893 S541, which expands the capacity of the state in order to remedy wage theft, equal pay violations, and other employee exploitation undermining New York labor policies. Accomplishments. The Empire Worker Protection Act creates a public enforcement action similar to the long-established QI-TAM action, allowing affected workers and labor unions to step into the shoes of the state and following a notification process to the state, sue to enforce state labor law. The action, when victorious, allows for recovery of the penalties that the Commissioner of Labor could recover, most of which return to the state coffers to enable further public worker protection enforcement, and a portion of which is awarded to the workers who brought the action. The Empire Act will expand resources available for public enforcement and meet the needs of workers suffering from the New York labor law enforcement crisis. New York should also pass the Securing Wages Earned Against Theft Act. Make the Road supports the Securing Wages Earned Against Theft bill, which will help workers collect stolen wages. Wage theft is rampant in New York, but exploitive employers too often hide or transfer their assets to avoid paying wages they have stolen from their employees. Even when workers win a court-awarded judgment, they are unlikely to collect the money owed to them. The SWEP bill will update New York law, joining other states which provide workers with legal tools to ensure that their employers will pay them once they are awarded a judgment. We thank you for the opportunity to present this testimony and look forward to working with the Senate to protect workers' rights. Thanks.
Ms. Lum? You might want to you can bring it closer to you.
Hi, my name is Joanne Lum, and I'm an organizer with the National Mobilization Against Sweatshops, a worker center based in New York City. Thank you, Senator Ramos and Assemblymember Rosenthal, for sponsoring the sweat bill and being our advocates out there on it. We look forward to making it happen. To explain who NMAS is, we're a worker center composed of members of all types, all backgrounds, all races, and who work in all kinds of industries. So restaurant, nail salon, construction, day labor, stores. And one thing that many of them share in common is that they've experienced wage theft. And in my 27 years at NMAS, I have seen that wage theft has become increasingly common. And so much, and for immigrants, for citizen workers, it's become so common a problem that many workers don't even know that wage theft is illegal. Young people think that it's just how you can keep your job. Immigrant workers think a lot of times that minimum wage doesn't apply to them or that it's optional for their employers. That's how bad it's gotten. No one really takes it seriously as a crime, except for you and us here. Even though wage theft in this country amounts to more than all the other types of theft combined. And so we hear all the estimates of $1 billion per year, $3 billion per year of New York wages stolen from New Yorkers every year. In the last 9 months, for example, with 3 of our worker centers filing claims at the Department of Labor on behalf of home care workers, with just 500 claims in the last 9 months, we've gotten calculations of $65 million. And this is just one industry, just, you know, a few of us doing these claims. So it's just the tip of the iceberg. The wage theft, it's staggering, the number of, the amount of money that's stolen. And the statistics might be staggering, but the human cost of wage theft is immeasurable. We heard a little bit earlier, but we've seen so many workers sink deeper into poverty. They've had to work 2 or 3 jobs. They've become homeless. Their children need to help out and work. And the government ends up subsidizing these law-breaking bosses by spending more on benefits and programs like food stamps, housing assistance. Because wage theft is so pervasive, the labor laws become meaningless for a lot of people. Not because it's a bad law, but because it can't be enforced. It's not enforceable. So how can a law be enforced when scofflaw employers can take advantage of the time it takes for a decision or a judgment to come down on a wage claim, to shut down their business, reopen under a new name, hide their assets? And when workers can't collect on a wage theft claim, then of course greedy bosses will keep doing it because they can get away with it. Word has gotten around that you can't collect. So for instance, one of our members filed a wage claim at the State Department of Labor, and 5 years later when the DOL issued a wage order, it said it couldn't collect. The employer had shut his produce store and was not responding. The DOL had to get help from the AG's office. One senior DOL administrator that I met with told us in confidence several years ago that, you know, we could use help with collection. In other cases, nail salon workers that we worked with who had a wage claim against their employer, who had owned 3 houses, but then when it was time to pay up, suddenly the employer had foreclosed and the bank statements showed hardly any money. Countless workers have seen their bosses shut down their restaurants only to open up again around the corner, or even in the same location with a different name, different owners, but the same menu, some of the same workers. Hearing about cases like these is why many workers say they wouldn't bother going after their stolen wages. They've heard from others that it's a waste of time. Unless we make sweat law, all the efforts to raise the minimum wage will not help workers much, as Senator Ramos acknowledged earlier, right? In fact, it'll mean more wage theft. So if workers aren't paid for all the hours worked, instead of being robbed, you know, $15 an hour, they'll be robbed $21 an hour. So why would we expect scofflaw employers to pay the new minimum wage when they're not paying the current minimum wage? Wage theft has got to stop now. We urge our elected officials, don't be misled by organizations like the Hospitality Alliance that seem to want to protect the interests of sweatshop employers. They keep on talking about the need for notice. Well, here's notice. There's minimum wage law, overtime law. And if it's very complicated, there are a lot of agencies who are here today and organizations that can help them understand the law. But by blocking sweat, the Hospitality Alliance is hurting not just working people, but all the honest businesses that are trying to comply with the law. We call on you to do the right thing and pass sweat today. Workers are working hard, should be paid correctly. Thank you.
Thank you, Senator Ramos and Assemblywoman Rose. Rosenthal for this opportunity to speak before this committee about steps that our lawmakers in New York can take to stop employers from stealing the wages of their workers. This thievery is a pernicious social sin against God and one another. As it says in Deuteronomy chapter 24, 14 to 15, quote, "You shall not exploit a poor and needy hired servant, whether one of your own kindred or one of the resident aliens who live in your land within your gates. On each day you shall pay the servant's wages before the sun goes down, since the servant is poor and is counting on them. Otherwise the servant will cry to the Lord against you, and you will be held guilty." The sin of stealing from the poor, our own kin, or resident aliens, we call them immigrants now, not aliens, is behavior that is damaging to the soul and economic livelihood of workers who enter into employment relationships in good faith. They rightfully expect that if they do their job and work hard, that they will be paid what the employer agreed to pay them. For those of us who run not-for-profits, who employ people, we make every effort to be clear with our employees about what is expected and the compensation they will receive for their labor. This is why, since 1893, the New York State Council of Churches has joined our Roman Catholic brethren to shape laws which promote workers' rights. Pope Benedict, not known as the most progressive pope, nonetheless stood on principle by saying in his charity encyclical, quoting Vatican II, "The Church in the Modern World, Gaudium et Spes," quote, "I would like to remind everyone, especially governments, engaged in boosting the world's economic and social assets, that the primary capital to be safeguarded and valued is man, the human person in his or her integrity. Man and woman are the source, the focus, and the aim of all economic and social life. The faith community is broken like everyone else, and there are poor practices and abuses to be found in institutions which proclaim the virtues of which Pope Benedict spoke. But as a faith-based employer, which I am, I know that if we have any hope of surviving spiritually and financially, how we treat our workers is everything. We also do business with groups who treat their workers ethically, and we don't do business with those who do not. And as the church, we offer our praise to the vast majority of employers in all sectors of our economy who make good on formal and informal contracts with their workers. Conversely, as a matter of principle, the Council of Churches, which represents 7,500 congregations in every part of this state, will critique and change laws and practices which facilitate theft and unethical behavior. The Sweat Bill was close to becoming law in 2019 by the legislature. Unfortunately, it was, as was noted before, vetoed by Governor Cuomo based on assumptions that were incorrect. Since that time, wage theft has not abated but gotten progressively worse. We note the gross fact that employers in this state steal at least $1 billion a year from their workers, which was an estimate last proffered in 2014. one could safely assume that that number is considerably higher now. The pandemic made it hard to work, but, sorry, I lost my spot. I apologize. The pandemic made it, okay, almost got it. Yes. The pandemic made it hard to work. But many brave workers, out of necessity, put their lives at risk to work only to have their wages stolen. Our government did not stop this theft. In our present situation, where we welcome migrant people to our state, we have people across the partisan divide who complain about the cost of welcoming them. In response, we have lawmakers, the mayor of New York City, the governor, legal aid, the federal government, all scrambling to ease some of the cost of helping migrants by helping them to secure work, a work permit. Letting people work is, of course, a humane and altruistic position, but this is also about practical public economics. As a state, we are spending a lot of money on services, on people who would like to be less reliant on public shelters and have their own agency. They would prefer to work instead, and yet it is cruel and duplicitous to tell people we want them to work only to refuse to change laws that incentivize that work and facilitate independence. Frankly, employers who steal are asking the public to not only tolerate their theft from workers, but actually subsidize their stealing, because employers, in not pulling their weight, are in effect tasking the government to pick up the tab for their negligence. Moreover, as our safety net gets more strained, matters get even worse because we receive less revenue to pay for those services because people are not paying taxes on their lost wages. So it's bad economics. Instead of our government rewarding unethical employers while punishing employers who do the right thing, while seeing a corresponding increase in social spending combined with a decrease in tax revenue, we owe to the residents of New York to break this unvirtuous cycle. We need employers to carry the load that is properly theirs. The sweat bill allows a worker to place a lien on an employer's assets if they steal, so the worker has some assurance that they will be paid the wages owed to them should their claim be successful. This lien is not done precipitously, but with due process and a set of documentation that is presented to the clerk. It is not something that's just done willy-nilly, as the Hospitality Network seemed to suggest earlier today. This mechanism would, of course, be unnecessary if all employers had a moral compass, but alas, we are human and live in a fallen world, which makes laws like SWEAT necessary. In closing, I would just say a word about process. We almost got the SWEAT bill passed last year, but it never made it to the floor on the last day of session. I really am hoping that for this legislature that the same thing does not happen, and that if there are any matters that need to get reconciled or amendments that need to get addressed, that be done as openly and transparently as possible, that it not get tangled up in some committee, and that we get a clean vote on this bill in this session. Workers have suffered too long and have run out of patience with political promises being made which were subsequently broken by a state legislative process which sometimes can lack transparency and public debate. So we call on you as our legislators to lead the way and get SWET passed this session and onto the governor's desk. Thank you.
Thank you. Mr. Montero?
Thank you. Thank you, Senator Ramos. Thank you, Assemblywoman Rosenthal, for holding these hearings. I'm here to support the SWET bill. I'm a private practitioner who civilly prosecutes wage theft claims, primarily in Nassau County, Suffolk County, and Kings County. I'm here in two capacities. One is in my own, and in my own practice with my own statement. I'm also going to begin with a colleague of mine, Chris Marlborough, who is scheduled to be here to proffer his own testimony, but he couldn't, understanding that he had a last-minute bout of COVID. So I'm here in his stead, and then I'll proceed with my own remarks. Chris wanted to talk about a case of his. His client, Kel Tobago, was here earlier. He had to leave because he had to go to work, of all things, right? So Kel's employer operated a chain of discount stores in the Bronx and Queens. He and his coworkers were required to work 11 hours a day, 6 days a week for less than minimum wage with no overtime premium. When Kel started the job, his employer paid him $180 for working 66-hour work weeks. After many years on the job, Kel was still being paid less than minimum wage. Even the store managers were paid less than minimum wage. In 2013, the Department of Labor investigated his employer, but when the investigators arrived at the work site, most of the workers were required to hide or work in another location for the day, so that was a skeleton crew, if they wanted to keep their jobs. Other workers were told to falsely claim that they were relatives of the employers in order to evade the DOL investigation. Kel was ultimately interviewed by the DOL, which found that the employer had stolen wages from him. Kel was awarded money by the DOL, but his employer told him that he would be terminated if he cashed a check. In my own practice, that's happened to me as well. If you cash a check, you're out of a job, and the employers are keeping score. Kel's employers fired several of his co-workers because of the DOL investigation, but Kel never cashed his check, so he kept his job. In 2014, Kel's employers learned that several workers were planning to file a lawsuit. The employers responded by terminating more workers and filing a false police report against one of them, claiming he stolen a bag of cash from the business. When this worker dared to show up for court appearances, Kel's employer tried to have him arrested on the steps of the courthouse. After that lawsuit was filed, Kel and many workers were afraid to participate because of their brutal employer. The employers responded with more than 100 acts of retaliation. They hired folks to intimidate workers and their families. They filed false police reports against a particular worker claiming assault with a deadly weapon. They interrogated other employees. They terminated other employees. They physically threatened other employees. And the old standby, they always threaten, and this is true in my practice as well. There's been much testimony about how wage theft laws disproportionately affects the Hispanic Latino community. There's always an issue regarding immigration status. We're going to get you deported on and on and on. These are common threats seen in many of these cases. Anytime a worker attended a court appearance, they would immediately be suspended from that work, and certain defendants coerce workers into signing false documents, indicating that they are withdrawing without pressure or obligations from the lawsuit. Again, that's happened to me too. I'll get something in the mail saying, hey, Mr. Montero, I don't want to sue anymore. It'll be written in English, despite the fact that my client doesn't speak English. It'll be in perfect grammar, and then I'll have my client's handwritten signature, which oftentimes clearly indicates that he didn't write the document. This happens more than it should. When Kel saw the retaliation against his coworkers, he had enough. He joined the lawsuit and became a key participant in the case. My colleague Chris obtained a preliminary injunction against further acts of retaliation, but that didn't help because the retaliation continued. Kel was fired a few months later, but he continued to fight. Now, this is why the SWET bill is important. The defendants did everything and anything to hide their assets. These defendants had $1 million in assets. Despite more than 100 acts of retaliation, there was still an insufficient legal basis for securing assets in the course of the litigation. There was no venue to stop them. So the employer used many dirty tricks. They formed more than 50 corporations to operate their 13 stores. They transfer corporate assets into the name of their relatives. They cried poverty to the DOL when they were caught stealing wages, and in all subsequent settlement talks, something that we've heard about earlier. However, this is far too common. When workers stand up against wage theft and their employers retaliate against them, they're discouraged from trying to recover their stolen wages. The employers drag out litigation for years and oftentimes settle for pennies on a dollar. Oftentimes, this story ends with one of two results: an empty judgment that you can't collect, or if the worker is lucky, pennies on a dollar. Kel's story is different. What happened with Kel is one of his employers passed away during the pendency of the lawsuit. Chris's investigation revealed that he left millions of dollars in an estate, which we found in a surrogate's court. Chris filed a claim against the estate to recover the lost wages and demanded an accounting, and only to discover that that estate was undervalued by $15 million. All right,
Holy moly.
well, probably would have never been found. He asked the surrogate's court to require the estate to post an $11 million bond to preserve the assets of the estate and prohibit the transfer of any real property while the wage theft case was ongoing. This made all the difference in the world, because now, in real concrete terms, these defendants were forced to come to the table in light of this lien against its prohibition of the movature of assets. Well, that case settled for $11 million. Okay? A few days before trial was scheduled to begin, Kel himself and a bunch of his workers received over $100,000. Had he not been able to secure the assets in the estate proceeding by happenstance that one of the employers died, the typical case would have been pennies on a dollar, come and get the money, which is really hard to do in these cases, as a bunch of folks testified earlier today. Kel firmly believes that he would not have been able to receive relief for the class if they had obtained a judgment at trial. There was simply no one to collect the judgment against, and the money would have been long gone, probably likely before trial even started. As I said earlier, 50 corporations, it's tough to untangle that web. So Chris and Kel urge the passage of this SWEP bill. I'm going to talk about something that's very related, because it's something that I deal with on the ground in my practice all the time. I always tell the members of my committee that the best ability a plaintiff's workers' rights attorney has is not liability. New York State legislature passed strong bills, powerful bills, 6-year statute of limitations, 196, Article 6, 142, 146. These are strong bills. It's not liability that's important. It's not the best ability. It's collectability, because it all comes down to collectability. So that's the ability that drives a lawsuit. So when I meet with defendants and they're unabashed at mediation, I am told, come and get the money. Who cares about your judgment? And then the mediator will sort of smooth that out and say, there's a collectability problem. Because there's always a collectability problem. That's what these cases come down to. Doesn't matter what you owe, you have to have an avenue to retrieve it. And without an avenue to retrieve it, the collectability, the most prominent component of a wage theft claim, is not there, and that depresses any settlement, if at all, and otherwise you're ended up with an empty judgment. Two quick provisions I do want to address. Sometimes defendants or certain folks will say, well, the passage of this SWEP bill is unnecessary because of provision, New York's Business Corporation Law, the BCL, and New York's limited liability. In a nutshell, those laws provide that the 10 largest shareholders of either the corporation or the LLC are liable for wage claims. So there's already protections, because these people are already liable. They're not. The bottom line is that there's time limits that must be triggered in order to hold them liable. One of them is that you have to file your notice that you're going to hold these folks liable 180 days after termination. That's hard, because the statute of limitations runs 6 years. So if you're terminated and you realize you have rights a year later or 7 months later, well, then you can't hold those folks liable. So it doesn't really work. Two, you don't know who the LLC members are. These are privately held corporations that are not publicly published. You have no idea who they are. So
Different bill.
Right. And so then it doesn't work. So we hear time and time again, well, folks are already held liable. They're not. And then you have to, and then you only have 90 days for the execution of unsatisfied LLC and a BCL a notice before you can then initiate a case. If you initiated a case after the 90-day period, after the judgment is returned unexecuted, well, then you can't trigger those two provisions of the LLC law and the BCL law. So, you know, I was exiting Madison Square Garden, and the guy was giving out flashlights, right? Free flashlights. You know, it was a big crowd. I was like, what's this about? Well, the flashlights were free, but the batteries were $10. And they were inside the flashlight, right? So you couldn't buy the flashlight. You know, you had to buy the batteries. That's what these BCL and LLC provisions remind me of. It's a whole lot of nothing that you can't really trigger. You can't have one without the other. And that sort of plugs back into the sweat bill. If you don't have the collectability, it's like purchasing, you know, having someone offer you a free flashlight, but you got to pay $10 for the battery. Well, it doesn't work, and he's not going to give it to you. So you kind of need both in order to effectuate these outcomes, and the outcome is recovery of stolen wages. Thank you.
Thank you. Mr. Medina.
Thank you, Chairwoman Jessica Ramos, for the opportunity to testify on behalf of the Worker Justice Project and Los Deliberistas Unidos. My name is William Medina. I'm a Deliberista from Astoria, Queens, member of the Worker Justice Project and leader of Los Deliberistas Unidos. Wage theft is a crisis that mostly impacts immigrants, low-wage workers, and community of colors. I and many of my colleagues have experienced wage theft in our workplaces. I personally have witnessed how multi-billion-dollar corporations are stealing the wages of workers and using fear as a weapon to silence us. Enough is enough. The system has failed to protect us, and we are left to rely on community organizations like Worker Justice Project to fight wage theft, mostly using our collective power to recover our wages. In the past 4 months, Los Deliberistas Unidos have helped deliberistas recover more 50,000 in stolen wages from DoorDash, the biggest app delivery corporation in the country. Every day, I hear stories of wage theft in many industries like construction, restaurants, and home cleaning. Every day, I witness the anger, the frustration, and depression of colleagues who have experienced wage theft. We take many risks with the hope to earn some money, to buy food, purchase a Metro card, or simply be able to pay our rent. For essential workers like me, a day of work is worth everything. It means being able to survive and provide for our families. At this moment, Los Deliberistas Unidos are also fighting wage theft, which happens in many forms. The city of New York is allowing the corporation to steal our pay by not enacting the minimum pay law. We were supposed to have a pay for our labor. Instead, we are forced to depend on tips as a form of wage, and sometimes even our tips are stolen. Wage theft is an act of violence that affects our emotional health and impacts the safety of our families. Not being paid means not being able to care for our families and not having dignified housing. Sometimes, when we organize and fight, employers simply ignore our demands because they know the system is designed to protect them. We can no longer allow employers to feel entitled to steal our wages and harm the well-being of our families. We need to ensure there are consequences and that we hold them responsible for their actions. We cannot keep fighting alone. We need the government to have our back in fighting wage theft. We need your support urging New York City Mayor Adams to follow the law and have corporations pay us for our work. And we need to change the system to empower our communities and together ensure our labor is valued and protected. We look forward to working with you until there is no more wage theft in our community. Lo que quiero decir en nombre de los miles de trabajadores es que no solamente soy un líder comunitario, También soy una persona que entiende sus necesidades. Trabajo en las calles como deliberista y año tras año me he dado cuenta cómo estas compañías llevan sus cuentas bancarias con millones de dólares, resultado del trabajo de nosotros como trabajadores, los cuales estamos haciendo esta labor en climas extremos, arriesgando nuestras vidas a causa de los asesinatos y robos de nuestra herramienta de trabajo, y los cuales hasta la fecha no hemos recibido ninguna clase de pago mínimo, compensación o seguro de accidentes. Tenemos en este momento trabajando con esta compañía DoorDash, la cual siempre quiere sostener el pago de los trabajadores. Ellos no quieren pagar a los trabajadores, siempre quieren retener los pagos de ellos, y nosotros estamos con la organización trabajando de la mano para recuperar estos pagos retenidos. La gente en las calles sufre diferentes situaciones y nadie se preocupa por ellos. Por eso estoy aquí, porque quiero que las cosas cambien, y estoy seguro que trabajando juntos podemos hacer un cambio histórico en la ciudad de Nueva York. Thank you for listening and your time.
Thank you, Mr. Medina. Asambleísta Rosenthal, ¿empiezas tú?
Thank you, Senator. Unfortunately, I have to leave, but I will, trust me, I will read all your testimony. I'm very familiar with the plight of workers, but I think it's only getting worse. And as the senator and I were just saying, the stories continue to be moving to us and to our colleagues, but they keep getting worse. And it is past time that we pass this into law. We will do our best, and I thank the senator for holding such a comprehensive hearing with so many opportunities for people to give us their story, and everyone who's watching or will hear about this hearing. So thank you also for your steadfast commitment to passing the sweat bill. And once we do that, we'll do more. So we're looking forward to justice for workers. And thank you for sticking with us on this. Thank you.
It's wonderful. Well, thank you, Assemblywoman, and thank you for being here. I mean, the truth is, it doesn't get easier to hear these stories of wage theft and of rampant abuse of any New Yorker, documented or not, no matter what walk of life they come from. Ms. Lum, you've been a member, dare I say, a leader of the Sweat Coalition for a very long time, predating my time in the Senate. Can you, we've already discussed a little bit about the case that inspired the bill, but can you maybe speak to maybe a bird's eye view of why it's been so damn hard to cross the finish line over all these years?
I think people have alluded to this, but I think it's really become the business model. Wage theft has been incorporated into the way of doing business and making money for those employers who are particularly greedy. Because in a lot of the cases that we've had, the employers are able to open other businesses. So somehow, it's not just about making ends meet, but they're able to profit enough to lay groundwork for other businesses, which is fine, but not on the backs of the workers. And I think so there's very strong incentive among a lot of the business owners to keep this the way things are so they can continue doing this. But definitely I've seen that through the years, the more and more of these employers are learning the way of avoiding liability and responsibility. Because when we first, many years ago, when we were doing, wage theft existed and there were a lot of cases, but people could more easily collect. But it seems like the employers, the scufflaw employers spread the word, and everybody was learning how to get around the law, which is why sweat becomes more urgent.
All right. Well, thank you. Reverend Cook, it's very nice to have you here. You know, you represent the New York State Council of Churches, which are they only Christian churches, or do they?
It's 7,500 Protestants. Congregations.
I see.
But we work with other Christian groups like the Roman Catholics and Interfaith and people of no faith. So.
And I imagine that, you know, when people of faith meet for your meetings, you perhaps share stories of the strife that your congregants might be suffering across the state. Is there any one in particular that might come to mind for you to share with us? Sorry to put you on the spot.
That's okay. Yeah. I just know how many pastors have people who come to their office and they tell you, they say, I need a food card, I need help with my rent, I can't make my bills, I'm suffering from immigration issues, I feel overwhelmed. And sometimes pastors, when they have those encounters, they maybe try to just offer a little bit of assistance, but they don't always think about the larger systemic question. Why is this person in my office who is suffering in this way? So I can't give you exactly one example, but it's much more of an aggregate, you know, situation where in our congregations we have people who say are home care workers who, you know, they can barely come to church sometimes because they have to work these really long hours, and they experience you know, a lot of stress in their families, working these long hours and being undercompensated at the same time.
I think we can say that there is a pattern that is apparent among clergy of a systemic issue that needs to be addressed, so much so that you have become a steadfast advocate for the sweat bill.
We just said you can't solve this problem with charity and a few prayers and hand out a food card. You have to. The system matters.
God will not provide all the wages.
The system matters, you know, a lot, and the details matter. You know, I was really impressed with your testimony about ways in which people can wiggle around this, and
I've seen them all.
You know.
And if I may, just to buttress what we were talking about, you know, instead of complying with wage laws, what I'm seeing is creative ways to avoid the wage laws, right? So a dummy set of books, you know, fake time records, acknowledging pay that you didn't get, right? So a lot of folks get paid in cash, and you acknowledge $900 received, but you get $6, you know, and sign here, and they'll cover the sheets, right? You know, so instead of complying with laws, you know, just getting, from my experience, folks are getting, and employers are getting more creative in avoiding them. And to your point earlier, you know, it's just be getting more egregious, and it's baked into the pot. You know, the wage claims are baked in to the cost of doing business, where, you know, like you get it and, all right, it's a landscaper, we settle landscapers for this amount. You have a standard number for settling landscaper cases? That's incredible to me. How did you come up with that? Well, we've settled a few of them. You know, well, maybe you should stop cheating folks out of wages as opposed to having a standard, you know, wage claim against landscapers, you know, and firms have a specialty and they attack the folks, and your guys are going to be scared, and we're going to do depositions in courthouses now because they're terrified of going to courthouses. So it's just, you know, it's just this layer upon layer. Layer and layer. You know, there's a Clint Eastwood movie. I forgot what it's called, but Clint Eastwood is on a bus, and he's got to get this witness to the courthouse to testify against a dirty cop. And so he brings the witness, and all the officers line up the main road of the courthouse on both sides, waiting for the bus to come. And Clint Eastwood is on the bus, and he takes, a wood to the windows, and he knows that they're going to come after him, and he takes the school bus, and he's trying to get the witness to the courthouse, and the whole way, like, the cops are shooting at him from both sides, and he's driving, and the thing's getting shot up, and he makes the witness to the courthouse, and he testifies, and that's what I feel like bringing a wage case sometimes. It's like I take my case, I put him in the front seat, and I say, we got to go through these line of, folks firing shots at me, and I got to get to the courthouse.
Yeah.
And I'm just getting incoming from both sides, and we're ducking, and I'm hoping that my case doesn't get, killed before I get to the courthouse steps. And that's what these defendants do sometimes. They're like, well, we're going to throw this at you, we're going to throw this. And, and I'm savvy to it because, but the playbook is getting better, more sophisticated, as opposed to correcting the improper behavior.
Well, one possible shield, of course, would be the sweat bill.
Ah.
The other one is the LLC transparency bill, which is actually carried by my colleague, Senator Brad Hoylman Siegel, who was here earlier today. I'm wondering how much time and resources would that actually save you and your clients?
It's more of, and it would, to answer you directly, but if there's a threat of liability, they're going to, hopefully stop with the shenanigans, right? Because there's money there. Again, it's not liability. The defendants are like, we don't have records. Well, the law's pretty clear. So you can rely on a reasonable recollection of your plaintiffs in the absence and all this. And the law's pretty good in terms of establishing liability. But, again, it's all about, well, there's personal liability attached to it. So when you sit down to hopefully settle a case, there's a real threat now that, wow, I have a house, I have assets, I can't just make it up. And the sweat bill, helps in one realm of that in restricting the flow of assets so that you could avoid your obligations. But the BLC and the LLC law is another one because you're just trying to hold people to account.
Yeah.
You're just trying to hold people to account. And there was something I heard earlier, which in my practice is fundamentally false. There is not a huge frivolous lawsuit problem. There's not. Most of these claims are brought in federal court. There's heightened pleading requirements in federal court. You can't just make stuff up, right? So, the thought that there's going to be an avalanche or a wave of folks filing frivolous to extort money that is not rightfully, theirs is just not happening. From an attorney's perspective, you just can't do that. You'll get in a lot of trouble for doing that. I've never seen it, and the federal court's going to stop you cold.
Mm-hmm. So you and like many other attorneys who testified earlier represent the worker.
Yeah.
What are the attorneys who represent the employer like?
Oh gosh, they're mean and nasty. No, you know what? For the most part, it's a small community. It really is. It's a small community. So what normally happens is it's a big firm, right? And they come in, and it's a big firm charging a lot of money, and then the employer will say, by the way, I have no money, meanwhile, each of their 4 attorneys is getting paid $550, $600, sometimes $1,000 an hour. So in my practice, we're cordial because they see me all the time.
Sure.
And it's the same, and that's how it should be. You have some folks that you really got to press because they will hide records, and I never fault the attorneys. I always say, oh, it's a client, So I try to be cordial with my colleagues. I see them all the time. Half of my committee, I'm not here on the Nassau County Bar Association, but I am the chair of their labor committee or incoming chair as of next month.
Oh, congrats.
Well, thank you. So, it's folks that I deal with. So, just like you have your colleagues and you may sort of butt heads, you try to keep it civil and cordial. And for the most part, if there's some abnormalities, I always attribute it to the client. I try not to attribute it to the attorneys.
Mm-hmm. Okay. No, what's been your experience? Tell us everything.
That's very nice of you over
Oh,
Nassau County.
well,
But I would say, well, I don't want to jump the line.
That's okay, we'll get
I think there's 2 things. If you let me, now I have 2 points. Okay, so no, I've had experiences where it feels like there's I've had really terrible experiences where actually there's the statements from the employer bar is racist comments about our clients. assumptions that they're just like less than on a regular basis. Like even, you know, I spend a good amount of time creating a baseline. And so it really, it's not every employer's attorney, but I think that it kind of speaks more to the communications that are happening to the employer, to the attorney from their employer about who these human beings are, or, you know, their assumptions that maybe they're not that, right? So I think that's like one thing. I've had some really negative experiences, and sometimes I wonder if it's as well like a situation where sometimes it's almost ill-advised. Sometimes I'm like, did your client know that you're doing this because you're extending this lawsuit, and are you getting paid more money for it? So I'm not sure. So those are two things. But I think one thing I really wanted to address that you asked before about what SWET does, and as an attorney, yeah, it is really a lot of work and a lot of time. And you know what SWET would do, or you know the LLC bill that you mentioned before. Yeah, that would be great to reduce the amount of time and looking for that. But I think it's more so a sense of justification for our community members and our clients, and knowing that they at least got the money back, because it's a loss of faith in the system. It's also a loss of faith in what they can build for their families. In this, like when those hours that we cite and everything, they're working around the clock. Those are hours that they don't get to be with their family members. Those are hours that when they are with their family members, they're not their best selves. Because they're exhausted. You know, we talk about the money, we talk about all the amount of money and, you know, the law, but these are human lives, and it's horrific what's happening to them, because it's every day. They're in and out, and a sense of life for them to actually live, you know, and to be with their family. And to just earn the money to just have the money that they earned. That's like what's so difficult to hear some of the opposition to this, because it's the money that they've earned and worked so hard to obtain. And it's rendered meaningless because it may give someone else more money to maybe ignore their family that they don't want to spend time with. But I just so often I see these clients, and so that just really are doing everything they can for their children, for their like family members, to try to make things work, and to spend just a little bit of time to get to church on Sunday, to get together, right. And so often they have to miss it. So I know that the time and the money is important, but the value of what it means for someone to be able to recover money, and that they're not seen as worthless, they're not seen as less than. I think there's a real human value there that I just want to uplift here.
No, thank you. I appreciate that. I mean, I very often talk about how the current state of our economy largely sees our immigrant workforce as disposable. And, you know, if one dies, well, the other one's just, you know, on their way here. And it's really unfortunate because, as you say, you know, every single human being deserves to live a whole life. And that's really what we're trying to get at here, and a perfect segue to Mr. Medina's situation with his colleagues, the deliveristas, who are so often treated as disposable by some of the biggest corporations on the planet right now, right? Uber Eats, DoorDash, Grubhub. Am I missing any other big ones? Yeah, I mean, we're talking about billion-dollar multinational corporations who would rather spend money lobbying government so that they don't have to pay you and your coworkers, your colleagues, a living wage, even a minimum wage. Can you talk about how difficult that campaign has been for you?
Sí, can you speak Spanish?
Si quieres hablar en español,
Sí.
no hay problema, yo te traduzco.
Ok, gracias.
Dale.
Sí, bueno, nosotros iniciamos una campaña, los Deliveristas Unidos iniciamos una campaña para el salario mínimo. Todo esto nosotros lo iniciamos porque pues yo soy un trabajador más que hago pues deliveries en la ciudad de Nueva York, y pues tenemos muchos problemas en las calles. Nosotros en este momento no contamos con una herramienta que regularice el robo de salario. Estas compañías todo el tiempo están siendo más creativas, están como buscando las formas de no pagarnos una compensación, no pagarnos un seguro, no darnos un minimum wage, y es por eso que pues que yo estoy acá representándolos porque en las calles, pues yo también, de mi experiencia personal, estuve aquí en pandemia también trabajando. Fue una situación muy difícil porque yo trabajé pues en clima extremo, también pues he sido víctima de robo y pues todas estas situaciones me llevaron a pensar que debe haber un cambio. Necesitamos regularizar un poco más, pues como te dije, el robo de los salarios. Necesitamos que estas compañías paren porque arremeten siempre contra el trabajador. Puntualmente ahorita tenemos un caso en el centro de un trabajador al cual ya hace un tiempo se le deben $8,000. DoorDash le debe este dinero y hemos estado luchando con la compañía utilizando diferentes mecanismos para que le paguen el dinero, pero lamentablemente no se ha podido. Esta persona ha pasado por situaciones muy difíciles porque a raíz de que no le han pagado ese dinero, ha tenido que pedir prestado, ha tenido que hacer otros trabajos para poder alimentar a su familia. Estamos hablando de un trabajador que tiene hijos, que tiene a su familia aquí en los Estados Unidos y no ha sido posible recuperar ese dinero, y así pues tenemos muchos casos, nada más que desde este año en enero hasta abril hemos recolectado más o menos alrededor de $100,000 que la compañía no ha querido dar a todos los trabajadores.
¿Y qué compañía es?
DoorDash.
DoorDash. ¿Tú quieres
Sí.
traducir un poquito?
Yeah. So, Mr. Medina was saying that his own experience as a deliverista has been many. He has witnessed how the companies are avoiding to be responsible for paying when they get in an accident or when their tools get stolen, and they find every day a creative way to.
Usa el micrófono.
Oh, okay. Oops. So,
No me caiga.
so Mr. Medina was saying that he's been working as a deliverista, specifically with DoorDash, where he has experienced how the companies are every day trying to avoid to pay them a living wage, and actually avoid to take responsibility when they get injured, when they get into accidents where their main tools of work get stolen. And all these situations have actually push him to actually fight for minimum wage. Since they don't have a minimum wage, I would say they're actually not considered workers, they're considered independent contractors. And he witnessed how everyday workers are experiencing many experiences, and some of them is actually wage theft, which actually is wage theft of their tips, not even their own wages. And one of the cases that he brought up as example of that is of a worker who has been waiting for over a year now for $8,000 of unpaid wages, and we've been contacting the company. They're unresponsive, and this deliverista has gone and done everything as a way of survival, even borrow money to be able to cover his day-to-day expenses.
Okay, I just want to give everybody a better picture of what it's like to be a deliverista in New York City right now. Do you know approximately how many deliveristas there are?
We're estimating, based on the number of registered motorbikes, that it's like 65,000, but obviously we believe there are more, especially as a new workforce is arriving into the city, so everybody's venturing into delivery work. So,
and these workers have to purchase their own bicycles?
Yes. So a deliverista, in order for somebody to get into delivery, they have to buy their e-bikes, which can cost anything between $14,000 to $15,000 just for the e-bike. Then an extra battery that can cost $500. Then they have to also purchase their own equipment, which is their rain jackets, their winter jackets. They bag to do delivery. They can cost $80. Also, they have.
Wait, the companies don't even provide.
Don't provide anything.
The bag, they don't provide anything. Now, if the worker's bike is stolen, does the company help replace the bike?
No.
Nothing.
Now
So
when-
all of the overhead is on the worker.
Yeah, we did.
Is the worker provided with any health insurance?
The companies provide health insurance for them to buy it. So they make business with other companies to promote their business at a low cost. So it's up to the worker to buy those. I would say we did we did a calculation of the Liberistas who do this work. The estimate to start off doing this job in the first year is about $14,000 to $20,000 just to start as a Deliverista, all the operating costs.
How much they have to spend
How much they have to spend
to become a Deliverista?
Yes.
How much is the minimum wage for the Deliveristas that you are fighting for right now?
We have been fighting for $30 an hour. That has been the national fight because the operating cost to start this job is close to $16,000, $20,000. Right now, the city, we won the minimum pay in 2021. And so right now we have a law that mandates for Deliveristas to have minimum pay because they're not considered workers, so they don't actually have a wage. The city did propose a $24 an hour, including the on-call time, which is the time they are waiting for a delivery. The city revised, unfortunately, the companies, as you said, instead of investing that money to pay workers, they invested money in lobbying and building a anti-organizing campaign. And right now they managed to shift the current proposal role to give the company more flexibility, which the current proposed pay that the city has is two forms of payments. The city is giving them flexibility to choose if they want to pay per hour at $19 an hour, that would be in 2025, or if they only want to pay on trip time, which is the only time that they're delivering, not the waiting time, it would be 50 to 53 cents a minute, which the companies, it translates into $33, which the companies are making a big deal because they're saying $33, not even a nurse or a person makes that. That's only if you are receiving deliveries, like the full shift. The reality.
I thought you guys were essential workers.
Yeah.
I saw you guys out there during the pandemic holding us down. Has there been talk of any hazard pay?
So yes, and the workers, they want to fight for more. The reality is that the companies right now are lobbying Mayor Adams not even to give them minimum pay. And the big fight right now is that the companies are putting a large campaign to divide workers, confuse consumers, scare away restaurants, so workers don't have to be paid not even a minimum pay.
How much money are they earning on average right now? How much money does one Deliverista make in a week?
Bueno, ahorita está como muy suave el trabajo y bueno, yo como trabajador más o menos estoy trabajando 13 o 14 horas diarias, estoy haciendo más o menos entre 120 y 140 dólares. Lo que significa que como 120 a 140
en
dólares
un día.
En un día, más o menos entre 12 a 14 horas diarias.
12 to 14 hours of work a day, you make at most $140.
Sí, sí. Entonces, lo que yo quería decir es, porque si nosotros estamos educando a los trabajadores a que trabajen responsablemente, a que tengan sus equipos, a que rueden en la ciudad responsablemente, porque muchos deliveristas están en bicicleta, pero hay muchos que ahora tienen su moto, se están preocupando por tener sus license plate, sus seguros, por tener todo. ¿Por qué no regularizamos a estas compañías? ¿Por qué no les exigimos a estas compañías que nos exigen a nosotros los trabajadores que también tengamos que pagar los taxes, tengamos que incluir en todos nuestros gastos operativos? ¿Por qué nosotros los inmigrantes y los trabajadores tenemos que seguir viviendo de la caridad si nosotros nos estamos preocupando de una manera responsable por cumplir todas las leyes que la ciudad nos está dictando? Nosotros estamos cumpliendo las leyes, las compañías también las están cumpliendo. Yo no creo que las estén cumpliendo porque ellos están arremetiendo contra el trabajador. ¿Qué está haciendo la organización? ¿Qué está haciendo Worker Justice Project? Estamos día a día trabajando con los trabajadores, los estamos educando, les estamos diciendo, tengan sus licencias, tengan sus placas, tengan sus seguros, manejen responsablemente.
Y no manejen en la acera.
Y no anden por la acera, sí. Eso lo podemos hablar, pero sí.
I just said, and don't ride on the sidewalks.
Ajá, es verdad. También los estamos educando en ese sentido. Ahorita los estamos educando con el plan estructural que se va a dar acerca de las baterías. O sea, que estamos haciendo un trabajo muy duro y no es justo que vivamos de la caridad cuando estas compañías lo único que quieren hacer es hacerse como taparse los ojos y simplemente no dar nada a los trabajadores.
¿Quieres traducir un poco de lo que él dijo? No sé.
I'm going to try to summarize it, but he basically asked the question why, if the city is holding more responsible to workers and they're becoming more responsible to pay their taxes, to get their license plates, to do everything to be good citizens and to comply with the law, why we can't have these companies comply with the law and to have them pay a living wage. And the organization, and they are educating themselves to make sure that, you know, they do everything possible to do what they need to do in the right way. And they strongly feel that, you know, it is time to hold these companies accountable who are pretty much profiting out of their labor, but are not willing to pay them a dignified wage.
I mean, if I were you guys, I'd go on strike. Si yo fuera de ustedes, me iría a la huelga, para que dejen de joder. All right, very good. Thank you, panel C. All right,
you.
on deck, panel D, Brett Thomason from the Steam Fitters, Local 638. I'm sorry, before Brett, if you can take the second chair. Before you, there should be Angelina Palafox, who is a nail technician. Is she still with us? Perfect. Please take that first chair, and then Brett, you'll be to her left. Bill Banfield, Assistant EST with the North Atlantic States Regional Council of Carpenters. And Josh Pomeranz from the International Brotherhood of Teamsters, Local 804. What a lineup. Hi, how are you? I'm ready when you are. Yo estoy... Perfecto. Yo estoy lista cuando tú estés lista para comenzar. Dale, Angelina.
Buenas tardes, mi nombre es Angelina Palafox. Perdone, es que
Todo bien.
soy una especialista en uñas. Llevo trabajando más de 20 años en la industria de las uñas. Mi historia es igual o peor a muchas trabajadoras de salones de uñas. Perdón, es que esto...
Respira, tranquila. Aquí todos estamos para apoyarte, ¿cierto? Right? We're all here to support her through her testimony. That's right.
Gracias. Hay muchas irregularidades en los salones de uñas que finalmente se conecta a robos de salarios. Y como madre soltera se me hacía difícil pagar gastos. Nunca recibí un pago justo, días de enfermedad o vacaciones. Había un ambiente negativo entre los trabajadores provocado por la misma jefa. Había discriminación entre compañeras, no nos apoyábamos y tampoco nos hablábamos por varias razones, como estatus migratorio y competencia en el trabajo. Esto evita que en un salón haya organización entre trabajadores. Antes de la pandemia tuve una jefa que nunca nos proporcionaba equipo de protección personal como guantes, mascarillas y gafas de protección. Esto afectó mi salud reproductiva y negativamente. Y conozco chicas que tienen gastos médicos por falta de protección en el trabajo. Cuando comencé a trabajar durante la reapertura de la pandemia, la jefa no nos daba mascarillas, únicamente nos daba guantes de baja calidad pero no lo suficientes para cada clienta. OSHA requiere que los empleadores paguen por el equipo de protección personal que nos protege de los peligros en lugares de trabajo, y el Departamento del Estado indica que debemos utilizar guantes de nitrilo y mascarillas N95. Pero los dueños usualmente no nos dan guantes. Si nos llegan a dar guantes, son de baja calidad. Estos guantes se rompen fácilmente, penetra el agua a nuestras manos, siempre se forma una humedad. Esto ocasiona hongos o pues, se pueden transmitir también enfermedades que pueden traer los clientes a nuestras manos, y luego nuestras manos, así llegamos a casa, cocinamos, vemos a los niños.
Vas muy bien.
Perdón.
Respira. No hay afán.
Perdón, es que esto me afecta.
Es muy entendible. Por eso te digo, no te preocupes, tómate tu tiempo. Okay. Sé que es muy difícil a veces, recordar cosas que nos han pasado, pero de pronto piensa en la valentía que es necesaria para poder cambiar esas injusticias. ¿Cierto?
Yo compraba mis propias mascarillas. O sea, los trabajadores sacrificamos nuestra salud porque los empleadores economizan. En mi último trabajo, la dueña pagaba a veces en cheque, a veces pagaba en efectivo. Cuando pagaba en efectivo, nos descontaba dinero también. Llamé a la IRS y ellos me dijeron que los dueños no deben descontar por un pago en efectivo. Entonces, cuando yo le dije esto a mi empleadora, me quitó mis clientes por una semana hasta que me despidió. Y se quedó con mi licencia de aprendiz de técnica en uñas. Las jefas a veces cobran por dar un número de licencia para que las trabajadoras puedan sacar su licencia, cobran entre $800 a $1,000, cuando ellas deben proveer este número gratuitamente. Porque si ellas no nos proveen ese número, las compañeras no pueden obtener una licencia de aprendiz de técnico de uñas. Esto fue robo de salario y un despido injustificado. Sacrifiqué mi salud reproductiva y mental para las ganancias de un dueño que no consideró mi salud y seguridad. El salario de $100 al día, trabajando entre 10 a 12 horas, jamás paga por un gasto médico. Es por eso que estoy aquí. Le invito a apoyar esta ley de consejos de estándares mínimos de salones de uñas para evitar que historias como la mía sigan pasando a otros trabajadores.
Tranquila. ¿Quieres agüita?
Estoy bien.
Sí.
Estoy bien, gracias.
Can you get her water? This is coffee? No, it's water. was like, I'm
Quisiera
sitting next
hacer
to
mi
coffee the whole time.
trabajo de una manera saludable y segura y no sacrificar mi salud por la belleza de clientes y ganancias del negocio de un jefe. Patrocinar esta legislación significa la protección de muchos trabajadores como yo. Es nuestro derecho, es lo menos que merecemos. Estamos cansados de robos de salarios, cansados de los bajos salarios y cansados de estar expuestos a productos químicos peligrosos todo el día sin ventilación y protección adecuada. No es justo que empleadores reciban reconocimientos de que están haciendo un buen trabajo a cambio del sacrificio del salario y la salud de los empleadores. Por eso exigimos su apoyo para que todos trabajemos, tengamos un lugar de trabajo seguro. Gracias.
Gracias. Gracias, Angelina.
You want me to?
Yes, please.
Good afternoon. My name is Angelina Palafox. I am a nail specialist. I've been working in this industry for over 20 years. My story is similar to many workers in the nail salon industry, and perhaps for many immigrants. There are many irregularities at the nail salons that finally have a link to a wage theft. And as a single mother, it was very hard for me to pay the bills. I never received a just pay, sick days, or vacation. There was a negative environment between the workers caused by the boss. There was discrimination amongst co-workers. We did not support each other, and we didn't even talk for different reasons. For example, like our migrant status or the competition at the workplace. This prevented organizing ourselves, the workers at the nail salon. About EPP, before the pandemic, I had a boss that never provided us with EPP, personal protection equipment, such as gloves, masks, and safety glasses. This impacted my reproductive health negatively. And I know women and girls who have medical expenses for the lack of protection in the workplace. When I started working after the reopening, after the pandemic, our boss did not give us face masks, only gloves, but not enough for each customer. OSHA requires that employers pay for the EPP that protects us from the risks and dangers in the workplace. And the State Department provides that we need to use nitrile gloves and N95 masks. But the owners usually give us low-quality gloves to save money. These gloves rip easily. Water penetrates in our hands, and with that humidity and dampness, fungus can form, and then we can transmit illnesses that customers bring to the salon, and when we arrive home, we have to cook, see our children, and expose them. I had to buy my own face masks. In other words, we workers sacrifice our health so the employers can save money. Regarding the salary and her license, in my last job, the owner paid for some days by check and others in cash. When she paid us in cash, she would discount some money. I called the IRS and they told me that the owners should not discount any money for paying in cash. When I confronted my employer with this, she took away my customers for a week until she finally laid me off, and she retained my apprentice license as a nail specialist. There are owners who charge to share their business license number for $800 and even $1,000, when this should be given for free so the workers can get their own licenses as nail specialists. Otherwise, you can't get an apprentice nail technician license. This was a salary theft and an unjustified layoff. I sacrificed my reproductive health and my mental health for the profits of an owner who did not take into consideration my health and my safety. The salary of $100 a day working between 10 and 12 hours would never pay for the sacrifice I had to undergo on my health. That's why I'm here. I invite you to support this legislation of the Council of Minimum Standards at the nail salon industry to avoid stories like mine from occurring to other workers. I would like to do my job in a healthy and safe manner and not sacrifice my health for the beauty of customers and the profits of the business of my boss. To sponsor this legislation would mean to protect women like myself. It is our right. It's the least we deserve. We are tired of wage theft, tired of low salaries, and tired of being exposed to chemicals, dangerous chemicals, all day long without ventilation or adequate protection. It's not fair that employers be recognized as doing a great job in exchange for the sacrifice in our salary and the health of employees. It's for all of this that we demand your support for all workers. Thank you.
Thank you. Mr. Thomason.
Thank you, Senator. I'm Brett Thomason, Political Director at Steamfitters Local 638. We're a union of nearly 9,400 members that have jurisdiction over all steam fitting, pipe fitting, and sprinkler fitting in the 5 boroughs in Long Island. Apologies for my truncated remarks today. I was planning to be joined by one of our organizers who was going to speak directly to his experience investigating and prosecuting wage theft on a near daily basis, but he's out ill, so I will just relate what I hear from our organizers and from our 9 business agents who are daily out on job sites, monitoring where we have work and where we can potentially have work. So I want to say plainly and clearly that just like so many of the other industries that we've heard from today, wage theft is pervasive in the construction industry and affects the non-union workforce constantly. Our organizing department is overwhelmed with calls about wage theft, and they spend days and weeks sometimes investigating wage theft and trying to address it with non-union workers. The unfortunate fact is that most cases are not able to be recovered. Those wages never come back to those working people. In our industry in particular, We find contractors that are hiding behind paperwork or not disclosing payroll. We support the LLC transparency bill for this reason as well. It will make it easier for us to investigate wage theft. There's generally no recourse for those working people. So we support any range of options to help address this issue. Obviously, fully funding DOL so that they can be doing investigations is important. Making sure that DAs and the AG are prosecuting and investigating wage theft, and then the SWEAT bill, which we're supportive of as well. Not only so that we can return stolen wages to workers, but also, as has been mentioned, what we found is this is just the cost of doing business for a lot of these companies. So anything that we can do to deter the practice in the first place so that we don't have to investigate and prosecute wage theft would be a net benefit on our end. I also want to talk about one of the areas of wage theft that is doubly pernicious, and that's when it happens on prevailing wage and public works projects, which we're seeing all over the city and out on Long Island, whether it's work that should be done under a school construction authority PLA or has IDA money attached or any kind of public money where the public is meant spending our money, it's meant to create good paying high road jobs. And when we have non-union contractors doing that work and misclassifying workers and stealing their wages, not only are you robbing those workers of the pay that they're owed, but you're robbing those communities of the economic development opportunity that's meant to be spread by creating high quality, high road, good jobs in those local communities. So in our view, it's a double theft in that regard. It's particularly pervasive out on Long Island, where we've been losing union work for years now.
IDAs.
Yes. And what we see, and I hear this from our organizing team and our 9 agents, is that regularly we are seeing workers doing steam fitter work being classified as laborers so that their employer, if they are even paying the prevailing wage, can pay at a lower rate rather than the steam fitter rate, or in some cases just pocketing the wages of their workers. And these are prevailing wage jobs. So I'll close with that. We're supportive of this legislation. As you know, our union hall is always open to you. If you want any more information about what our organizers are experiencing daily, you can always come to us, and we appreciate the opportunity to speak with you today.
Thank you. Mr. Banfield.
Senator, thank you very much. My name is William Banfield. I'm the Assistant Executive Secretary Treasurer of the North Atlantic States Regional Council of Carpenters. I'm here today to testify on behalf of my union membership, representing more than 30,000 men and women employed by the leading carpentry contractors in the industry. Our union represents carpenters, pile drivers, millwrights, shop millmen, and floor covers, working throughout New York, Connecticut, Maine, Massachusetts, New Hampshire, Rhode Island, and Vermont. I am here on behalf of my membership today, but I'm also here to advocate on behalf of all carpenters and all construction workers, even the men and women who don't carry union cards, who we still consider our brothers and sisters. All blue-collar workers are impacted by wage theft, and all blue-collar workers deserve to be paid the wages they've earned. There's a crime wave affecting hardworking New Yorkers that you won't hear about on the news. Construction contractors are using underhanded schemes, shell companies, shady bank accounts, and check cashing stores to avoid paying employees the full pay they have earned. Getting cheated out of wages is all too common experience for construction workers, and with over 528,000 New Yorkers employed by the construction industry, about 1 in 18 workers statewide, this is an issue that hit close to home for thousands of families in the Empire State. When contractors cheat their workers, they also cheat on their taxes, and that impacts every honest taxpayer in the state. In New York, it adds up to $1 billion in lost wages every year, impacting tens and thousands of workers. Everyone loses when contractors commit tax fraud. Workers cheated out of the full pay they've earned, law-abiding contractors who deserve an even playing field, and every taxpayer forced to pick up the bill to fund critical services. Wage theft hits hard in the construction industry because of the way workers are paid. Some contractors pay workers off the books. Others rely on third parties to operate in the shadows, and even some pay with gift cards. An unscrupulous contractor can try to save on taxes by pressuring workers to accept lower wages than they've earned. Construction is a hard job. Now imagine working 10 hours a day, carrying sheetrock and setting concrete forms, and then getting a fraction of your pay at the end of the week, or nothing but false promise to make it up to you next week. Victims of this type of wage theft are faced with a Hobson's choice. They can either accept the lower pay, or they can complain, risking their job and any chance they have getting back pay. That makes it incredibly difficult to catch these tax cheats in the act. Wage theft is a crime that impacts real people, including New Yorkers all across the state. Just last year, 3 concrete supply and construction companies in Bellport were ordered by the federal government to pay nearly $1 million in back wages and damages to employees. The order came after the U.S. Department of Labor found that the companies had used multiple payment schemes to avoid paying overtime. In Yonkers, our union visited a construction site using an out-of-state contractor. As we handed out information cards to workers, one of the site superintendents laughed and told us, "Why bother? They're all undocumented." Another company notorious for exploiting undocumented workers has cornered the high-rise concrete market in Westchester County because contractors that obey the law are unable to be competitively bid against them for their projects. In Yorktown Fire District, we reported wage violations to the State Labor Department, which levied fines against the contractor and forced the company to pay $25,000 in back wages. At a $26 million project to build a new residence hall at SUNY Purchase, we found wage theft violations that led to a state DOL investigation, resulting in fines and payments of $20,000 in back wages. In Middletown School District in Orange County, we found a roofing company advertising on Craigslist for day laborers to do carpentry work for $20 per hour. We reported our findings to the DOL, but after 2.5 years, we have not heard any action being taken. I could go on and on with stories like this. Some of the stories may sound small, to some people, but they're not small for the men and women who are being cheated out of their wages. There are leaders who are standing up for blue-collar workers and fighting wage theft, and I want to acknowledge their efforts. First, I want to thank the committee, especially the chair, Senator Jessica Ramos, and the members who have invited us here to shine a light on this critical issue. At the state level, the Construction Wage Theft Task Force's coordinated effort among the New York State Department of Labor, Attorney General Tish James, district attorneys to combat corruption and crime within the construction industry. Due in part to the efforts of this task force, the New York State DOL has recovered more than $360 million in stolen wages over the past decade. At the county level, aggressive district attorneys are also cracking down on wage theft. During his tenure as president of the District Attorneys Association of New York, Orange County District Attorney David Hoovler made fighting wage theft and tax fraud a top priority. And just a few weeks ago, Manhattan District Attorney Alvin Bragg announced his office's first ever worker protection unit. These efforts deserve to be commended, but more needs to be done. Other states are taking strong action to crack down on wage theft. Colorado passed a law that defines labor as a thing of value and makes wage theft a felony. Colorado has also strengthened enforcement against misclassification. Delaware passed the Wage Theft Act, which makes the failure to pay wages a crime, like a regular theft crime that can be charged as a felony. Minnesota also punishes wage theft as a crime with a $1,000 threshold for felony offense. We hear a lot lately about rising crime, but wage theft is one that stays under the radar. The offenders rely on victims to stay silent, threatening future employment opportunities, and using their power and influence to evade accountability. That's coming to an end because more and more people understand that workers aren't the ones being cheated. Aren't the only ones being cheated. Also submitted for the record are 3 reports that I focus on wage theft and misclassification, along with a few websites which may be important for you to look at. Stopping wage theft is good for construction industry, it's good for blue-collar workers, and it's good for New York's economy. Thank you very much.
Thank you, Mr. Banfield. Mr. Pomerantz.
Thank you, Senator Ramos. My name is Josh Pomerantz. I'm the Director of Operations for Teamsters Local 804. We represent approximately 8,500 working people in New York City, Long Island, and Westchester. Over 8,000 of our members work for UPS. UPS, like other large employers, commits rampant wage theft against its workers. When caught, the repercussions are merely financial and easily incorporated into the cost of doing business. Enforcement mechanisms and penalties must be enhanced if we're ever going to curtail corporate America's immoral and criminal behavior. Companies like UPS commit wage theft in multiple ways. In some instances, we've been able to obtain a remedy. In other cases, we're still pursuing remediation. Even when we've exposed large-scale, systematic acts of mass theft by UPS, they continue unabated. We've been able to correct smaller-scale time shaving and individual acts of underpayment, but there's no doubt that there are acts of theft that we miss. Under the current legal framework, workers and unions must spend significant time and resources to recover what's stolen. Even if found liable, employers can still end up ahead or break even on their crimes. In early 2020, UPS employees filed a class action lawsuit against UPS for wrongfully deducted charitable contributions to the United Way. At the end of 2021, nearly 2 years later, UPS settled for over $1 million. For years, UPS had been strong-arming members into donating to United Way for its own tax and reputational benefit. Management then took it a step farther and began taking deductions without receiving proper authorization from workers and/or failing to properly retain authorization cards. The scheme was so ubiquitous that even some supervisors were deemed eligible and accepted payouts from the lawsuit. UPS ended its relationship with United Way in New York. We've heard from other local unions that UPS continues similar illegal activity in their jurisdictions. For a company profiting billions of dollars every quarter, paying out $1 million has virtually no effect whatsoever. One of the more disgusting forms of systematic wage theft UPS currently performs is against its holiday season hires. We at Local 804 have been aggressively pursuing this since 2019, but the illegal practice has continued every year since and is sure to occur again in just a few months. UPS is undeterred, as management knows their profits will outweigh any repercussions. The manner UPS systematically steals from its most vulnerable employees is neither complicated nor uncommon. To handle the Christmas volume, thousands of temporary employees are hired as delivery helpers on the UPS truck. They earn minimum or near minimum wage and are often part-time. UPS instructs these seasonals to begin their workday by meeting a driver on the street at a specific location or at a warehouse. Rather than pay these people from their scheduled start time, as required by law, they're paid from the completion of their first delivery stop. Each worker may lose out on minutes or hours per day, and UPS is able to pocket the cumulative value of unpaid wages. As the scale of theft is widespread, the amount being stolen is far from insignificant. UPS has avoided liability for its theft, as most white-collar criminals do, through legal delay and obfuscation. The company refused to provide the union with contact information and time cards for the 2019 seasonal hires, forcing us to go to the NLRB. We won at the ALJ level and at the board level, but the company continues to appeal and refuses to give us the information. As is the nature of being a low-wage worker in New York, it's highly unlikely that these people will have the same phone number and address as they had in 2019. They will likely never be able to recover what was stolen from them. When seasonal workers attempted to file a class action lawsuit against UPS, they were prevented because they had been forced to sign individual arbitration agreements as a condition of employment. These waivers will eventually be voided, as our CBA takes precedent over them, but it's allowed UPS to delay their comeuppance as well as allow them to reinvest the wages they stole. Several such workers went forward with the individual arbitrations and won, but that represents only a fraction of UPS's victims. UPS corporate is fully aware and is in support of the systematic theft. The separate agreements were presented to UPS at our national grievance panel, but the company refused to rectify their violations. We will win this through arbitration, but locating these workers and pursuing their claims after so many years will be extremely difficult, which is exactly what UPS intended. Not only is UPS refusing to take accountability in our grievance procedure, but they're also indifferent to the investigation currently being performed by the New York Attorney General. The AG originally got involved because UPS's failure to pay over 100 employees their correct hourly rate. Most of the underpayments related to part-time employees who worked so many hours during the pandemic that they qualified for full-time jobs. Today, almost all of these employees are getting the correct hourly rate, but they are still owed significant retro pay. Unfortunately, there's little the AG can do for underpayment because of federal preemption issues and a lack of enforceable state laws. There's more they can do with the seasonal theft, as minimum wage laws were violated in some instances, but the enforcement mechanisms are still not strong or specific enough. Further, the AG is not budgeted with sufficient tools or resources. UPS is fully aware that the Attorney General is investigating them, but they continue to flaunt the law due to the lack of serious consequences. The Attorney General and other enforcement agencies must be given what is necessary for them to go after these criminals. Like the underpayment of wages being difficult to prosecute, individual employee time shaving or alleged payroll errors occur with little recourse. When the union becomes aware of time shaving, such as when drivers have their time cards altered so it appears they did not go over DOT hours, the company corrects what we present them, but suffers no other consequences. This means that every case we do not catch is a successful crime. If a workplace does not have an aggressive union, there's virtually no deterrent against individual acts of theft. The amount stolen from each person may not be enough for them to invest their time and resources to recover, particularly when it likely means they'll lose their jobs regardless of whether they win or lose. For an employer, stealing a little from a lot of people is no different than running a company with tight profit margins but a large customer base. Wage theft is another input in the cost of doing business. Thank you for your time and your attention to this, and we're happy to answer any questions.
Thank you so much. Wow, that was, it's been quite a panel. Angelina, I want to start by thanking you for your bravery in sharing your story. I know it's not easy, but it's necessary because we have to shed light on these injustices so that we can pass the laws to correct them. So thank you for your bravery. You know, I know nail salon work is actually very hard. And perhaps our society doesn't value nail technicians as the artists that you are. Heck, I would argue you should be DC-9 painters. I'm not kidding, they use drills. So I have been working with nail salon workers to pass the Minimum Standards Council bill. For those who don't know, the bill proposes that we create a mechanism in our state government for nail salon owners and nail salon workers to have a mediated conversation on how to improve the pay and working conditions for nail salon workers. I cannot tell you how often I myself go to nail salons as a good Latina and meet nail salon workers who are only paid if they have a customer in front of them, or they are paid only a percentage of what the customer has ordered, not even being paid per hour. Or my personal favorite, because I like to sneak into the break room sometimes, when I see the DOL poster that's on the wall, it's so conveniently from 2019, the year when the governor signed the executive order to do away with the tipped wage for nail salon workers. And of course, they are trying to perpetuate that system, not wanting to pay nail salon workers $15 an hour as is outlined in the law. I want to ask you a kind of facetious question that I also wanted to ask the deliverista, because it is so obvious that so much sacrifice goes into doing this work. Why do you choose to continue doing this work? It's been 20 years.
Porque me gusta hacer el trabajo, me gusta hacerlo.
Because I love doing my job.
No he optado, me gusta ver que los clientes queden satisfechos con el trabajo.
I like to see customers happy with the work we do.
Would you argue that a lot of this work that tends to be done by undocumented workers, I'm sorry, I'm trying to phrase this correctly. Does the lack of documentation of many workers, do you feel, result in employers wanting to routinely take advantage and keep driving down standards for your work?
Sí, el no tener una documentación impide también estar en otro trabajo.
Yes, being undocumented also prevents us from getting another job.
I mean, I imagine, especially with the nail salon industry, actually, unlike the construction industry and the deliverista industry, there's a lot of human trafficking taking place in our nail salons here in New York State. I know that your organization has also collaborated on reports about the correlation between your exposure to chemicals and toxins and miscarriages and other reproductive health issues for women. Do you know of women who have experienced that?
Sí, conozco mujeres que han tenido esos problemas más serios.
Yes, I've known women who have had those problems, even more serious issues.
Como asma.
Like asthma.
And you were talking about in your testimony about fungus on your nails and on your hands.
Sí, eso también cuando eso no estamos supuestos a trabajar con clientes que traigan hongos, pero a veces los jefes nos obligan a hacer ese tipo de trabajos.
We're not supposed to
Esos
work with customers
hongos
that have fungus, that bring fungus to the workplace, but the owners force us to work in those conditions.
What happens if you say no?
¿Y si te niegas a hacerlo?
Pues hay a veces que si uno se niega a hacerlo, el empleador nos deja 1 o 2 días sin trabajo, nos dice, oh, te llamo después, y opta por hacer con otra trabajadora.
If we refuse to do it, the owner might tell us,
se
don't come to
molesta.
work for 1-2 days and give the work to another co-worker.
If given the opportunity to organize, would you join a union?
Sí.
Okay.
Yes.
Thank you, Angelina.
Gracias.
Brett, I'm curious about your organizer's experience, and I know that your colleague was sick and unable to come, but I'm sure you spend plenty of time together and can recant a few stories. You were saying that the organizers get phone calls all day, and they find themselves returning phone calls from ununionized workers, I presume?
Yes.
What kind of
Because
stories are they hearing?
They're out on job sites daily, targeting new work for us, and when they visit those job sites, by far, wage theft is the most common complaint that those workers have about their employer. And so, we could tell you stories all afternoon about some of the things that they see. just the other day, this wasn't an organizer, but one of our business agents was up at a site on the Upper East Side that's being converted to a 3K. But through a loophole, most of the work is not being done under the School Construction Authority, PLA. So he saw steam fitting work being done and made a couple attempts to talk to the workers, and they didn't even know who was employing them.
Is this a regular practice of the SEA?
It's one that we're learning about.
Interesting.
More and more common. Yes.
Well, I do happen to have a bill, since a few of my other bills are starting to come up, to put prevailing wage on projects with state loans, granted not SEA. But it was a part that we left out of the larger prevailing wage law. Bill, can you speak to maybe the difference that a collective bargaining agreement makes?
Sure. Being a member of an organization, I've been for 37 years, we have when you go on a job site, you have the backing of your union. So you can go in and, as a worker, and demand a wage and benefit that was negotiated for.
Right, because it's on paper.
Because it's on paper. It's on paper, which, eventually turns into the prevailing wage when you're working on city projects, whether it be a firehouse, city hall, school, whatever it may be, highway work, you have that prevailing wage. And, so with that, if there is an issue on site with a lack of payment, whether it's a wage or benefit, we're the first line of defense for our members. We go out and we'll fight for them, and it makes them feel a lot stronger, that knowing that we're there for them.
Do you provide them with an attorney if needed?
We have our own attorneys,
Right.
and we deal with them on a constant basis, but
But your members don't have to worry about that.
doesn't have to go that far. Right. So if we need to, we go through an arbitration process. We have our fund office, which does audits on companies to making sure that payments have been received. And there's a lot of different avenues that we can go to make sure that we get these payments, for the members, whether it's directly to a company or to the worker themselves.
You were describing a case that took 2.5 years?
Still ongoing.
Still ongoing, and it's been 2.5 years.
It's been 2.5 years.
While you were describing it, all I could think about was inflation. The cost of the labor provided, yesterday's price is not
Right.
today's price.
Right. So with that one there, we went down to the job site. It was a school work. We found out the workers on site there, young kids from New Jersey coming in because of the proximity where it was, underage, maybe 17, 18 years old, working on the site.
Okay, I guess that's... Okay.
So we got the district attorney involved, Orange County District Attorney. We also got the New York State Department of Labor involved. We put the two together. The DOL says to the district attorney, I'll take care of this one. If I need any more assistance, I'll give you a call. 2.5 years later, still nothing has been done about that project.
And it's safe to say that the 17 and 18-year-olds did not receive state-certified training that can
Correct.
only be provided by the unions.
Right.
So they didn't know how to work safely.
Correct. They're on the roof without any, fall protection, so forth like that.
Mm-hmm. Very good, thank you. Josh, UPS happens to be meeting with me tomorrow.
Oh.
What should I tell them?
You should tell them to pay their people properly. You should tell them to give proof of that to the union, because we've been chasing that for quite a while. A big part that I'm sure everybody here deals with is even verifying what they're actually doing. So, for example, I mentioned the 100 or so essential workers that showed up to a warehouse during the pandemic, part-time employees, working over 8 hours a day. And then we were able to, through the grievance procedure, get them full-time jobs.
Pardon my ignorance. If you're working 8 hours a day, how is that part-time?
Exactly. So we have it in our contract that if you work more than 8 hours a day for 40 days in any 70-day period, you get a full-time job and all the benefits that come with that.
So it really just sounds like their way of allowing themselves to pay the workers less and get around the union and the collective bargaining agreement?
Our part-timers are in the union as well.
Right, okay.
But it's different wage rates. And then we've been chasing retro pay for these folks for years now. Some of them get a check. We don't know that they do until they tell us. They don't know the breakdown of how those numbers came about. But if they, for example, see a $5,000 check, it seems like a lot, but they might, in some cases, be owed $20,000, $30,000. And then when we go to the company and say, how did you even come up with this $5,000? They shrug their shoulders. I'm still chasing this for years. So I sent information requests yesterday over these exact things from years ago.
All right.
So it's obvious, the shell game that they're playing with the money. Companies like this are clearly reinvesting that money or paying out dividends to their shareholders with money that they're stealing from workers. And at a minimum, they need to be sharing this information with the union.
Absolutely. When we talk about wage theft, before we were talking to a few members of the hospitality industry, of restaurant owners, and of course those are largely small businesses. But here we are hearing about DoorDash and UPS. Some of, never mind real estate tycoons, if I may, and large contractors, people who can perfectly, pay their workers a fair wage, a living wage. It's very frustrating, as it is. I always love to say that, no business is viable if you can't afford to pay your workers the minimum wage. Then you don't belong in business, right? No, it's not worth saving any business over making a worker homeless, leaving a worker homeless. But it's increasingly frustrating with these companies who seem to just, keep all of the profits up top with the C-suite executives and not, respect those who are actually making their profit possible. Those are some thoughts. I don't know if anybody else wants to add anything else. No? All right. Well, then thank you very much. And we will go to panel E before our 10-minute stretch. And we have Carmela Huang, Senior Attorney at the National Center for Law and Economic Justice. We have Naoki Fujita from Take Root. We have Janine Peña from Youth Against Sweatshops. How we doing? I don't see customers up here. Daisy Chung from the New York Healthy Nail Salon Coalition. And Sandra Cruz from NICE, New Immigrant Community Empowerment from Jackson Heights, Queens. What? All right. Carmela, you want to kick us off? I'm ready when you are.
Senator Ramos, thank you for the opportunity to testify today. My name is Carmela Huang. I'm a senior attorney at the National Center for Law and Economic Justice, NCLEJ. NCLEJ is based in New York, but works across the country to advance racial and economic justice for low-income families, individuals, and communities through litigation, policy advocacy, and support for grassroots groups. For more than 60 years, NCLEJ's mission has been to enforce the rule of law, protect entitlement to a wide range of public benefits, and advance the rights and safety of low-wage workers. NCLEJ is recognized as a national expert on due process rights. Beginning in 1970, when NCLEJ achieved a landmark victory in the U.S. Supreme Court case Goldberg v. Kelly, NCLEJ's work on matters throughout the United States, including in New York, has helped define our modern understanding of procedural fairness. NCLEJ strongly supports the passage of the Sweat Bill. My testimony today will focus on how the Sweat Bill satisfies due process requirements and mirrors wage liens that already exist in other states. It is a fundamental principle that our government may not deprive a person of life, liberty, or property without due process of law. Enshrined in the 5th and 14th Amendment of the U.S. Constitution and Article 1, Section 6 of the New York State Constitution, the right to due process is a commitment to the rule of law and fundamental fairness. However, what types of situations require due process, when that process must be provided, and what procedures satisfy that right are not always straightforward questions to answer. When talking about property interests, the law is very clear that the deprivation of needs-based benefits such as food stamps, Medicaid, and unemployment insurance triggers the highest level of protections. Due process is satisfied only when, prior to the deprivation, an individual receives meaningful notice and a full and fair opportunity to contest the proposed action. This is because, as the U.S. Supreme Court has stated, the termination of aid pending resolution of a controversy over eligibility may deprive an eligible recipient of the very means by which to live while he waits. In most other circumstances, though, there's no standard formula for providing constitutionally adequate due process. Instead, determining whether a proceeding satisfies due process requires the balancing of 3 factors. 1, the private interest that will be affected. 2, the risk of erroneous deprivation through the procedures used. And 3, the government's interest. The Sweat Bill would allow workers whose wages have been stolen to file a lien on the real and personal property of those who are directly responsible for their wage theft, their employers. These employers have a legally cognizable interest in keeping their property free from wrongful encumbrances, but those interests are balanced against the interests of the state in enforcing its laws and protecting the health and well-being of the people and economy of New York, and the interest of workers in recovering wages from labor that has been unlawfully taken from them. While workers may notify employers of their intention to file a lien prior to its filing, the Sweat Bill also permits workers to notify employers of a lien up to 30 days after the lien has been filed. This flexibility is key to the bill's ability to fulfill its intent, which is to restore the efficacy of the state's wage and hour laws by stopping employers from transferring their assets to evade wage claim judgments. It's important to note, as has already been noted by others, that the Sweat Bill's notice provision is identical to the provision contained in the state's mechanics lien law, which was determined by the Court of Appeals to satisfy due process in 1978. The U.S. Supreme Court has also affirmed that due process is satisfied when notice and hearing are postponed until after a lien is filed, if there are allegations that the property holder plans to take action that would render the property unavailable to satisfy a judgment. Once the lien has been served, once notice of the lien has been served, the Sweat Bill provides the fullest protections to the employer to reduce the risk of wrongful attachment. Workers seeking liens are required by the bill to itemize their wage claims, including the value of their claims, going beyond what is required of a mechanics lien. And Sweat allows an employer to demand even more. The bill allows an employer to demand a detailed factual statement from the worker about the wage claim and to begin to have the lien canceled if the worker does not comply with the demand within 5 days. The employer may also demand that the worker commence a wage claim action in court or at the Department of Labor within 30 days. Failure to meet this demand again permits the employer to have the lien canceled. After an action is commenced in court, the employer has access to all of the due process hallmarks that characterize our court system. The employer may present evidence, cross-examine witnesses, seek representation by counsel, and appeal any decisions that do not have a strong foundation in either the facts or the law. If at any point the court determines that the value of the lien has been willfully exaggerated, the lien is immediately voided, and the worker is prohibited from any further action to collect on the claim. The employer may then commence an action against the worker for damages, including all attorney's fees and costs. No lien, whether it is a mechanics lien or a wage lien under Sweat, may be foreclosed on without a court order. This means that no part of the employer's assets actually transfers to the worker until there has been a full and fair finding on the facts. The lien places potential buyers on notice that property may be used to satisfy an eventual judgment, but it does not actually stop an employer from selling and others from buying that property. Property with liens can be less attractive to buyers and can command less market value. A lien may affect an employer's creditworthiness. So Sweat provides employers with a way out. A An employer who has not been able to void a lien, either by making a demand that the worker has been unable to meet or by showing that the lien has been willfully exaggerated, may execute a bond for an amount equal to the lien and have the lien fully discharged. Not all states with wage liens have similar bond provisions. There are currently 4 other states with wage lien laws: Washington, whose law became effective in 2021, Maryland, which added a wage lien in 2013, Wisconsin, which has had its wage lien law since 1975, and Kentucky, whose wage lien dates from 1952. These 4 states demonstrate 2 divergent paths, exactly. Whereas Washington and Maryland both allow an employer to discharge a wage lien through the execution of a bond, neither Kentucky nor Wisconsin permit employers to remove wage liens through the payment of bonds, although such bonds are allowed for mechanics liens. The 4 states differ from each other and the sweat bill in other significant ways as well. In Washington, a wage lien may be filed on a much broader array of property, including accounts receivable, payments intangibles like loan repayments and payments from credit card processors, and even community property co-owned by an employer's spouse or domestic partner. In Maryland, a wage lien must be accompanied by an affidavit signed under oath, but it is self-executing and may be foreclosed upon if the employer does not initiate a court action to contest the lien within 30 days. Kentucky's wage lien attaches to all property that has ever been involved in the operation of the employer's business regardless of ownership, which allows workers to place liens even on property that has already been sold or assigned to a third party. And in Wisconsin, any worker who files a wage claim petition shall automatically have a wage lien. The lien takes effect as soon as the worker files a notice of lien with the clerk, pays the specified filing fee, and serves a copy of the wage claim petition on the employer. These liens are also super priority liens, taking precedence over all other pre-existing liens, debts, judgments, decrees, or mortgages against the employer, except for those explicitly excluded by statute. All of these differences show us that wage liens may take a variety of forms and still comply with due process. This is because, as the U.S. Supreme Court stated in Matthews versus Eldridge, due process, unlike some legal rules, is not a technical conception with a fixed content unrelated to time, place, and circumstances. Due process is flexible and calls for such procedural protections as the particular situation demands. Here in New York, the particular situation before you now is this. Wage theft has become pervasive and endemic, so commonplace and seemingly incurable that many low-wage workers simply accept it as one of the costs of living in the state. The ineffectiveness of the state's wage and hour laws means that many hard-working New Yorkers live with fundamental unfairness. Workers who labor at full-time jobs can find themselves unable to meet their basic needs and those of their families. They can face food insecurity and even homelessness. Wage theft also harms the financial viability and competitiveness of employers who respect the law. With due process protections built in to safeguard the rights of employers and to eliminate the risk of frivolous liens against them, SWEAT can begin to reverse the harmful effects that unchecked wage theft has had on workers and businesses in the state. I therefore respectfully urge you to restore the enforceability of New York's wage and hour laws and pass the SWEAT bill. Oh,
Thank you. Should I use this one?
Yeah.
Okay. Okay, thanks. Wow, that was exactly 10 minutes. Okay. Senator, I want to thank you for the opportunity to speak. I'm an attorney in the labor and employment field, and I'm currently a senior staff attorney at Take Root Justice, a nonprofit legal services provider in New York. We partner with worker centers like NICE to give legal representation and legal education to mainly construction and service sector workers. Take Root does work beyond the workers' rights field, and the organization provides legal, participatory research, and policy support to community partners throughout New York. The focus of my legal practice is taking action when employers fail to pay their workers. Just to give you a little preview, I'm going to talk about my practice with utilizing mechanics liens. I also want to say before I start that I was able to review the entire bill before coming here and presenting my testimony. And credit is due to the staff, the legislative staff who drafted it. It's very well drafted, and I think it addresses any concerns that could be raised by critics. So let me begin. I'll try to keep it fairly short. I'm going to tell you two stories. As other speakers will note and have noted, wage theft is a drain on the economy of this state and a drain on the lives of working people in New York. The magnitude of the problem is hard to describe. I work on a team of either 4 or 5 lawyers plus support staff, and last year alone, in 2022, we collected over $800,000 in wages that were not paid on time. The Senate, by passing the Wage Theft Act, the Wage Theft Prevention Act in 2010, made a major step in remedying this problem, but more needs to be done. And that's why I'm speaking today in support of Senate Bill 1977. I would like to share 2 stories about workers who aren't able to be here today. And I will try to be as detailed as possible without naming the relevant employers. Ultimately, these employers paid their workers in full, but first they needed a little nudge. That nudge was the mechanics lien, a law which has been utilized and has been upheld by courts for over 100 years in this state. But I'm not going to name these employers because I think they did the right thing. But I'll provide you a little bit of a story. And the key fact I want to present to this committee, if nothing else, is 2 points of time. The time when my organization filed the lien with the county clerk, and the time when the employer issued a check for the past wages due, that time span. The first matter was in 2021, and the amount owed was $4,000 for construction work. $4,000 is a modest sum, but important to my client. My client was a member of NICE, one of our worker center partners located in Jackson Heights. I have to get that plug. And he had performed work, not for a long period of time, hence the amount, on a residential building in Brooklyn, in Kings County. We filed a mechanics lien in November 2021. In December 2021, after a brief negotiation with the company, the client was paid in full. The time elapsed was less than 30 days. This is a marked contrast to the stories we've heard about waiting 6 years, 7 years, more to be paid. In fact, this was a small employer. They didn't want to come to Manhattan, and they came to the offices of NICE in Jackson Heights, and they hand-delivered this check within 30 days of when we filed the lien. And I guess what I want you to take away is that this is a fast process, and it's a fair process. Carmela has in great detail laid out all the protections, and I will also briefly touch on some of the due process protections that are available to currently to construction industry employers. The second story was in 2022, and it was caused by $15,000 in back wages for work done on a larger project in Staten Island, a commercial property for seniors. In this case, it was a little bit more complicated because there was a subcontractor involved, although the person who contacted me was the GC. And it took a little longer to collect. However, again, we filed a lien in April of last year in 2022. And the company, from their offices in Long Island, delivered me a check within 90 days in July of 2022. Again, to me, a very efficient and a very process. What I want to say about due process is briefly this. This was a small family construction company. The owner's son was the one who came and hand-delivered the check to me. And the first thing that the owner told me was that he didn't believe the claim, and that if he wanted to lift the burden of the lien, he was going to bond it out. And I don't know if that term has come up today, but this is not a lawyer. This is just common knowledge in the construction industry that if you believe that the claim is false or has been exaggerated, by simply posting a bond, the lien will be released and one can dispose of the property and use it as per normal. I was impressed that he knew more about the law than I did. Mechanics liens is a very, very small part of our practice. But the fact that he knew that this due process protection was available to him suggests to me that employers will get the message. Employers will be informed about how they can counteract any sort of fraudulent claims, of which I've seen none. I believe that mechanics liens, and if it's expanded through Senate Bill 1977, is one of the most effective means for workers to achieve speedy relief. One of the reasons I just add is that the mechanics liens are such a small part of my practice is that many workers, when they are referred to us by a worker center, have already passed the 8-month or the 4-month, a fairly short deadline in which one can file a mechanics lien under the current law. So I do work with many construction workers who are simply beyond that time limit. That concludes my remarks. I think I'm going to cut it short there. It's a little bit less than 10 minutes, but I'll be available for any questions. And I thank you for your time, and I thank you for your work on this bill. It's extremely important.
All right, good afternoon, everyone. My name is Yanine Pena. I'm a member of Youth Against Sweatshops, but I'm here speaking on behalf of Women Against Racist Violence, WARV. We're a multiracial collective of young people organizing to address the racist violence that women experience daily in the form of 24-hour workdays, wage theft, and displacement. I'd like to share our perspective on wage theft along with a personal anecdote. In my early 20s, I worked at a bar where I was promised cash payments at the end of each night. After 8 hours of work, the manager tells me that he can only pay me if I get certain male customers to buy a certain amount of drinks. I noticed that many of the girls around me were roped into this line of work to accept being groped by drunken men out of necessity. Many had children or were undocumented. I walked away that night with $5 and a Metro card. I can't describe how violated and worthless I felt that night. It was only years later till I began organizing with En Masse and the Sweat Coalition, and also with home attendants, hearing about their harrowing stories of wage theft, that I was able to make sense of what me and many of my colleagues endure. Every year, bosses steal billions from workers, and our state turns a blind eye, and their zero response leads to many to believe that wage theft is a victimless crime and that bosses can freely get away with stealing from their workers. What's the use of calling it wage theft or a crime if there are no consequences? I believe part of the problem lies in how our perspective and what constitutes as violence and crime. Sometimes it ends up trivializing rather than revealing the issue. It doesn't capture the suffering and generational aftershocks of wage theft, or how it destroys workers' lives, their families, and their communities. I think we need to start calling wage theft by what it really is: racist violence. Let me break it down for those who think this is hyperbole. Every paycheck that is stolen from a worker is a step closer to starvation and homelessness. What is this if not violence? Every paycheck stolen from a woman is a step closer to staying in an abusive relationship to survive. What is this if not violence? Every paycheck stolen is a step closer to a worker being landed in prison for committing a crime out of desperation. What is this if not violence? In the South Bronx, one of the poorest congressional districts in the United States, where many of the home care workers that I organize with live and work, wage-stealing agencies operate there. Every 13 hours stolen from a home attendant each year means money deprived from them and their families, impacting their ability to afford education, housing, and other necessities. This traps families and our kids and communities in a cycle of racist violence and poverty. Perhaps this is why I'm so infuriated today. Wage theft continues unabated because so many politicians are too immobilized by blood-sucking sweatshop bosses to end this violence. They've been duped by unethical and shameful organizations like Hospitality Alliance against their better judgment to believe lies about how workers will abuse sweat and file false claims. In the era of Me Too, we're told that all victims of abuse must be believed. That is only unless their wages have been stolen and they dare to speak out. It's time to start believing workers. Shame on Hospitality Alliance using their black celebrity president as cover for their racist crimes. Shame on them for claiming victims of wage theft are liars. And if politicians have a shred of integrity, they'd stop listening to Hospitality Alliance and pass sweat and be part of the solution to redress this violence, rather than just be another obstacle in the way of justice. I urge you to pass sweat immediately.
Good afternoon, Senator. Nice to see you. So my name is Daisy Chung, and I am the director of the New York Healthy Nail Salons Coalition. And the coalition was created in 2014 to organize with workers for improved working conditions in the nail salon industry. And our organizations collectively represent thousands of nail salon workers in New York. And I want to thank you, Senator, for holding this hearing today. New York's nail salon industry is part of a national multi-billion-dollar sector, and New York is actually home to the highest concentration of nail technicians. These are manicurists and pedicurists in the entire country. The New York City metro area has the highest number of workers and salons in the state, and also followed by other cities, including Rochester, Buffalo, Poughkeepsie, and Albany. Nail salon work is overwhelmingly performed by immigrant women and immigrant women of color. Nail technicians make up the vast majority of the industry's workforce, with 85% identifying as women and 88% born outside of the United States. Among these workers, 73% identify as Asian or Pacific Islander, and 21% identify as Hispanic or Latinx. Despite nail techs organizing in this industry and their successes in the last several years, they're still facing the same exploitative conditions on the job. There's an overwhelming lack of compliance with basic labor standards in the nail salon industry, and wage theft, like many other industries, it's pervasive and widespread. According to a 2022 research report by Cornell University's Worker Institute, the average hourly wage for nail technicians in New York is $13.89, while the median wage is just $10.58 per hour, and both are below the required minimum wage. In another report released in 2020 by the New York-New Jersey Regional Joint Board of Workers United, 82% of nail salon worker respondents reported experiencing wage theft, with an average loss of $9,412 per year per worker. Employer compensation practices in the industry also contribute to workers' confusion about what they're legally owed, such as paying off the books, offering daily rates of pay, or commission-based pay. While wage theft in the nail salon industry remains a persistent problem, workers are often fearful of the consequences of reporting such violations. Nail techs are typically immigrant women of color who are paid low wages, have limited alternative job opportunities, and lack the social protections based on their immigration and/or employment status. This creates a precarious situation that heightens workers' fears of retaliation by their employers for speaking out about working conditions. Many of these impacted workers are single mothers or sole breadwinners for their households, and the devastating impact of wage theft cannot be overstated. Workers who are part of our coalition express frequently enduring significant levels of stress over the economic insecurity that's created by stolen and low wages in the industry. And they're pointing to the pressures created by rising rent costs, rising food prices, costs of childcare, and sending remittances to provide for their families in their home countries. One thing that's interesting to note is that the Workers United report that I just mentioned also found that wage theft was more common at salons that charge low prices. So in the report, it states, at salons where manicures were $15 or less, workers experienced an average of $123 in wage theft per week. At salons where manicures were $16 and higher, workers were paid an average of $58 more than the required minimum wage. The average cost of nail salon services in the New York City metro area is $13.71, much lower than the nationwide average, despite the higher cost of living and doing business in the region. Low prices in New York have created an untenable race to the bottom in the industry, where responsible salon owners are being outcompeted by those who are willing to cut corners at the expense of their workforce. And we believe that government policies must guide the marketplace when unfair competition of such nature arises. The New York Healthy Nail Salons Coalition supports legislative efforts to deter and eliminate wage theft in our economy and to ensure that all workers can recover full compensation from employers when their rights are violated. In addition, we also ask that the members of the Senate and the New York State Legislature address poor and declining standards in the workplace beyond minimum wages, as workers across the nation are fighting for bread, but for roses too. Our coalition is advocating for the passage of the Nail Salon Minimum Standards Council Act, which would create new labor standards that will improve working conditions for the tens of thousands of nail salon workers throughout our state. Thank you.
Buenas tardes a todos los presentes. Mi nombre es Sandra Cruz. Soy trabajadora inmigrante en la ciudad de Nueva York y soy miembro de la organización NICE. Hace unos meses atrás trabajé en un restaurante llamado La Macarena, ubicado en la calle 48 entre las avenidas Séptima y Octava en Manhattan. Había conseguido este trabajo en octubre de 2022 a través de una agencia de empleo, en la cual me ofrecieron un pago de $16 por hora como ayudante de cocina. También me habían prometido un horario distinto a lo que me pedían ir a trabajar. Durante ese tiempo, la chef principal había estado ausente la mayoría del tiempo que yo estaba trabajando. Y cuando ella regresó, simplemente decidió botarme del lugar. Cuando regresé a preguntar por mi pago de los días trabajados, me encontré como respuesta que me avisarían cuando el cheque estuviera listo. Pasaron exactamente 2 meses y después, para finalmente recibir mi pago a través de un cheque que cuando fui a cambiar al banco, uno de los agentes me dijo que no podían hacerlo, ya que tenían problemas con la cuenta del restaurante La Macarena, y que esto estaba pasando desde hace tiempo con otros trabajadores del lugar. Hasta la fecha de hoy, 25 de mayo de 2023, no he podido cobrar el dinero de mis días trabajados. Como la mayoría de los que estamos aquí, yo dependo de salarios para mantener a mi familia y cubrir nuestras necesidades básicas. Es por eso que la frustración, la indignación y la tristeza son algunas de las emociones inevitables de sentir cuando se es víctima de robo de salario. Especialmente cuando se sabe que el empleador no cumple con su obligación y sube fotos a las redes sociales en sus actividades de disfrute que demandan una cantidad considerable de dinero. Como trabajadora en la industria de restaurantes, he sido testigo de cómo muchos empleadores abusan de su poder al retener salarios, negar horas extras e imponer jornadas laborales extenuantes y manipular los registros de tiempo para evadir el pago justo. Este sector, que es una parte vital de la economía de Nueva York, se ha convertido en un terreno fértil para la explotación laboral y el incumplimiento de los derechos de los trabajadores inmigrantes. El robo de salario minimiza nuestra motivación y nuestra confianza en un sistema que debería valorar nuestras contribuciones y proteger nuestros derechos laborales. Necesitamos una mayor supervisión y cumplimiento de las leyes laborales existentes, así como la implementación de sanciones más severas, como por ejemplo el proyecto de la ley de Sweat, que nos da el poder como trabajadores en mi situación cuando no me han pagado y además el cheque ha rebotado, de embargar los bienes del empleador para así tener una herramienta que nos permita obtener lo que por derecho nos corresponde como trabajadores en la ciudad de Nueva York. Muchísimas gracias.
I'm sorry. Yeah, I just want to translate what to say. Yeah. Good afternoon, everyone. My name is Sandra Cruz, and I'm an immigrant worker in New York City, and I'm a member of the organization NICE. A few months ago, I worked at a restaurant called La Macarena, located in 48th Street between 7th and 8th Avenue in Manhattan. I had gotten this job in October 2022 through an employment agency, in which they offered me a payment of $16 per hour as a kitchen helper. They had also promised me a different schedule than what they asked me to do when I started. The head chef has been away for most of the time, and I was just starting out when she came back, and she just decided to fire me, to throw me out of the place. When I returned to ask about my payment for the day's work, I found as an answer that they will let me know when the check was ready. It took exactly 2 months to finally receive my payment through a check that when I went to check at the bank, one of the agents told me that they could not do it since they had problems with La Macarena restaurant account. And that this was happening for a long time with other workers from the restaurant. Until today, May 25th, 2023, I have not been able to collect the money from my day's work. Like most of us here, I depend on wages to support my family and cover our basic needs, which is why frustration, outrage, and sadness are some of the emotions to feel when you are a victim of wage theft, especially when it's known that the employer does not fulfill his obligation and uploads photos to social networks of his activities of enjoyment that require a considerable amount of money. As a worker in the restaurant industry, I have witnessed how many employers abuse their power by withholding wages, denying overtime, imposing grueling work hours, and manipulated time records to evade fair pay. This sector, which is a vital part of New York's economy, has become fertile ground for labor exploitation and the violation of the rights of immigrant workers. Wage theft undermines our motivation and our trust in a system that should value our contributions and protect our employment rights. We need more oversight and enforcement of existing labor laws, as well as the implementation of tougher sanctions, such as the SWEAT bill, which empowers us as workers in my situation when I have not been paid and also the check has bounced, to seize the employer's assets in order to have a tool that allows us to obtain what we are entitled to as workers in New York City.
Thank you. All right, I guess let's get started. I like to fancy myself a cocky New Yorker. And yet this issue finds me feeling a deep embarrassment because we're so behind other states who have had a real mechanism, I mean, since the 50s, right? Can you tell me if these states have seen a high rate of frivolous claims?
So, I mean, in preparation for today's testimony, we met with advocates in all of these states, and we asked them how their wage lanes have been operating, how successful they are. Especially in Washington, where they just passed the law in 2021, they've gone through a very, very similar process, and it was very fresh in their minds, where they met the same opposition, and opposition said the same thing that they're saying here in New York, not enough due process and frivolous claims. And universally, with everyone we've spoken to, I mean, it's the same situation as what we see here in New York. There just aren't frivolous claims. Other people who've testified today have talked about the barriers for workers to even bring these claims. It takes a lot of bravery for somebody to walk, to be in these abusive situations for a period of time and then to stand up against essentially their abuser in a court of law in an environment like the kind of environment we've been in for the last few years, where even going to court can sometimes feel like a really risky venture.
Do you and Mr. Fujita, given your experiences, I mean, with the mechanics lien, with the, research on wage liens, do you feel that our SWET proposal, our bill, adequately addresses not only the problem, but outlines a good process to tackle the issue? If we were to pass SWET, do you believe that we would be successful in stemming wage theft?
Absolutely. Just talking to some of the examples of the other states, it's been said that in Wisconsin, 80% of cases go to settlement extremely quickly, and it is because of the power of their wage lien. That's why the Hospitality Alliance keeps talking about how this is going to, how SWET is a problem because it's going to bring employers to the settlement table sooner for better settlements. To my mind, that is the premier feature and benefit of SWET rather than a detriment. So.
Yeah. Well, like I said, from my experience with the mechanics lien and reviewing the SWET bill, which extends this to not just construction workers, people who are working on properties, this is a process that works, and it works quickly. And just going back to that small business owner in Long Island, he had a choice to bond out the lien, and he told me, I can't pay this immediately. I need to go back and look at the records and make sure that that number is correct. He looked at it, he made that decision, and if the number was inflated or if it was wrong, I don't think he would have paid. I think he would have gone the other option. I think he would have used the bond. But this process is fast, it's fair, and I just want to acknowledge the other panelists who have come before have talked about how the DOL really is challenged to collect on some of their judgments. Part of the bill gives this power to the Department of Labor. I hope that they will use it and that people won't have to wait 6 or 7 years to get paid. So I think that in terms of achieving a good outcome, it's proven. It works. Just let other workers use the same tools that are already available to construction workers.
That's wonderful. Well, if your organizations haven't submitted memos of support already, please consider doing so. That would obviously give us an extra nudge that we just might need now that we have 8 days of session left and counting. Ms. Peña, I am so happy to see you here. When I was young, I was a member of Students Against Sweatshops, and it was largely inspired by my mom, who would toil behind a sewing machine for 12 hours a day when I was a little girl, and then bring home with her another bag of things that she needed to sew. And I have long known that poverty is violent, that there is pervasive racism in the way our economy is set up. But that also, unfortunately, like in Ms. Cruz's situation, where she is Colombian, worked at a Colombian restaurant, sometimes even our own, hurt our own community, which breaks my heart even more, if that's possible. But I'm wondering, how does that make you feel about the future as a young person? Now that we're kind of at this post-pandemic, trying to figure out how to shift the paradigm from what it used to be.
Thank you.
Is it not on?
I don't know if it's working, but
yeah, there it is.
Thank you, Senator Ramos, for having me here. I think that in our current state, it makes me feel like the future is bleak, because I've heard cases of wage theft happening in big companies like UPS, DoorDash, and even in some offices where people are salaried workers and they're not getting paid overtime. A lot of people think that because they're salaried workers, they're not entitled to overtime. And so, that's why SWET is so necessary, because, to have our rights trammeled on like this and have no recourse is no future for anyone who's entering the workforce.
I'm sorry that you had that experience at that bar where you worked. I wish I could say you know, that it only happened to you, but it's just so often happens to so many women, so many young women, particularly women of color. I mean, I certainly see it along Roosevelt Avenue in Jackson Heights in my neighborhood. And you're right, it is out of the desperation for work that we have created, that our society has created. So thank you for bringing your perspective here today.
Thank you.
Thank you. Ms. Chung, you know, I once read a while back that actually manicures in New York State were some of the cheapest in the country.
Yes, that is correct.
And yet, somehow, in the most expensive city in the world, right, these employers just can't seem to muster the courage to do the right thing. And I also feel like it's in an industry where sometimes, you know, it's our own folks who are hurting our communities, you know, whether it's the Latino community, the South Asian or East Asian communities. Do you have any, I guess, observations or thoughts in how we can create a more level playing field and raise the standards within our own communities?
Yeah, I think in terms of nail salons, the issue around pricing is really serious and dire in New York, right? When we're comparing it to other jurisdictions across the country, you know, we're just finding that New York just has the lowest prices, and you know, it's coming at the expense of workers, right? It's not like a magical kind, you know, it's not a magic production, right? There is a specific reason why that works as a business model, and it's because workers are not being paid properly. They're not being protected from harmful chemicals at work. And, you know, I do want to share that, you know, we've also heard from employers who do want to do the right thing and want to, you know, protect their workers, pay the proper wages, but they are faced with kind of an existential challenge when, you know, and as you know, right, New York City is so dense in nail salons, and they're having difficulties when the 2 or 3 other nail salons on that same street are charging much less than they are. And so, you know, that is one of the concerns that they bring up, that in order, you know, that they can't compete in this kind of environment. And so I think that needs to be addressed. And, you know, really making the distinction between cheap services that are exploitative versus affordable services that are accessible to our communities.
Mm-hmm.
So I think, you know, sometimes they get convoluted and they get kind of shuffled together, but, you know, there are distinctions around that, and, you know, we want to make sure that we're able to address that kind of, you know, unfair competition that's happening.
Thank you. Ms. Cruz, is La Macarena still open? ¿Todavía está abierta La Macarena? So it's still operating. Do you know of other workers whose wages have been stolen? ¿Sabe de otros trabajadores a los que le hayan robado el salario también?
Sí, de hecho fuimos a NICE, varios compañeros, pero supe que algunos de ellos cambiaron, o sea, que les pagaran en comida, o iban con sus familias a comer varios días, varios meses, hasta que así completaran su
Translate that, please.
Yeah, so she definitely know, because it was her and a bunch of co-workers that went to NICE to present the case, and she's mentioning that one of the reasons about how they decide to pay some workers, it was just offering the lunch or dinner, basically to have like 2 or 3 days of free food and the restaurant as a way to pay them for the time they work there.
That is so elite.
I'm sorry.
Yo pues no puedo hacer eso porque tengo hijos y yo sí necesito, o sea, necesito el dinero, no puedo ir a cambiar pues el dinero por comida.
Yeah, you can translate.
She is saying that she definitely could do the same because she has family, kids, and she needs the money to pay for the basic needs.
Okay. I want to leave very clear that that is illegal,
Totally
in case
illegal.
anybody might be confused. People are only to be paid in money and not in goods for their labor. Have you been able to find work since? ¿Has podido encontrar trabajo desde que saliste de la Macarena?
Gracias a Dios, sí.
¿Y te están tratando mejor? Are you being treated better?
Sí.
Overall, and I'm scared to ask, what has your experience been like as an immigrant here in New York as of late?
¿Cómo ha sido tu experiencia como inmigrante en la ciudad de Nueva York? ¿Quieres saber?
Bueno, al principio las cosas fueron muy difíciles. De hecho, en octubre, cuando pasó lo de la Macarena, mi familia y yo estábamos pasando por un tiempo muy difícil. Yo creo que ha sido el tiempo, lo más duro que hemos pasado como familia, precisamente en ese tiempo. Pero gracias a Dios ahorita las cosas han mejorado. Gracias a Dios hemos aprovechado las oportunidades que esta ciudad nos ha brindado y han sido mejores las cosas para nosotros. El trato, todo ha sido mejor, gracias a Dios.
Yes, since she came here, she's mentioning how hard it's definitely for an immigrant for her to start a life here. And it was exactly during that time, October, when she started working at this place, that she found herself in like the worst situation. And she's saying, thanks God, now is a better time for her and her family.
How did you find NICE? ¿Cómo llegaste a NICE?
Precisamente la persona que me contrató para la Macarena, que era el chef, yo pues lo llamaba a él, porque él fue quien me contrató, pero por órdenes de los dueños de la Macarena. Y pues ya él, cansado de que yo le llamara a él, me dijo, no, Milena, es que yo la contraté, pero no puedo hacer nada. Sé de una organización que ayudan a los migrantes, les asesoran, puede ir allá, y de hecho él nos acompañó a varios de los que trabajábamos con él, porque él se sentía culpable porque él nos había contratado, pero pues nosotros le dijimos, no es culpa suya. Entonces él dijo, lo que puedo hacer es guiarlos allá y acompañarlos en el proceso, dando mi testimonio porque él era el chef, dando mi testimonio de lo que yo vi, porque a él sí le pagaron, pero porque él les dijo que él iba a seguir trabajando ahí siempre y cuando se pusieran al día con él. Pero tan pronto le pagaron, él dijo que él no podía que él no volvía a trabajar ahí con ellos. Pero él sí ha estado pendiente a ver si nos pagan o no.
¿Y hace cuánto fue eso? How long
En
ago was that?
octubre del año pasado.
Bastante reciente. Well, it is clear that greed is quite prevalent, and I'm very thankful for all of you and your efforts and your advocacy and your time as we continue to build our strength to fight back and hopefully get this bill passed. Thank you for testifying today. All right. It is 3:56. We have reached our 10-minute stretch, and we will be back here at 4:06.
Familiar with the extent of wage theft and the wage collection crisis in New York. Because while we have obtained millions of dollars in court judgments for workers and back wages, in many cases, collecting those judgments has been difficult, if not impossible. Too often, in efforts to deny workers of their rightful wages, employers hide or transfer their assets, file for bankruptcy, go in and out of business, or frustrate the justice system by delaying workers' cases or failing to respond or appear in a case altogether. These actions render wage theft laws meaningless. So I'm going to share three examples of ALDEF experiences to show why the SWEAT Act is badly needed to combat wage theft. In one case in which ALDEF and Latino Justice PearlDEF co-counseled in, we brought it against a restaurant chain called Kumgang San, and we secured a $2.7 million judgment for a group of Korean and Latino workers, where the restaurant failed to pay minimum wages and overtime and also stole tips from their employees. However, by the time of judgment, after years of litigation, the restaurant owner had closed his business. his Manhattan restaurant, and then filed for bankruptcy. The restaurant owner also avoided responsibility by transferring his assets to family members. Our legal team had to file a new lawsuit against the restaurant owner for fraudulent conveyances in order to reverse the transfer of assets. And while we prevailed at trial, it took a tremendous amount of time and resources for the workers to actually realize their victory. These are resources that not all workers have access to when faced with similar wage collection challenges. In a different case, Aldef brought a lawsuit against another restaurant, Canton Kitchen, for the owner's failure again to pay minimum wages, overtime, and spread of hour wages. However, the owners closed the business and filed for bankruptcy during the lawsuit. This meant that the worker couldn't discover any of the owner's assets. The owners then promptly reopened the restaurant under a different name, and the worker was unable to recover any of his unpaid wages. And I'll share one more example. Aldef secured a $1.2 million judgment for minimum wages and overtime paid to workers at a garment factory in Chinatown. But by the time of judgment, the owner had fled the country and claimed that he had no money. After several unsuccessful efforts to discover the owner's assets, the workers were only able to obtain $120,000 of the $1.2 million judgment in bankruptcy proceedings. So these are just a few examples of wage collection issues that prevent our clients from receiving the wages that they fought for in court. Other worker clients in the restaurant, nail salon, construction industries have also experienced similar wage collection challenges. Critically, if the reform proposed by the SWEAT Act had already been in place when our clients went to court, including allowing workers to put a temporary lien on an employer's property and making it easier for workers to attach an employer's assets at the start of litigation before assets can be sold or transferred, then workers in so many of the cases that we have brought in and so many of the cases that have happened throughout the state could have accessed legal tools to collect stolen wages owed to them. When workers are unable to collect their stolen wages, basic minimum wage and overtime laws are rendered useless. We must pass the SWEAT Act to strengthen enforcement mechanisms for our state's labor laws and to protect both workers and law-abiding employers. Thank you so much for the opportunity to testify.
Thank you, Ms. Lee. Mr. Medina?
Yes. Good afternoon, Senator Ramos, staff. I am Jose Medina. I am a retired New York State Department of Labor officer. I work in the Division of Labor Standards in the enforcement of minimum wage, overtime, child labor, retaliation cases. Thank you for the opportunity. I'm sorry. Thank you for the opportunity to address the issue of wage theft, a huge problem that has overwhelmed the Department of Labor for many reasons. One of them is the lack of resources, and two is because of the lack of legal resources for the Labor Department to enforce its jurisdiction in collecting wages, unpaid wages. Unfortunately, unpaid wages, it's a way of life for many people, for many businesses. They figure that if they pay $30 a shift, which is very common, $40 a shift in a restaurant, 10, 12 hours. They pay somebody a construction worker nominally $100 a day for working 10, 12 hours. This is, what happens is that not only are they violating the minimum wage law, overtime law, but they're also not paying unemployment insurance, they're not paying for workman's compensation, they're not paying for any health care or any of the other services or benefits that employees may be entitled to. Now, the problem is that the Department of Labor, the Division of Labor Standards, can make a determination after we do an investigation that wages are owed to individuals. However, the problem is that once we have done the investigation, we have approved the determination. I approved it at the first level, then it was approved by the supervisor. Then we would send the determination to the employers, their attorneys, accountants, whoever was involved representing them. and then we try to sit down with them and negotiate a settlement. Now, in most cases, when we had an attorney sitting down in front of us, we were able to come to some agreement and collect money. However, the majority of the cases that we dealt with, where we had no attorney, no accountant, there was nobody there giving the employer any kind of legal assistance or telling them what they needed to do. So in those cases, we found out that the rate of payment was zero. So I always loved it when I got an attorney in front of me arguing the case, because I knew that this attorney would do the utmost to negotiate the best deal for his client, but on the other hand, understood that we were there to enforce the law and we were going to collect one way or another. So we simply had to negotiate the numbers. Wages are never negotiable. That's just the law. We cannot negotiate the wages. We cannot negotiate damages, 25% damages. What can be negotiated is the penalties. If we impose 4 penalties, $4,000, we could negotiate them down. If they pressed us hard enough that they were all broke and everything, we could say, okay, $250, but the wages have to be paid. The problem is that many employees just simply did not bother to show up, simply did not bother to respect the process, and they just ignored the whole process. So when we came up with a determination, we mailed it to them. We follow up with phone calls, 10, 20 phone calls, that I would be the person to make the phone calls at that stage and say, we send you a determination, I haven't received anything, I'll send it to you again. It doesn't cost me anything. I would email it, I will send it again, and they will not answer or anything. So what happens is that at that point, we start a process of trying to get employers to respond. And when the employers do not respond, then there's nothing we can do, and the only thing we can do is what is called an order to comply. Basically, we refer the case to an order forcing them to pay, and if they do not appeal, then an automatic judgment is issued by the department. However, there's nothing automatic about the judgment, because we can wait for 10 years for a judgment to be issued for one simple reason. There is nobody to write up the judgment. So employees will call me every week, every month, and say, Medina, where's my case? And it's like, your case, let me check on the computer, because that's done in Albany. And then I would open up the case and say, well, your case is waiting for a judgment signature. So it's sitting somewhere up in Albany, and I know it's been 5 years, it's been 6 years, but I'll make you a deal. I would tell the employees, if you promise you're not going to open your mouth and tell them who gave you the phone number of the supervisor up in Albany, I will give you that number and you can call them. And then if they say who gave you the number, you can say, oh, you don't know, you were calling Buffalo or somewhere else and somebody gave you the phone number. That was one way for me to put the fire under Albany, but on the other hand, I can't blame Albany when they have 2.5 people handling approximately 9,000 cases or more that have been determined that they are owed payment. These are cases that the department has already made a determination that money is owed. So we have at least 9,000, approximately maybe 15,000 cases. 15,000 cases that are sitting there waiting for someone to pick them up and say, what's the next step? There's a senior, a supervisor, and 2 half clerks, or 2 quarter-time clerks. That's the extent of the staff that is handling this kind of stuff. So it's their job to issue judgments. It's their job to issue appointments with the Industrial Board of Appeals and to handle all of that when the employers are legally appealing the case, which is totally understandable. They're entitled to procedure. They're entitled to have us prove that they are guilty in fact. Well, those are the easy cases, and those are the cases that we spend a lot of time, because someone has shown up and they had said, I'm the owner and I take responsibility and I'm going to fight the case, which is totally fine with us. You know, we did our investigation. We are going to show all the facts of the investigation, and it's up to you and your attorney to prove otherwise. And the judges will make a determination. They sustain us or they discharge the case. So the difficulty is that we have no way, even if we do a judgment, there's no way for us to collect. So a judgment is registered with the clerk in the county where the business is, and then it just sits there. And it will sit there for 10, 20 years because nothing is done about the collection because there's no teeth in the law.
How long?
10, 20 years. So we have cases. I mean, the reason why we have 9,000 cases and maybe up to 15,000 cases, it's because there is no process by which we go and collect the money. I mean, we can put the judgment on, but it just sits there, and as long as the person is not trying to sell that property, nothing happens. So for us, the idea that that there is a mechanics lien and that the owners can be forced to pay, it is really, I think, the best idea in terms of enforcement, because this will give the department and it will give the Attorney General also the tools that once we made a determination, which is a legal determination, it's just after any other investigation that any other law enforcement agency does. That's what we are, a law enforcement agency. Once we make that determination and a judge has said yes, then if we do, for us to have the mechanics lien, it will be great because then we can close down. And we have cases where we have one restaurant in Queens where the employer told the employees, you can go to the Department of Labor, I'll drive you there, because they can't do anything. I have half a dozen other cases there. And it was true. I checked the record, and then I said, oh, yeah, this guy has a lot of other cases. I mean, he even lied about who was the person who owned the restaurant, and he got a friend to sign up for the liquor authority license. So he was using the liquor authority in the procedures during at the Industrial Board of Appeals, where we have a judge and everything is being documented. We found out that some of the employees who were serving beer in the restaurant were actually minors at the time that they were not being paid minimum wage. So we have not just issues of unpaid wages, we have issues of minors selling liquor and all the other things that went on with that. So it is very difficult for us. I mean, we just sat there, you know, it was the judge, our attorney, me, I was testifying, I was the witness, and then the defense attorney, and then, you know, people are testifying that, yeah, I was a minor when, and the gentleman owes me wages, and the guy is, you know, very lackadaisical. It's like, oh, no, it's not me. It's like, you guys can't do anything to me. And so for us, it's very frustrating, demoralizing to be in a situation where it's like, I mean, somebody's actually laughing in your face and saying, so what? What are you going to do to me? Nothing. You can't do it. There's nothing you can do. So now the other thing is that, of course, we have no teeth. There's no teeth in the law for us to enforce, to get the money. And also because there has been such a shortage of investigators. We have made the department, I'm no longer with the department, I'm retired. The department took some positions on policy decisions. For instance, statute of limitations, 6 years. So the statute of limitations is supposed to work when you file your claim, then we go back 6 years and we do an investigation. but because we're so overworked, so if you have employees that are owed money for 6 years, so instead of doing an investigation for 6 years, we're doing an investigation for 3 years in order to expedite the case. So, but in the meantime, it took us 3 years to get to the case. So the case was filed in 2010. The employee has a right to collect his wages from 2004, but we didn't get to the case until 2013. So
We should peg it to inflation.
so, I mean, how much money is that worth? It's been 9 years already since the person wasn't paid. So we're only going to collect money on 3 years. So that's one of the things that we have done to expedite work. I mean, something else that that the department did also was, in the restaurant industry, what we used to do was we would go and figure out the schedule of the restaurant. You know, we would just pick up the menu and say, so you're open from 10 a.m. to 10 p.m., Monday through Sunday. Yes. So how many people you have? Oh, I have 5 employees. So you have 5 employees. How many tables you have? You have 40 tables, or you have 30 tables? And so how many people do you have to, what kind of shifts do they, oh, they all work 8 hours. Nobody works more than 8 hours. So if everybody works only 8 hours, you will need a shift, you will need not 5 people, but you will need 20, 30 people to work. In order for you to stay in business, you need 30 people. So where are the other 25 employees? Oh, no, I don't have 25 employees. Where are the records? There are no records. So we used to do what was called computations for unknown employees. So we would compute, because we had made a determination, just like unemployment insurance does, that if you have certain business, a certain size, you have a certain number of people, then therefore you have to be paid so much in employment insurance. So we had the same, procedure. So therefore you owe the Department of Labor for 25 unknown employees. And when those people come forward and make a claim with us, there will be money in the system to pay those people. Well, the department found that, you know, it wanted to make collecting money easier. It didn't make collecting money easier at all. It just meant that restaurants gotta, you know, any restaurant owner can say, oh, I only have 5 people, and there is no proof.
Mm-hmm.
Where are the bodies? Dig up the bodies. So, and then some of the other things that we did was, for instance, the department also has closed the information desk, information office. The department has always wanted to close the information office because it needed to have 3 or 4 people manning the office. So when COVID came, that was the perfect opportunity to close the division, to close the information office, and to stop taking taking care of people from coming in and filing claims at the office, and then we would help them, whether it was in Mandarin, Korean, Spanish, Italian, whatever it is. So these are all reasons why, I mean, 2 things. One is the lack of funding at the Department of Labor, and 2, the lack of teeth. And the SWEAT Act will give the Department of Labor the teeth that they need in order to enforce collecting unpaid wages from the people that are there. Because one of the things we are very good is when there was a claim and we followed through, when we finally got through to the claim, is we stayed on it like bloodhounds. So we stayed on it until we collected or the people disappear, which, you know, they did often. Mm-hmm. So I'm very happy to see that you have taken it upon yourself, and you're giving them the tools, and also because we need to make the Department of Labor accountable, the commissioner accountable for all the inactivity, and basically because that's the person who's responsible. And if she's not doing her job, then it is very difficult for the employees. We have a saying in the Department of Labor, who takes care, or who protects us, no, who protects the people who protects the employees. So there isn't anybody protecting the DOL employees, because it is not the commissioner and it's not the top management. It's for them, it's just another political job, which is a very sad story.
Okay.
Thank you.
Thank you, Mr. Medina. Ms. Mejia.
Buenas tardes, miembros honorables del Senado y nuestra senadora Jessica Ramos. Mi nombre es Sandra Mejía, soy inmigrante de México, residente del Bronx por muchos años. Trabajé durante 2 años en Liox Wash Supply Laundromat, ubicado en el Upper West Side de Manhattan. Tenía que lavar, secar y doblar 80 libras de ropa por hora. Durante mi empleo, yo trabajaba 6 días a la semana y me pagaban solo $10 la hora, sin pago de horas extras y días de enfermedad no pagados o tiempo de descanso, una clara violación de la ley de hora y salarios. Antes y durante de la pandemia, mis compañeras de trabajo y yo sufrimos malas condiciones de salud y seguridad. Trabajamos en el sótano sin ventilación, sin calefacción, en el invierno, sin salidas de emergencia, sin papel higiénico y sin equipo de protección durante la pandemia. No teníamos espacio para el distanciamiento social o protocolo para la desinfección del lugar de trabajo por la agencia. Nosotras, las trabajadoras, estuvimos expuestas al robo de salario y al contagio de COVID. Cuando me enfermé de COVID, el gerente me dio solo un Tylenol y me dijo que siguiera yo trabajando. Durante la pandemia, el 25 de noviembre del 2020, decidí organizarme con mis compañeras de trabajo. Exigimos mejores condiciones pidiendo que el empleador nos pagara el salario mínimo. Entregamos una carta pidiéndole al empleador que negociara y devolviera los salarios detenidos ilegalmente. El empleador no quería negociar los salarios robados por lo que demandamos a la compañía. El empleador aún no ha respondido al caso legal. Los dueños decidieron aprovechar la debilidad en la ley laboral después de demandar a la compañía y ganar nuestro sindicato independiente certificado por la NLRB. El empleador cerró la lavandería, despidió a todos los trabajadores y se llevó todas las máquinas. Los dueños cerraron una segunda ubicación y alquilaron otro lugar con el nombre de otra compañía. Le cambiaron el nombre. El 27 de mayo del 2021 ganamos nuestro caso de robo de salario en la corte por defecto. El juez determinó que la compañía me debía a mí y a mis otras 5 compañeras de trabajo $809,585 con 30 centavos, casi $1 millón. Como respuesta, el empleador decidió declararse en bancarrota y evitar la responsabilidad. Hasta ahora no hemos recuperado un solo centavo. Recolectar el dinero que ganamos en un desafío. Tuvimos que encontrar un abogado de bancarrota y todavía estamos luchando porque sabemos que este empleador continúa operando en Brooklyn y todavía puede robar salarios de otros trabajadores. El robo de salario afectó drásticamente mi vida, la de mi familia. Nadie nos devolverá el tiempo, el trabajo y el ingreso que perdimos. Estoy aquí hoy pidiendo que se pase el proyecto de ley Sudor para detener este abuso. Necesitamos resolver de raíz esta epidemia llamada robo de salario. La solución una protección robusta como sudor, línea de empleadores deben respetar las leyes. Si los trabajadores pueden colocar una línea en los activos de los empleadores durante un caso legal, eso garantiza que los trabajadores perjudicados como yo puedan recuperar los salarios perdidos. Si esta ley hubiera existido cuando mis compañeras de trabajo y yo exigimos nuestros derechos, otro habría sido la historia. Este proyecto de ley evitaría que los malos actores cometan robo de salarios como ocurrió en la lavandería Líos Wash Supply. El proyecto de ley Sudor puede terminar con el ciclo de la pobreza y el abuso de causa de el robo de salarios.
Good morning, honorable member of the Senate and champion Senator Jessica Ramos. My name is Sandra Mejia. I am immigrant from Mexico and resident in Bronx for many years. I worked for 2 years in the Leon's Wash Supply Laundromat in the Upper West Side, Manhattan. During my employer, I have to wash, dry, and fold 80 pounds of clothing per hour. I work 6 days a week, and I was paid only 10 per hour, without payment on overtime, basic leave, or meal break, clean violations of the wage tag and our law. Before and during the pandemic, my co-worker and I was suffer terrible health and safety conditions. We work in a basement with no ventilation, without heating in winter, no emergency exits, and no toilet paper, protection equipment During the pandemic, we have no room for social distance or protocol for workplace extension. The workers were exposed to the COVID and suffering in wage tag. When I got sick with COVID, the manager gave me Tylenol and told me to continue to working. During the pandemic, on November 25, 2020, I decided to organize it with my companions. We demand better conditions, asking to the employer pay us at least the minimum wage. We deliver a letter, requires the employer to negotiate and return the salaries held illegally. The employer did not want to negotiate. They stole salaries, so we sold the company yet. The employer has no answer to legal case. The owner decided to take advantage to the weakness of the labor law. After demanding the company and winning our independent union certificate by NLRB, the employer closed down the laundromat, fired all the workers, and took all the machines from the laundry. The employer closed down the second location and renewed another place with another company name. They changed the name. On May 27, 2021, we won our wage tape case and a court by default. The judge determined the company owner, my 5 co-workers and me, $8,019,585.30 and almost $1 million in response to the employers decide to declare bankrupt and avoid responsibilities. So far, we have yet to recover a simple penny, collecting but the money. We are in as challenging. We had to find bankrupt law. Will still fight because this employee continue to operate in Brooklyn and can still wage for the other workers. Wage tape affect my life and my family. As life extensively, nobody will return to time, work, and income we lost. I am here today demanding the passing the SWAT to stop this abuse. We need to resolve this epidemic, college wage tape, from the root. The solution is robust protection has SWAT. We know employers must respect the laws. If your workers can place is late and employers assent during the legal case, the guarantees that Harmed workers can recover lost wage. If this law had existed when my co-workers and I demand a rise, I will be sharing another history. This bill will prevent bad access for committing wage theft, has happened at Lions Supply Suite. Suite can be cycling and perverting and abuse that cause wage theft. Thank you.
Thank you. Now, is Yolanda Castello with us?
She's not, but she left her testimony to be read.
Okay. We can include it with the written testimony, the other written testimony that we've received, just in the interest of time, if that's okay. Then we'll go with Carlos, Don Carlos.
Buenas tardes, señora senadora. Buenas tardes, señora señores
Buenas tardes.
presentes.
¿Sí está la lucecita verde prendida?
Sí, acércate. Buenas tardes, señora senadora. Buenas tardes, señores presentes.
Caballero, voy a pedirle que hable fuerte, como si hubiera desayunado.
Todavía no desayuno. Y estoy un poquito ronco también.
Bueno, si necesita agüita, nos deja saber.
Mi nombre es Carlos Faicán. Soy miembro de NICE desde hace 4 años. Mi trabajo es carpintero en madera. Trabajé en un taller de carpintería en Másped haciendo unos mesones y otros artículos de madera, y me daban el plano o dibujo de lo que me pedía mi supervisor, ya fuera mesa, muebles para baño, etc. Él me pidió que trabajara en 3 mesones de 1 pulgada 5 octavos. Cuando estuvimos terminando, me alegó que me había pedido 3 mesones de 1 pulgada 7 octavos, para finalmente hacerme responsable de haber hecho un mal trabajo, y me descontaron de mi salario el trabajo mal hecho. Según ese fue el pretexto para que mi caso terminara en robo de salario, el día 20 de mayo del 2022. Me presenté a cobrar mi salario y me llevé la sorpresa que el empleador me dijo: ¿sí sabes que ese material es caro? Te lo voy a descontar por haber hecho mal el trabajo. Me molesté y le dije que no podía hacer eso. Yo le dije: yo trabajo por necesidad y no por gusto. Hicimos de palabras y me dijo que no había nada, que no había nada el material, que había dañado el material. Y en vez de darme mi salario de $1,200 que recibía por semana, solo me pagó $500. Yo me enojé, me puse bravo, nos hicimos de palabras vulgares y groseras, y posteriormente nos vamos a los golpes. Aunque el único agredido físicamente fui yo, y al final me echó de la oficina. Quiero pedir esta parte para que quede muy claro. Yo me acerqué a mi empleador para reclamar mi salario y él me agredió. Yo exigí que si los mesones no servían, que me los diera para cubrir la parte faltante de mi salario, a lo cual se negó y me fui con mis $500. Aunque lo reporté a la policía, no llegó en el lapso de 1 hora. Yo no había nadie en el taller, decidí irme. La policía me habla cuando yo ya iba rumbo a casa. Me sentí impotente sin saber qué hacer y pensé dónde vine a caer, y preguntándome qué podía hacer para recuperar mi dinero, pensando que iba a hacer porque ya no tenía para pagar mi renta, no tenía trabajo. Es muy difícil esa situación. Cabe mencionar que esto es solo un ejemplo, pero el robo de salario me ha pasado 2 veces. Gracias. Acá está, sorry. Sé que otras personas han pasado por mi mismo dilema, y si a mí me ha pasado 2 veces, sabemos que es un problema sistemático. Quiero asegurar que las compañías responsables de estos robos no sigan explotando a los trabajadores. Por eso necesitamos mejores leyes como la ley de SUED, que nos daría una herramienta para poder reclamar. Tenemos que poner fin a estas malas prácticas porque es una injusticia para la comunidad de trabajadores inmigrantes. Muchas gracias por escuchar mi testimonio.
My name is Carlos Osvaldo Faitan. I have been a member of NICE for 4 years. I work as a carpenter. I worked in a carpentry shop in Maspeth making some countertops and other wooden items, and they gave me the plan or drawing of what supervisor asked me for. Whether it was a table, bathroom furniture, etc., he asked me to work on 3 tables of 1 inch 5/8. When they were finished, he argued that he had asked me for 3 tables of 1 inch 7/8 to finally hold me responsible for having done a bad job, and they deducted from my salary the job poorly done, according to him. That was a pretext for me, my case to end in wage theft. On May 2022, I went to collect my salary, and I was surprised that the employer told me, "Do you know that this material is expensive? I am going to discount it for having done a bad job." I got annoyed, and I told him that I couldn't do that. I told him I work out of necessity and not for pleasure. So we started to exchange some strong words. He told me that I had damaged the material, and instead of giving me my salary of $1,200 per week that I receive weekly, he only paid me $500. I got angry. He used vulgar and rude words, and later on we went to blow, although the only one physical attack was on me. And in the end, he kicked me out of the office. I want to repeat this part so that is very clear. I approached my employer to claim my salary, and he attacked me. I demanded that if the counters weren't working the way he is supposed to have them, he demanded them back to sell later on and recover part of his salary. The manager refused to give it to me, and he only gave me $500 for my whole week that I supposed to get $1,200. Although I reported it to the police, they didn't arrive within an hour. There was no one in the workshop anymore. I decided to leave. The police called me while I was going home, on my way home. I felt helpless, not knowing what to do, and I thought where I came from and wondering what I'm gonna do to get my money back, thinking what I was going to do, because I no longer had the resources to pay my rent. I didn't have a job, and that situation is very difficult. It is worth mentioning that this is just not an example. Wage theft has happened to me 2 times. I know that other people have gone through the same dilemma, and it has happened to me twice. We know that it is a systematic problem. I want to make sure that companies responsible for this theft do not continue to exploit workers, so we need better laws. I support SUED law that will give us tools to reclaim our stolen wages. We have to stop these bad practices because it is an injustice to the immigrant workers community. Thank you very much for listening to my testimony.
Thank you. Ms. Pacheco?
Buenas tardes, senadora. Buenas tardes a los presentes.
Mi nombre es Luz Mercedes Pacheco Rojas. Soy una trabajadora inmigrante y soy miembro de NICE. NICE es una organización comunitaria en Nueva York que lucha por los derechos de los trabajadores inmigrantes sin importar su estatus migratorio. Trabajé en una compañía llamada NGC Clean Service Corporation, en el área de limpieza y de remoción de construcción en varios lugares, en la 224 West 124 Street, Harlem, en la 1850 Jerome Avenue y en la 310 de Grand Concourse. En el Bronx, trabajé realizando construcción, pintura, demolición y limpieza de construcción para una compañía, en un horario de 8 a 5:30, de septiembre y octubre del 2022. Fue un trabajo arduo por 12 días y cuando recibí mi cheque fui al banco con la emoción de poder cobrar mi salario. Lo que obtuve fue un cheque sin fondos. Me sentí devastada y burlada. Estuve trabajando junto a muchas compañeras y compañeros fuertemente para dejar el edificio reluciente y brillante por cada espacio y cada rincón del mismo, hasta que la supervisora diera su aprobación. Fueron muchos baños, muchas cocinas, muchos apartamentos dejados listos para ser arrendados. En muchas ocasiones la supervisora hasta nos grababa con su teléfono mientras hacíamos las limpiezas y las subía a las redes sociales burlándose de nosotras. Teníamos que hacerlo porque teníamos temor a represalias si no accedíamos a las órdenes de nuestra supervisora y teníamos que permitir que nos grabara, aun cuando no estábamos de acuerdo con esta acción, porque nos sentíamos humilladas. La falta de pago me afectó porque no pude hacer frente a mis necesidades básicas personales, pagar mi renta a tiempo, y se me hizo muy difícil comprar alimentos, pagar el tren. Fueron momentos difíciles, sin dinero y habiendo trabajado duro con todo mi empeño. Aunque le pedí al jefe mi dinero, no me ha pagado hasta ahora y por eso estamos aquí, ofreciendo mi testimonio como prueba que el robo de salario es un acto cobarde en contra de personas vulnerables como nosotros los emigrantes. El robo de salario es una injusticia sistemática. No es justo trabajar y no recibir pago. No es justo trabajar con compañías que no nos pagan y que nos explotan, en donde los empleadores como este que cambian el nombre de sus compañías o que ocultan bajo la impunidad continúan robándose el salario. Por eso estamos aquí, porque apoyamos la aprobación del proyecto de ley SWET, porque en casos como el de NGC, que fuimos afectadas muchos trabajadores porque tenemos casos reportados en NICE, que este empleador ya había engañado hace 2 años a 10 trabajadores bajo otra compañía con un nombre diferente, y no es correcto que él simplemente abra otra compañía para seguir robando el salario. Se necesitan leyes más fuertes para corregir estas injusticias y hacer que se cumplan las leyes. Queremos justicia para los trabajadores. Gracias por escuchar mi testimonio.
Good afternoon, Senator Ramos, for having us here. My name is Karen Vargas, Workers' Rights Coordinator at NICE, located in Jackson Heights. I'm going to do the translation, make the translation for Luz. My name is Luz Mercedes Pacheco Rojas. I am an immigrant worker, and I'm a member of NICE. NICE is a community organization in New York City that fights for the rights of immigrant workers regardless their immigration status. I work for a company called NGC Cleaning Services Corporation in the area of construction, cleaning, and removal at various locations: 224 West, 124th Street, Harlem, and 1850 Jerome Avenue and 310 Grand Concourse in the Bronx. I work doing construction, painting, demolition, and construction cleaning for a company from 8 a.m. to 5:30 p.m. in September and October to 2022. It was hard work for 12 days, and when I received my check, I went to the bank with excitement of being able to collect my salary. What I got was a bounce check. I felt devastated and mocked. I was working hard together with many colleagues to leave the building shiny and in every space and corner of it until the supervisor gave her approval. There were many bathrooms, many kitchens, many apartments left ready to be rented. On many occasions, the supervisor, when record us, even record us with her phone while we were doing the cleaning and uploaded them to social network, making fun of us. We have to do it because we were afraid of retaliation if we did not comply with our supervisor's orders, and we had allowed her to record us, even when we did not agree with that action because we felt humiliated. The lack of payment affected me. I could not meet my basic personal needs, pay my rent and on time, and it became very difficult to buy food, pay for the train. It was a difficult time without money and having worked hard with all my effort. Although I asked my boss for my money, he has not paid me so far, and that is why we are here, offering my testimony as a proof of wage theft. That wage theft is a cowardly act against vulnerable people like us immigrants. Wage theft is a systemic injustice. It's not fair to work and not get paid. It's not fair to work with companies that do not pay us and exploited us. We're employers like this one who change the name of their companies or who hide under impunity and continue to steal our wages. That is why we are here, because we support the approval of the SWEAT bill, because in cases like NGC, many workers were affected because we have cases reported in NICE that this employer had already stolen wages from 10 workers 2 years ago under another company with a different name. And it's not correct that he simply opened another company to continue stealing wages. Stronger laws are needed to correct this injustice and enforce the laws. We want justice for workers. Thank you for listening to my testimony.
Thank you. Thank you for sharing all those worker stories. I can't imagine I can't imagine it being easy, but I'm thankful. It's clear that there's a lot of dehumanization that happens in so many of these workplaces. Thank you for being here and for sharing your experience. Ms. Lee, what you outlined seemed to be quite textbook what we're trying to avoid here altogether, in terms of the transference of, if I remember correctly, the transference of the assets, from the employer. I mean, it sounds like, based on your experience, SWEAT would make a tremendous impact in the way you do your work.
Absolutely. I mean, I think you heard just now that it's not fair to work without pay. It's also not fair to get a court-ordered judgment for millions of dollars and not be able to get that money back. And so I think, so the SWEAT bill would absolutely help so many workers put some teeth really into wage theft laws and ensure stolen wages.
Mr. Medina, I'm happy you're here because, obviously the DOL didn't come to testify in person, although, again, I do want to state for the record that they submitted written testimony, but it's given us a glimpse into what's actually happening at the Department of Labor, and the huge advantages to the employers given the lackadaisical system, even though I don't even feel confident using the word system. So you said that there were approximately two and a half people handling 900 cases?
9,000 cases.
9,000 cases.
And it's possibly 15 depending on how you count them.
And
So
the 9,000 cases are cases where it's already known that money is owed.
Yes, those cases we already made a determination and they went to District 13. Once a case goes to District 13, that's for legal action by Albany to register the cases. Either people pay or the department has to file a judgment with the county clerk where the business is located.
Okay, and based on your expertise, do you believe that SWEAT would help this situation? Is there more that needs to be done for the Department of Labor to function the way we'd like it to?
Well, there's a lot of other stuff, but I mean, in terms of what this bill is trying to achieve, which is to give teeth to the division, which is in charge of enforcement, because one of the things that we do, me as a senior investigator, is to, once we make the determination and we issue it to the attorneys or to the owner, then it's my job to collect the money. So that will give us an option of, registering a lien and saying it's like we are actually going to collect, and not being able, or the option of me not being able to do anything, but simply to pass it on to District 13, and then District 13 just doesn't really exist.
Well, from one District 13 to another, we certainly do need to beef up the Department of Labor and ensure that there's proper funding so that we can have the appropriate personnel and ensure that they're appropriately compensated and well-treated themselves.
Well, that's another story.
That's a different hearing. All right. Well, thank you. In the interest of time, I'm going to try to keep it moving, so thank you for joining us, and I'm going to start calling up the next panel. Okay. Panel G, we have David Kolodny from Catholic Migration Services, Francisca Ureña, Home Health Aid, National Mobilization Against Sweatshops. Same organization, we have Samantha Isales, organizer and service worker, and Carlos Herrera, a restaurant worker and organizer. Come on up, or come on down, I should say. David, you're up first. I am sorry, but we are now, it is now 5 o'clock. This hearing has now been going on for 7 hours. And I am trying to attempt, bye, love you guys. I am going to try to attempt and make my evening events. David. You're on.
Is that working?
Yes.
Great. Good afternoon, Senator Ramos.
Good afternoon.
Thank you very much for convening today's hearing and for all your work to combat wage theft. Catholic Migration Services is pleased to submit this testimony in support of the Securing Wages Earned Against Theft Act, the SWEAT Act. Catholic Migration Services is a 501c3 nonprofit corporation and an affiliated agency of Catholic Charities Brooklyn and Queens. Each year, Catholic Migration Services provides free legal services to more than 4,000 low-income New York residents on immigration, housing, and employment matters, as well as providing valuable Know Your Rights trainings and education that enable people to learn and enforce their rights. The Catholic Migration Services Workers' Rights Program counsels and represents hundreds of low-wage workers each year. Our clients come to New York from all over the world and work hard to support themselves and their families. Our clients typically work very long hours in a variety of industries in New York City, on Long Island, and in Westchester County, including domestic work, restaurants, construction, retail, healthcare, and other service industries. Sadly, the common experience shared by this diverse group of workers is wage theft. Many of our clients work for less than the New York State minimum wage and without overtime pay, sometimes for years at a time. And many of our clients work and don't receive any pay at all for days, weeks, or even months of work. Some examples of this wage theft can be seen in cases that our office is currently litigating in the local courts. And I'll also just say, you'll hear from some of our clients later this afternoon, so I'm going to try to keep my comments short. We represent 2 longtime employees of a restaurant on the Upper West Side of Manhattan. One of our clients has worked at the restaurant since 2014. They have performed a variety of functions, including cleaning, dishwashing, and delivery, and have worked between approximately 70 and 80 hours per week. In return, they received wages of between $3.35 and $6.88 per hour during the 6.5-year period preceding our filing of the lawsuit. And of course, no overtime pay. Together, our clients were cheated out of approximately $490,000 in wages during that 6.5-year period. The family that owns the restaurant also owns a home and several other restaurants in New York City. But unfortunately, without Sweat, we cannot do anything to prevent the owners from hiding or transferring their assets while our case moves through the court process. We represent 2 former employees of a Brooklyn bagel shop who worked 60 to 70 hours per week for years. In return, they received weekly salaries that fell below the minimum wage and received no overtime premiums required by the New York labor law. Together, they were cheated out of approximately $175,000 in wages during the 6-year period leading up to the filing of our case. We represent 2 former employees of a Queens used car dealership who worked 6 days per week detailing cars. They received weekly salaries that fell well below the minimum wage and again received no overtime premiums required by the New York labor law. While the case was pending, the owners closed the business down and continued operating a separately incorporated used car dealership a few blocks away. We represent a worker formerly employed by a Queens medical clinic who was paid less than minimum wage throughout his employment and was not paid at all for the final 5 weeks of his employment. When he asked for his wages, his employer threatened to report him to immigration authorities. We also represent 5 delivery workers who worked for Dim Sum Palace. Some of those workers are here, and hopefully you'll hear from them later this afternoon. These examples are not out of the ordinary. They represent far too common working conditions faced by low-wage workers. Further, the clients we see in our office are very rarely the victims of innocent mistakes and technical violations of the law. What we most often see are employers that have made no effort to learn of their obligations under the wage and hour laws, or were aware of their obligations and actively took steps to cover up their violations by creating fraudulent payroll records. Sadly, the justice system too often does not work for low-wage workers who experience wage theft, as we've heard today. When low-wage workers assert claims to try to recover their hard-earned wages, they are very often unable to collect what the courts or the Department of Labor deem to be owed. Far too often, workers win judgments and never collect a dime. And because workers and worker advocates know that employers may engage in a variety of tactics to make themselves judgment-proof, workers often settle their cases for far less than they should have to. Workers and worker advocates know that if they spend 2 to 5 years in court, or sometimes longer, the employer may use that time to hide their money so that there is nothing left to satisfy a judgment. The strategies that employers use are often not illegal. I periodically receive an advertisement from a company that provides continuing legal education for attorneys so that attorneys can counsel their clients on making themselves judgment-proof. In fact, at 3:41 p.m. this afternoon, I received an email from Ross Dale, CLE. Just a little over an hour ago during this hearing, I received this email, and it was titled, "Protecting Assets from Lawsuits and Judgments." And it goes on to state the many ways in which they will help lawyers help their clients to hide their money. And it says, and I quote, "Specific emphasis will be placed on making clients appear judgment-proof." And this is part of the reason why the Sweat bill is so important. In my written testimony, I detail why the attachment provisions that are in the bill, sections 28 to 31, and the amendments to the business corporation law and limited liability company law are so important and can provide critical tools for workers. I'm not going to restate what's in my written testimony in the interest of time. And obviously, the wage lien section of the bill is absolutely critical and has rightfully been the focus of much attention at today's hearing.
Yes, indeed.
It's important to know that the SWEAT bill can provide the tools needed to hold perpetrators of wage theft accountable, and that it can accomplish this without increasing the cost of doing business. The bill does not require every business, for example, to purchase wage bonds or insurance against wage claims, or impose other requirements that could make it more difficult for businesses to succeed. It was discussed earlier that the Department of Labor could use additional resources, and we certainly support more resources being provided to the Department of Labor. However, those additional resources, without the tools that are available in the SWEAT bill, will still make the Department of Labor have a very difficult time in collecting the money that it deems to be owed. And Senator Ramos, I know that you know this, and you've patiently been here all day, and I applaud you for that. But I want to say this to your fellow legislators and to Governor Hochul, and I hope they'll hear it. The current state of affairs in New York with wage theft is a disgrace. It is an utter disgrace. It's a disgrace that people work long hours to put food on the table, to pay their rent, get medical care, and meet other basic needs, and then don't get paid for their work. It is just unacceptable. So Catholic Migration Services strongly urges the Senate to pass the bill, and we are available, as always, to discuss the particular provisions as well as any other relevant matters. Thank you.
Thank you, Mr. Kolodny. Mr. Song? Welcome.
你好，我叫宋德平。
你好。
从2005年开始在美家工作，美家指甲店工作。工资盗窃对于每个指甲工人来说话是一个非常严重的事情。许多年来，老板不干法律发工资，因为他们不怕法律，不怕政府。10多年来，我们的同事在芭比电影工作，在长岛的一个芭比电影工作。首先把地址先告诉一下。我带领他们反对这个工资盗窃，对我们华人工资来说的话是非常非常重要的事，因为我们这个韩国老板他歧视华人，而且在工作当中的话，他们打我们骂我们。10多年来，我们的同事在芭比店遭受了各种的歧视。我们的老板的名字叫做 Frank 和 Rosemary。拥有了许多的指甲店，他们有很多的连锁店，包括有很大的那个 house。他们非常有钱，他们拥有几家房产所，但是当我们的起诉老板的时候，他们开始出售和转让他们的房子。我们的律师用法律的方式阻止他们。但是由于法律的薄弱，我们的律师也没办法阻止。老板转移了所有的财产，最后虽然我们赢得了47万美金的判决，但现在为止我们只能收到10万美金。在我们获得判决10年之后，从我们的律师得知，老板正在拍卖我们的所判决冻结的房产。事实证明，在我们判决的前几个月，他们将房子的产权转移给其他人。10年后，我们仍然没有拿到我们应有的工资。我们的案件非常有名，因为我们的工人非常直言不讳，并被用作为制定什么 SWEET 法案的一个案例。今天我们在这里为确保每一个保护血汗工厂老板利益的政客和老板都看到我到我们不懈努力地追求我们的工资，并通过 SWEET 法案。我公开反对我们的老板，是因为我不想受到欺辱。在美国，为什么法律如此的薄弱？当我们试图改变法律或其他 强大的是，政府无力为我们做任何事情，我们为什么法律只能保护老板？我听说餐厅的老板诉苦，说老板也要正义，那我们的正义在哪里？如果我们对违犯和守法的老板都一视同仁，那么当然所有的老板都不会遵守法律。你们是我们选出来的官员，你们必须尽职尽责。我将继续为追讨被盗工资而战。如果我不成功，因为我们不能加强法律，那么必须负一定责任。谢谢。
谢谢。
I would translate. Hi, my name is De Ping Sung. I have worked in nail salon since 2005. Wage staff is very bad for nail salon worker. Many bosses do not pay wage according to the law. They are not afraid of law or government. More than 10 years ago, I stand up with my co-worker at Bobby Nail against wage staff and discrimination against us Chinese workers. My boss, Frank and Rosemary, owned many nail salons and were very rich. They had a big house in Long Island and owned several other property. But when we sued the boss, they started to sell and give away their property and store. Our lawyer tried very hard to stop them, but because the law is so weak, they were unable to stop them from getting rid of all the money. In the end, we won the judgment of $470,000, but we have today only able to collect $100,000. 10 years after our judgment, we found out from our lawyer, the boss, is foreclosing on the Long Island house. We leaned after the judgment. It turned out 2 months before our judgment, he transferred the deed to the house to someone else. 10 years later, we still have not got our wages back. Our case was very famous because we, the worker, are very spoken and used as an example to help make the sweat bill. I am here today to make sure every politician and every boss that is protecting sweatshop bosses see me and see that we have not and will not stop trying to get our wages back. And we want to pass the sweat. I spoke out against my boss because I didn't want to be bullied. In the U.S., the law are so weak, and when we go to change we need to change the law in order to make them stronger. The government is incapable of helping us. Why are the laws only protecting the bosses? I heard the restaurant boss are saying there's no justice for the bosses. Where is the justice for us? If we treat the boss who break the law and the boss who obey the law the same, there's no reason for any boss to follow the law. You are our elected official. You must do the right thing. I will keep fighting to get back my stolen wages, and if cannot, because the law is weak, we need make our law stronger. Thank you.
Thank you. Ms. Isales and Mr. Herrera?
Okay. Hello, everyone. My name is Samantha Isales. I'm going to try to make this quick because I have to run to get my son from school. So I'm coming to speak with you as a resident of the city of New York and a member of Youth Against Sweatshops, a youth-led organization. When my family moved to New York City from the U.S. colonized island of Puerto Rico 17 years ago, the belief of the American dream was at the forefront. We thought that with hard work and a job that pays livable wages, we've had the financial prospers that would allow us to access food and shelter, something that continues to be an ongoing struggle for Puerto Ricans on the island. This belief of the American dream, however, is one that many people are slowly waking up from as we realize how the state has subsidized wage theft. The wage-stealing bosses who exploit our weak labor law are the only ones who actually benefit from the American dream. They're the ones who get to build their wealth by profiting off the unpaid labor of workers whose dreams are shattered each day as they continue to be exploited by their employers for every bit of their health. This is really why industry representatives like the New York City Hospitality Alliance, headed by Melba Wilson, continue to hold such strong opposition to the sweat bill. Growing up in New York City, I have witnessed time and time again how prevalent wage theft is. When I got my first job at a hair salon when I was 14, I was paid $10 a day, $10, by my employers and was asked to make the rest of my wages via tips. I knew this was illegal, being that minimum wage at the time was $7.25 an hour, but the fear of speaking out against my boss, who, by the way, had a much larger support system than I did and had money to fall back on, it was a huge risk. So it was either being unemployed or underpaid, and of course I went with the latter. During my senior year of high school, I worked in a pizza shop in the Rockefeller Center where the owners underpaid my immigrant colleagues and myself so they could make more money to pocket. This, of course, directly affected me too because I was expected to stay on my tiptoes, being that cheaper labor could be hired if I did not do as my boss said, including working 12-hour shifts with no overtime pay or any lawful 15 or 30-minute breaks. This perpetuated a culture of racial divisiveness and competition between my colleagues and I, which only benefited our boss, whose restaurant continued to be in operation thanks to our labor. Fortunately, we were able to come to terms with the fact that our boss was actually the bad guy who was intentionally stealing our wages and benefiting from our division. Not much time passed before most of the staff was replaced by new workers, which is also a tactic used by wage-stealing bosses to prevent workers from speaking up and organizing. Essentially that's why they don't want SWEAT to pass, because they don't want workers to be encouraged to organize and hold them accountable, wage theft. And then I worked at an upscale gym on 14th Street where there were ongoing payroll issues the entire time that I worked there. Myself, physical trainers, and other staff were shocked to find out that our job was suddenly closed down after the owners filed for bankruptcy without giving any notice to any of us. Many were left clueless as to where the money went, as they never received the final paycheck. And unfortunately, I quickly learned that the company had pocketed my own money that I had believed to be paying in taxes, which resulted in me having to pay the IRS back and having no way of finding out where my bosses were, since they disappeared off the face of the earth, which is what happens when we don't have SWEAT. As it often happens, the advice that I was giving by peers whose wages were also being stolen was that perhaps things would get better if I pursued higher education. Here I am, a bachelor degree later, and to my misfortune, I witnessed the same happening in office jobs where bosses were asking me and my colleagues to take on more work, yet refused to pay us for that extra time. When we called them out after years of doing such work for free, they refused to negotiate or pay us. These are just a few of the extensive list of examples myself, one worker, can share about wage theft. For a very long time, I believed wage theft was just how business was done, so I avoided speaking up against this for fear I would be fired. I have to admit that the reality is that I was right. Wage theft is how business is conducted in New York City, and it's a crime, truly, and it should be a punishable crime, just like any other crime is. Business owners and wealthy people do not deserve special treatment and do not get to decide when SWEAT is passed. Workers will continue to speak up and stand against wage theft and those who commit it. How many times do we hear excuses about the reason SWEAT has not passed? The New York City Hospitality Alliance very loud and proudly shares on their social media the huge accomplishment they have made by stopping workers from collecting their stolen wages via their opposition to SWEAT. They should be ashamed about their hypocrisy. I am calling on Melba Wilson, a woman of color, and all of the members who claim to care about workers of color to do the right thing once and for all and to support the passing of the SWEAT bill. Workers would not negotiate wage theft loops with the New York City Hospitality Alliance. If the New York City Hospitality Alliance truly does not support wage theft, they'll stand with workers and urge our electeds to vote on SWEAT. Wage theft is a crime that truly ruins the lives of so many New Yorkers, as we heard today, and so many more people who are not here to speak up today, who, unlike business owners, do not have money, properties, or attorneys to fall back on when their boss decides not to pay them. I also call on our politicians, including our governor, a woman, to tell them that they truly need to stop pretending to be fools and acknowledge that SWEAT is how we fight wage theft. Your constituents are being robbed day in and day out, and you have laughed in our faces and set money aside for another task force. It does not matter how many workers the city hires to complete Department of Labor claims. If we do not vote sweat into legislation, $3 billion more in stolen wages will be taken from workers again next year. Workers deserve to be paid for every bit of their labor and shall be able to hold wage stealers accountable when they break the law through the use of the sweat bill.
Thank you. Mr. Herrera?
Okay. Thank you to Jessica, Senator, to listen to us. My name is Carlos Rodriguez Herrera. I'm a restaurant worker. I've been a restaurant worker for 20 years. I have also worked at deli, supermercado, retail stores, and doing delivery. Nearly every boss I have worked for has stolen wages, about 40 different bosses. One boss was Dave Melton, an owner of Domino's Pizza franchise. I worked one of Melton's Domino's Pizza from 2005 to 2007, getting paid $4.40 an hour, 66 hours a week, doing delivery, cleaning, cutting pizza, stacking products, street flyering, giving flyers on the street, and other jobs. I was paid less than the minimum wage. I have my tips stolen, my co-workers, and I organized to file a lawsuit against Melton for wage theft. But Melton was able to hide the access by selling 2 stores of the franchise and declaring bankruptcy. We were able to win some money by proving that Domino's Corporation knew what was going on and was liable. But if we hadn't been able to do that, Melton would have gotten away with stealing our wages. If we had sweat, we would have been able to put a link on the franchise and stop the Melton from fraudulently declaring bankruptcy. Over the years, I have organized with many other workers and hear many stories similar like mine. Bosses are easily able to get away with the robbing workers because they know the law won't do anything to them, and they can hide the access. This is why we need sweat to stop the bosses from stealing from us. Because it's easy for bosses to rob our wages. It spreads racist ideas that immigrant workers of color like me are cheap and disposable. Bosses think they can also get away forcing us working 60 hours, 70 hours, 80 hours plus a week, making our bodies sick and broken. They get away forcing us, discriminating against us, beating us up, even killing us. And I want to repeat this phrase 2 times. Some of my co-workers who also have had their wages stolen, they are mad that sweat hasn't been sweat has been delayed from so long. They didn't want to come today because they think the Senate isn't going to do anything. But we explained to them that is the Hospitality Alliance that is spraying lies about workers and delaying and blocking sweat. Why are they protecting criminal bosses who steal our wages? We are going to protest Hospitality Alliance door step next Friday, June 2nd, because we have enough. They make the labor law a joke. We urge you, elected officials, to pass sweat so workers like me, we can have the same rights to enjoy our lives. We don't want to be like slaves anymore.
Thank you.
Yeah.
Mr. Kolodny, just about how many cases does Catholic Migration Services take on for wage theft?
So So each year we have several hundred people, is this working? Several hundred people coming to our office for assistance with a wide range of employment-related issues. We only have the resources to file court cases for a small percentage of that group. For many more, we assist them in filing claims with the Department of Labor. Of course, if we can work things out directly with employers before legal action is taken, we try to do that. But with larger groups where more money is owed, we essentially can't try to negotiate before a lawsuit is filed because all we're doing is giving the employer time to hide their assets before a court case begins.
As they so often do, as we learn. How many of the cases that you do end up taking to court end up with a decision in favor of the worker?
So I don't have data. What I can tell you is that, excuse me, most wage cases where the employer actually appears to defend the case are resolved through a settlement. Because the litigation process is lengthy, it's expensive for employers, and for employees, they're concerned that they're going to go through that process and end up with nothing.
Dare I ask that you too have collectability issues?
Yes, we have several cases just in the last few years where we have judgments in the range of upper six figures or close to or low seven figures where the defendants just chose to ignore the lawsuit. Some of them are still around, but they have no assets in their name, and so our clients have not collected any money from those cases.
Thank you. Mr. Song, I'm so sorry for your experience at work. You know, you so often hear that women are mistreated as nail salon workers, and I know there is a small number of male workers, and it breaks my heart to know that you've been mistreated too. I'm very thankful for your translator because I didn't understand your words, but I have to say I did feel the indignation in your voice.
Thank you.
Thank you for testifying today. Same with the both of you. I'm wondering, as a restaurant worker, Mr. Herrera, how you feel about doing away with the tipped wage.
The tip credit? In the past we organizing because they want to get rid of a tip credit. You said
I said yes. I said the tipped wage.
The tip wage?
Yes.
Oh, okay.
Like the one fair wage bill. Are you familiar?
Yes, but I'm not agree. I'm not agree with one fair.
You don't?
No, with.
Oh, tell me more.
Yeah, because, look, the problem is the law, right? The minimum wage can be $100, but without enforcement don't mean anything. And we rely from the tips. Because the house don't pay minimum wage, don't pay overtime. They do a lot of tricks of the booths to exploit us. So imagine if they eliminate the tip credit, how we going to survive? A lot of co-workers, other workers say, like, we surviving with the tips. So we need the tips. But also we need enforcement of the labor law.
We definitely need enforcement.
Yeah.
But I do want to say, I mean, the reason why we have a sub-minimum or tipped wage here in New York is because, unfortunately, it's one of the last vestiges of the Jim Crow era here, where a second tier of wages was created for black people. And so I do believe that it is our duty to do away with that. It's not my bill. It's a bill that's carried by Senator Robert Jackson from here from Manhattan. Well, I think he has the Bronx now, too. I mean, in other places where they've done away with the tipped wage and workers are just getting the regular minimum wage or more, depending on the employer, my understanding is that tipping doesn't necessarily end. People still tip for
That's
good
the
service.
trick. That's the trick because if we don't have sweat,
Yes,
Right now
I
it's
understand about,
$15, right?
I understand
Yeah,
the
yeah.
enforcement part.
Yeah. But now it's $15. Not everybody pay $15.
Right.
What means one fair wage? Don't mean anything. And a lot of bunch of celebrities pushing this legislation, and also a lot of maybe for fancy restaurants it's okay, but not for us.
Interesting.
Yeah. So we need enforcement. That's why we asking you. I know, and I want to confirm you are on our side and not now the sweatshop bosses, because Hospitality Alliance, right? The guy, he's not here, but everybody hear him. He's protecting the sweatshop bosses, and I want to say again, we're going
That's
to
his
take
job.
this. It's his job, but there's a lot of money under the table, and there is that's the way. When I say the bosses, they spread, we are cheap, we are disposable, because that's the way they make money on us. They scare us, they exploit us, they beat us, they discriminate against us. That's to weaken us speak. So if we pass sweat, more workers.
When we pass sweat, Mr. Rivera.
When we pass sweat, more workers going to encourage to speak up.
For sure.
I know you feel sorry. Everybody feels sorry. People crying. We are the victims, right? But this is not only for immigrant workers. This is for everybody. Look, she's from here, Puerto Rican, but she's a citizen. So the conditions come down for everybody.
Sure.
Not of course, we are super exploited.
And people of
Yeah.
color overall.
Yeah. So that's what they think they can treat us like, excuse my words, but like shit. Yeah.
I understand.
Yeah.
Also, the tip also like the power of the worker, because we worry about eliminate the tip, they will eliminate the power of the worker. So under current law, the employer and the management cannot touch the tip. You know, often employer boss can using like increase the staff number. For example, 5 people work in the restaurant, they can hire 10 more to keep worker out because you cannot make money. So if we able to control the tip, we can protect our job. So that's also another reason why we want to keep the tip.
Have you guys told the One Fair Wage Coalition how you feel, what your concerns
Yes.
are?
Yeah.
And what has been their feedback?
They don't. They say, oh, that's good for you. Let's do this first and sweat later, but not really. In Hospitality Alliance, they part of. We like Andrew Rigi. He say something. I worked with some of these groups before. We was doing something together before, because also they wasn't agreed to eliminate tip credit, because they say we're going to pay more. If they increase the minimum wage, one fair wage, the bosses are going to pay more.
I see.
They didn't was agree, so we did something, but now they protecting the sweatshop bosses, and they are the main opposition, right? Hospitality Alliance, and look how they look down on immigrant worker color like me, like others.
All right. Thank you, Panel G. We're going to move on to Panel H, which is Sarah Ahn, my neighbor and director of the Flushing Workers Center. May King, she's a massage worker, also with the Flushing Workers Center. Oh, everybody's with the Flushing Workers Center. Sung Chow, who's a restaurant worker. And Sandra Mejia already testified. All right. Let's get settled. Okay, Octaviano? Se fue? Okay, did he leave any written... if he left written testimony, we can accept it into the record. La verdad, en el interés de tiempo... Pero con mucho gusto te lo recibimos. All right. Sarah. Hello. Hit it.
Okay, I'll be very fast. I'm sure. Shout out to everyone who is still here, including you, Senator Ramos. My name is Sarah An with the Flushing Workers Center. I am here to testify today on the dire need of the SWEP bill. I was part of the coalition when we started almost 10 years ago, and it was dire then. I cannot express to everyone how much more dire it is today due to the fact that SWEP was vetoed right before the pandemic. As many have already testified, the game in town is to make sure your workers can never collect a penny, even when they win judgments in court and DOL, or force them to settle for pennies on the dollar. Most workers don't bother to take any action at all, and those who do are told from the very beginning how difficult it will be to recover their wages. As a young organizer, this was very shocking to me. Hearing lawyers, government officials, even judges tell workers who are simply asking for fair payment for their hard work that they should be mentally prepared to accept less, because otherwise they will likely receive nothing at all. I thought, what kind of justice is this? How can even judges cower before an employer? I've learned a lot through the years. I'm no longer as young and naive as I was, and understand that there is no justice in our courts, and in order for working people to win, we have to change all of society. So I think the question for all of us today, and those who will be reading these testimonies, is do we want to live in a society where wage laws are so easily overlooked that workers have no guarantee for payment for the labor that they have done? What does this mean in a country that has outlawed slavery over a century ago? SWET is important for many reasons, but most of all because it puts real tools in the hands of workers, their advocates, and the government to keep a very simple standard. If you do not pay your workers according to law, you will have to pay it back. That if you cheated your workers and you bought your home and built a business enterprise on that money that isn't yours, and now you have to pay it back. That we will treat bosses who follow the law and those who break the law differently. We have been stuck here for many years. Workers share story after story about how the system is so broken and how employers are more and more emboldened and pressured to cheat their workers. Hospitality Alliance says they care about wage theft but offer no solutions to address the very specific problem of transfer of assets and hiding money and assets. We are tired of this merry-go-round, and we need our elected officials to stand up for the many, not the few, and make the brave choice to try something to address a problem instead of letting us be held hostage by those who wish to protect law-breaking criminals.
Thank you. Ms. King? Hi. Welcome.
我叫 May， 我是一名按摩师，我在曼哈顿中城的，就是一家名为良子的按摩店上班。在那段时间里，我们就是没有支付任何工资。如果说没有客人的话，就是因为我们做按摩的，如果说一个客人都没有，我在这里上一天班，1分钱都没有。好，就是老板呢，就是经理就用这种制度，他就把他喜欢的工人，他就给他们多派工。如果说他不喜欢你，他就给你派1个或者2个，或者1个都不派。在工人之间，工资就悬殊很大，这样就形成工人之间拉帮结派，就不停的讨好老板，不停的讨好经理，工人就没有一点真脸，我感觉这样。但是我们呢，跟不讨好不讨好经理的工人就没办法谋生，收入都很低。但是我又不敢用劳工法来说这个事儿，因为一说这个事儿，老板他根本就不怕，因为很少，因为我来美国几年了，我新移民，我来了4年，我做过不同的工作，但是很少有老板遵从劳工法，遵守这个法律，因为他违法的成本很低，他根本就不会真正的保护我们工人，就是你赢了官司，你输了钱。比如说我们工人去告老板，你要花时间精力去告，但是到头来还是一场空，1分钱都拿不到。因为工人根本就没办法和老板对抗，工人毕竟属于弱势群体，就是在这种情况下，我和我的同事长期遭受这种不公平的待遇， 就跟老板提出这个不公平的待遇，跟他提出这个事，他马上就把我们解雇了，帮我和我同事几个解雇了，并且解雇的时候呢，老板还公开说，你告嘛，随便你告，你告不赢的，你到时候告了过后，受侮辱的是我们，不是他，因为工人就是在这些华人圈里面，在中国人当中，比如说我这次我没获得赔偿，到时候这华人圈全部都宣传开了，你看他告老板，告了什么都得不到，我们没办法抬头，这样老板就更加猖狂，他更会欺负工人。所以我现在这样，我要争取要回去上班，还有我希望老板欠我们的工资应该拿给我们，应该得到我们应有的赔偿。所以说我希望这个都是这个工资盗窃法案一定要通过，不通过的话就形成了恶性循环，在那个社区里面很糟糕的这样。这时候那个老板之间互相宣传，到时候压榨工人、欺负工人的现象就越来越严重，越来越严重。工人呢，他就不敢告了，老板说什么就是什么了。并且我们那个老板更可恶的是什么呀？他在明明工人已经很多了，他就不停的招工人，不停的招工人，哪个不听话马上就淘汰，哪个不听话就马上淘汰。这样看见年轻的来了，马上就把你年龄大的淘汰掉。所以说我们每个人都有那种心理压力、危机感。比如说现在非法移民来的多了，非法移民比我们这种合法移民更便宜，他看哪个工人呢更便宜，他就马上就用哪一个，不停的跟你工资不停的变换，不停的变换。我在那里都已经换了几次，都是工资调整了几次了，不停的把你的工资给你压低。所以说我感觉，既然我们为什么来美国了，对吧？我从中国跑到美国来，我来几年，我就冲着美国是自由、民主、平等，我们和老板应该享受平等的待遇，你说对吧？既然你们官员是民选官员，就应该听一下我们老百姓的心声。我连工作都没有，哪里来人权呢？我要吃饭，我要工作。比如说他给你10块钱，你要干，我找不到工作，我5块钱我也要干，因为我要吃饭呢，对吧？所以说法律更应该保护我们工人，保护底层劳动人民。我就是美国最底层的劳动人民，我希望通过这个法案来保护我们。谢谢。
You got all that?
Yeah. She write down.
Tell me
her
everything.
testimony. Yeah. My name is Mei Ching, and I am the massage worker. I work in the Leonte Spa in Manhattan for a couple years. During the time we were first not pay any wages for time we are not doing massage, even though it is against the law. The manager used the system to give us a lot of customer to the worker he liked, and make it very hard for me and some of my coworkers to make a living. I have had many jobs since coming to this country, and I see many bosses taking advantage of the worker and not follow the law. In the past, I did not dare to speak out about the law because I knew it will not protect me. My coworker and I were fired for speaking out about the unfair treatment at the work, and we are fighting to go back. We also want to recover our stolen wages, but worry that we will never get back a penny because many of my friends in my community experienced this. Many people say not to bother because the law is so bad and weak, and the only people who would benefit from the sweat not passing things. So he mainly say we really need the law to protect the worker. They even using the boss even using the new immigrant and to against the old worker against each other in order to control the worker. So I want to fight this time And we want to let people know, and we need you to support the worker, to help the worker, to pass this bill in order to help the worker. Thank you.
I'm doing everything I can, Ms. Ching, I promise. I also have here Mr. Chow.
Xu Zhuo.
He was replaced by Dave Pinson, who testified earlier.
Okay. Well, I mean, at this point, I don't really have many questions. I mean, I'm also happen to be the sponsor of the bill, so it is very clear to me. But if you feel that there are any points that have not been made on the record thus far in terms of how necessary, how urgent it is to pass the sweat bill, or anything else that we should know?
Can I take that spot? I can.
Yes, you can.
Testify now.
Please.
A lot of workers also.
Yeah. Hi, my name is Jin Ming Chao. I have been working in the restaurant industry in the U.S. since 2001, over a decade. Starting from 2006, I worked as a waiter in Wuliangye restaurant, earning a monthly base wages of $300, while the delivery worker only received a monthly wage of $600. We work 6 days a week, about 66 to 70 hours per week. So our hourly wage less $1 per hour. My colleague and I took the legal action against the Wuliangye restaurant and its employer. We got a court judgment ordering Wuliangye and employer to compensate 26 workers, including myself, with approximately $1.5 million. However, the owner had already transferred the property under different name, and closing down the restaurant reopened after a few weeks with the new name called Mapo Tofu. Although everything inside the restaurant remained the same, but our lawyer told us it's not possible you can prove there's the same owner. Therefore, we had a court judgment stating the owner owe us a $1.5 million. We might share already like $140,000. Over a decade past, we haven't received even a penny. In 2016, I started working a waiter in Joy Luck Palace, a unionized restaurant in Chinatown. Despite having a union, it was still unable to prevent the owner from stealing wages. Once again, we took the heartless owner to court. Unfortunately, the owner and their wealthy family claim they have no money. Despite expanding their business and opening more stores, we obtained another court judgment. But once again, we cannot collect even a penny. Later, I assist a delivery worker named Mr. Chen file a lawsuit against the Canton Kitchen for unpaid minimum wage overtime. So Mr. Chen also got the court judgment, but the owner simply, sell the restaurant to the other, maybe he's a friend. Until today, he cannot collect a penny. During the pandemic, wage debt getting worse and worse. The owner of the Yao Yao Sushi also failed to pay minimum wage overtime. I also assist the worker to file the lawsuit, find the lawyer, file the lawsuit. We got a judgment. And also, they just changing name, continue operate the worker until today. We cannot collect even a penny. There's so many judgments in my hand. But we need sweat. If we have a sweat, we can froze their account, right? We can link to the property. We can even link the restaurant and not worry about they can get away.
Okay.
And also, we want to tell the Hospitality Alliance, they are opposing the sweat. They are helping the sweatshop boss continue steal our wages. They need to take the responsibility for the wage owed to us, including my own wages. This is a full judgment. It's been like so many years, but it's just like a piece of paper. We cannot collect even a penny. So we need the sweat. We need sweat to pass now.
Absolutely. Thank you. All right, we have like 2-ish panels still left, and we're gonna bang these out. Up next, we have some members from the Chinese Staff and Workers Association. Apologies again if I mispronounce your name. Please teach me so that I can do better. Neng Wu Chen, Tai Wu Yang, Yingguang Sheng, Jinming Cao. And I'm wondering if I can throw in there Shuming Sheng and Jingguo Ke if they're still here. Let's just do the whole organization, and then that'll leave us with just one more panel from what I can see. Like trying to figure out who's still here. Hi, gentlemen. All right, whoever's already sitting down, please feel free to start. Good afternoon. You want to start? Go ahead.
OK， 你先讲。大家好，我是名字叫郑银光，我来美国30年了，在餐馆做工，2013年在曼哈顿华厨餐馆打工，做炒锅，做1个礼拜做了6天，一天做12个小时到13个小时，做到2000年3月27号。老板关门来欠我8天的工钱，我想那个他8天工钱没给我，我想去告劳工局，结果劳工局说他不许欠你8天的工钱，还有欠你很多的工钱，现在快3年了，他1分钱都没有还给我，那个他结果呢就是劳保的财产呐，对呀，我们就想这个法案怎么我们血汗钱1分钱拿不到。
Hi, my name is Ying Guan Zhen. I have been in the United States for 30 years. I have been work in the restaurant all this time. In 2013, I started work as a cook in the restaurant called the China Gourmet. I was 6 days away, 12 to 13 hours per day. I continued work there until March 17, 2020. I filed the Labor Department complaint for non-payment. And the Labor Department told me they not just owe me 8 days unpaid wages, also owe me a lot of money. But 3 years passed. I haven't even received a penny. So we need the law. We need a SWAT to protect the worker, to help us get our wages back. Okay, 建國。
大家好，我是郭金国，我来美国快30年了，都在餐馆做工。2016年开始，我进入兰州拉面做外贸工人，送外贸。每周工作7天，每天12小时，根本没有最低工资和我超时工资可以拿。老板向我做很多挺外贸工作，如何还买菜、搬送孙子，我们被他欺骗得好惨。2020年7月，餐馆在疫情大爆发时间新开门，老板还是叫我长时间工作，没有增加工资，一直到12月份，老板不管我的意外，继续2天叫我送菜，一户已经 新冠病毒病死的人家，家里人打电话给老板说，你这样照个送外贸工人送，他如果传病了，就全家都会死。会好麻烦。因为第三天老板就把我炒鱿了，我就去找朋友帮忙。朋友说，你这么少的钱做这样长时间是不对的，所以我就去找律师。律师说，一共被欠你19万，但他说我这种情况很难追回款钱，因为当律师写信去要求这个老板立即赔钱，立即赔款，欠款的时候，老板说，你没去告我，我也不怕你告我了。律师说，立即告了也没有用，因为老板名下没有钱了。但是我也一直看着他生意越做越好，开了一共3家店。为什么这个无良老板可以不但这个赔钱，还开这么多新店？我只好去投诉老公司，已经3年了，一点收拾都没有。如果这个还工资盗窃还案，我就可以冻结他的财产，就他立即赔偿，所以就反对这个停还案，就是全心全意帮老板偷工资。我要对我的血汗钱负责，立即赔款。
Hi, my name is Ke Jingguo. I have been in the United States for nearly 30 years, and I have been working in the restaurant all this time. In 2016, I started work as the delivery worker at Tasty Handful Noodle. I work 7 days a week, 12 hours a day, without receiving minimum wage and overtime. The boss even made me to do many additional tasks, such as the grocery shopping, picking up their grandchildren. I was treated very poorly. When the restaurant reopened in the July 2020 from the pandemic shutdown, they still made me work long hours without increasing my pay. In December 2020, for 2 days in a row, the boss forced me to deliver food to the COVID-affected household that already have someone die from the COVID-19. And boss got a phone call, that they say that was a very dangerous if the worker do that. So they worry about get affected. So using that excuse, fire me. And I talked to my friend. My friend told me, this is very long, we were so long, your wages so little. I decided to consult a lawyer. However, lawyer told me that it was very difficult to recover my unpaid wages because when the lawyer reaching out to my boss, demand immediate compensation. My boss say, go ahead and sue me, I am the judgment proof. The lawyer say that means even we won the case, it will be useless because the boss had no money under his name. And yet the boss business rife, and he opened more shop, three shop. How can this special boss not only avoid paying my wages and can be able to open more business? I have no choice but file the Labor Department complaint. But 3 years have passed, I haven't received any update. If we have a sweat, I could place a lien on their boss assets, force him to compensate me immediately. Whoever opposing this bill, who is helping the boss to steal wages, and they need to held accountable for my hard-earned money and compensate me immediately. Thank you.
Thank you. Gentlemen?
大家好，
你好。
郑寿明，我来美国20年了，几乎都在餐馆送外卖，多年来都是每周6天工作，每天12小时。这么多年来，餐馆老板都不付超时工资和最低工资，也有许多餐馆工人将老板告上法庭，但是几乎都是拿一点点赔偿就继续长工时、低工资的工作，有些甚至连1分钱也赔不到。令到工作环境一直没有改善。我从2016年开始在金满庭送外卖，也是每周工作6天12个小时。几个月前，我们5位外卖工人将金满庭告上法庭，但是老板只愿意出低于赔偿金的10%，要不就会一直拖下去。如果有缓工资盗窃法案，我们就能够按住老板的财产，包括他的5家餐馆，我们就不怕他将餐馆改名或将财产转移，这样才能真正令老板不敢违反劳工法。我今天也要对反对这个法案的餐馆会说，反对这个法案就是在帮无良老板继续偷工人的血汗钱，那么你们就要对我们的欠薪负责。谢谢。
谢谢。
Yeah, 3 of them work at the same restaurant, so So Min Jung will represent them to speak. Hi everyone, my name is So Min Jung. I have been in the United States for 20 years. I have been worked in mostly as a delivery worker for the restaurant. For many years, I worked like 6 days per week, 12 hours a day. Due these years, restaurant owner had never paid me overtime minimum wage. Many restaurant workers have sued their employer, but they usually receive very minimal compensation and are forced to continue work long hours and under minimum wage. Some don't even receive a single penny in compensation. As a result, our working condition had never improved. I started delivery for Dim Sum Palace restaurant in 2016. Worked 6 days per week, 12 hours a day. A few months ago, 5 of us delivery workers sued the boss, but the boss was only willing to offer compensation less than 10%. Or they will continue drag it out. And if we had the SWAT bill in place, we could hold on to the owner assets, including his 5 restaurants. And we couldn't have to worry about him to rename the restaurant or transferring his assets. Then we can truly prevent the owner from violating the labor law. Those who are against the SWAT bill, like the Hospitality Alliance, are really helping the law-breaking boss continue to steal workers' hard-earned money. The Hospitality Alliance should be held responsible for our unpaid wages if SWAT doesn't pass. Thank you.
Thank you. Well, I'm very happy to know that you're being well represented by David Kolodny at Catholic Migration Services. And actually, this ends up being the perfect panel to end our hearing on. I think one of the biggest takeaways from today's hearing is that clearly workers depend on each other. I've heard from your stories and from seeing you here together today that clearly a worker depends on another worker, and that together you find your strength to face your boss. And ultimately, that is the truth. Only workers will save workers.
他说，今天很高兴也看到你们站出来发言，因为早些时候你们的律师就在这里讲，他也讲到你们这个案子，他也很高兴你们能够找到这个律师可以帮你们争取这个权益。今天呢，能够听到你们出来去讲，也用你们这个故事来结束今天的听证会，就非常有意义。所以呢，他会继续。
I want to thank each and every one of you and everyone who testified today. Today was actually the first time that New York State ever held a hearing on wage theft. So we've made history, and your stories will now be in the record.
所以呢，今天非常感谢你们每一位出来作证，去讲这个事情，而且这个是在纽约州第一次在纽约市召开这个听证会。所以你们这个故事就非常的重要，它会让大家都听到。好，谢谢你们。
We have 8 more legislative session days to get this done. And so I hope that we will work with each other very closely in the days that remain so that we can finally put this behind us.
他还有8个工作日啊，就是议会的工作日，去争取去在这个8个工作日里面呢通过这个法案，所以他要跟大家密切的这几天做好这个事情。
谢谢。
好，谢谢啊 ，Thank you。
Thank you.